I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. Today is Wednesday, September 25th, 2024. The time is 2:54 in the afternoon, and this hearing is being held in room 500, the council chambers of the Johnny Wilson Building. The subject of this hearing is Bill 25-826, which is entitled Recidivism Reduction, Oversight and Accountability for DYRS Act of 2024. This legislation was introduced at the request of the Attorney General on May 21st, 2024. The stated purpose of this bill is to amend Title 16 of the District of Columbia Code to reform the Department of Youth Rehabilitation Services Supervision and Intervention Practices, including by requiring the department to develop and complete an individualized rehabilitation plan for each youth in custody prior to a dispositional hearing. Also requiring the department to provide services to those in secure placement within 30 days of entry, and requiring the department to develop a discharge and reentry plan upon a youth's admittance into placement outside the youth's home. The bill, Bill 25-826, also amends the District of Columbia Auditor Subpoena and Oath Authority Act of 2004 to establish a permanent and independent deputy auditor for independent juvenile justice facilities oversight in the Office of the Auditor. I usually do not expand much beyond that when I give an opening statement at the beginning of hearings. I will say that juvenile justice and juvenile crime has always been of a heightened concern to residents. I think because it's just frightening, this notion that a teenager may be committing a violent crime. There's often a lot of misunderstanding about what the reality is in terms of the data around juvenile crime, how much of our crime is juveniles and how much of it is juveniles who are repeat offenders whom the system has let slip through the cracks. And I'm hopeful we'll get into some of that here today. I am assuming that this bill was introduced at the request of the Attorney General, the point being the Attorney General, my assumption about the Attorney General, because their work in prosecuting juveniles, they've seen where there could be some improvements in how the system, meaning the government, is handling juveniles who've been accused of crimes or have been adjudicated as guilty of crimes. So we'll be getting into all this at this hearing. We have 12 non-government witnesses, and the hearing notice said testimony will be limited to 4 minutes each. I will be calling 4 witnesses at a time if they're in person, maybe 6 witnesses if any of them are virtual. The record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on October 9th of this year. This is because we have to proceed with filing a record, and we need a deadline for closing the record, and that will be 2 weeks after today. With that, I think I will leave it to the witnesses, but turn to colleagues first. I'm going to turn to Councilmember Parker because he is chairing the council's brand new subcommittee on libraries and youth affairs. This bill is not referred to the subcommittee. It's in the full committee of the whole, but I will recognize him first. And then in order of arrival, Councilmember Pinto, Allen, and Louis George. Councilmember Parker.
Thank you, Mr. Chairman. As the chairman mentioned, will be leading the council's new subcommittee on libraries and youth affairs, which will have jurisdiction over DYRS. While today's hearing was scheduled prior to the creation of that subcommittee, I look forward to engaging in today's conversation and following up with further roundtables, visits, and discussions. The focus of today's hearing is on the Recidivism Reduction, Oversight, and Accountability for DYRS Act, or the ROAD Act, as introduced by Attorney General Brian Schwab. But I want to zoom out and align on what we're seeing happening at our DRS facilities. Overall, we are seeing a staggering 92% recidivism rate, which I think we can all agree is unacceptable. Most of the young people that are served by the agency are in fact returning in one way or another. And it's important to note that that 92% rate incorporates arrests for violations of current or existing court orders, whereas roughly 70% are for arrest on new charges. Even still, I think we can all agree that a 92% recidivism rate is unacceptable for the direction we want to take the district. Prior to the pandemic, there was roughly a 30-day period between referral and first service at agencies like the Department of Behavioral Health, whereas the reported length of time now is more than doubled. There are delinquencies in terms of placements, as well as young people receiving needed services. And so the ROAD Act, I won't go through everything that the chairman highlighted, seeks to do several things. It ensures, as I read it, a level of accountability on the agency to ensure that there is an individualized rehabilitation plan for young people among being committed, as well as detailed lengths of time that they are expected to receive services. There is also an expectation to have an individualized reentry plan amongst when released from DRS, as well as an expectation for the courts to intervene at 4 months or so. I will stop there, but I would just say the devil is in the details, and we will hear from the auditor. And one of the things I anticipate her highlighting is in how and the details of the legislation versus the what. What I would end by saying is I will be looking to how do we ensure that we can provide young people within DRS's care the services that they desperately need, both mental health as well as education, while ensuring that we can drive down rates of juvenile crime and those young people in the care of DRS to begin with. So thank you, Mr. Chairman. I'm looking forward to today's hearing.
Thank you, Councilmember. Councilmember Pinto, who's participating virtually.
Thank you very much, Mr. Chairman, for holding this important hearing today. We have been through a lot as a city over the last several years when it comes to public safety and crime and support for our young people. We have a lot of major improvements that have happened. Violent crime is down 35% since this time last year. And now we must refocus our efforts on ensuring that young people are not set up for failure when they are in custody, and that we are truly giving meaning to the R in rehabilitative in DYRS. That's what this agency was established for and needs to be really focused on so that we can ensure that young people don't reoffend, that DYRS is a place where they can cool off, but are also guided by caring adults to become rehabilitated members of our community and not a revolving door for further offenses, of which we've seen far too many. We have to ensure that the proper interventions are put in place to reduce recidivism and help our young people return to their communities with tools that they need to be successful, productive, and thriving members of our society. The ROAD Act attempts to address some of this by requiring more individualized rehabilitation plans for every youth in DYRS custody that will be tailored to their unique needs. I'm pleased that the bill requires these plans be implemented quickly within 3 days of a youth's court order and updated regularly to ensure they are effective. Young people, like adults, are individuals and have different needs and different follow-up responses to yield the best outcome. I think this is a really important step towards addressing some of the challenges that we're experiencing in the district regarding juvenile justice and more healthy development of our youth. We can enhance public safety by addressing the root causes of youth delinquency. And I think this bill envisions a system that rehabilitates our young offenders and prevents them from reoffending, which is how we can better protect our communities and support our youth longer term. I am looking forward to hearing today from our public witnesses and members of the community on this topic. I look forward to asking our government witnesses, Director Abed and Attorney General Schwab and others about how they plan to implement the provisions of this bill, if passed, in a seamless manner, as well as potential obstacles and challenges they envision arising in this process. I have also a number of questions about the current status of law and policy when it comes to these types of plans, and what some of the hurdles have been to meeting that goal, and seeing if perhaps we can be supportive there, as well as the oversight component and how that would work in practice. I think it is clear that additional focus and support is needed when it comes to DYRS. I also am usually a person who believes that the legislative body is best suited to provide oversight, and want to be mindful of additional layers of oversight as we consider the best path forward. So thank you again, Mr. Chairman. Thank you, Attorney General Schwab, for introducing this legislation, so we can continue having this important discussion today.
Thank you, Councilmember. Councilmember Allen?
Thank you, Mr. Chairman. Big picture, the district's made some remarkable progress this year in strengthening public safety. By today's count, homicides are down 30%, assaults with a deadly weapon are down 27%, carjackings are down almost 50%, and robberies overall are down 39%. I think everyone will agree that the decrease in violent crimes is a welcome sign. But I think we would also all agree public safety continues to be our top priority, and we've got to continue to exercise oversight and explore our legislative options to ensure that our criminal justice system overall and our juvenile justice system in particular keeps residents safe and that it's transparent, fair, and accountable. In the case of the Department of Youth and Rehabilitative Services, or DYRS, it has taken a long time, mostly forced through the consent decree in the JRM case, for the district to have a safe, transparent, and accountable agency. When the consent decree was lifted a couple of years ago, I supported the mayor's decision to establish the Office of Independent Juvenile Justice and Facilities Oversight, which ensures the progress that DYRS made during that period of court oversight would not be reversed. But earlier this year, when the mayor proposed to then eliminate that same Office of Independent Juvenile Justice and Facilities Oversight, I was deeply concerned about what that loss of the office would mean for transparency and for accountability. And I worked with my colleagues so that we stepped in to continue its charge. We've seen troubling trends at YSC and youth under supervision. I think oversight and transparency is crucial to ensuring an agency that works well, and I want to explore how this proposed legislation intends to build on that. Oversight and transparency are key to ensuring that DYRS and our juvenile justice system as a whole does not backslide to the days of JRM. The last thing any of us should want to see is for this agency to go back under court action and a consent decree. I'm also encouraged with the actions that the council has taken and the chairman recently has taken with the committees, that my colleague, Councilor Zachary Parker, is in his willingness to conduct the necessary oversight over the next several months going forward. However, I want to ensure that the checks and balances on a more granular agency level are there to ensure the agency remains transparent and accountable. With that theme in mind, I'm looking forward to exploring it further with the public and our government witnesses today, and appreciate everybody for taking time out to come testify today. Thank you, Mr. Chairman.
Thank you, Councilmember Allen. Councilmember Lewis George.
Thank you. Good afternoon, Chairman Mendelson and Subcommittee Chairman Parker. And thank you for convening this hearing today. I'm eager to learn more about the intended impacts of the ROAD Act and other ideas for improving outcomes for DC's youth. I'm coming from the perspective today, as many may know or not know, I served as a prosecutor at the Attorney General's office, in the juvenile section. I spent days and nights in JM 5, JM 7, Saturday mornings in JM 15. And so I'm coming from a perspective of having been on the ground and worked closely with DYRS as a result of that, and worked closely with many people who are in the room today as we talk about what we can do to improve outcomes for youth, which I think is where we all are. We want to make sure that we are reducing recidivism rates by providing the services necessary for young people and their families to succeed. We must take a whole child, whole family approach if we are going to actually deal with recidivism. And I hope that that is where we are headed. And I am eager to talk about some of the ways I think this legislation actually goes to do that. One part of this legislation that is important is developing the individualized treatment plans within 90 days of a commitment for our youth. This is important. If you don't have a plan, you don't know where you're going. And if you don't know where you're going, you're not going to get to the intended result. And we have to have plans for young people as it relates to when they're going into commitment. How do we ensure we have a plan that meets the needs of that young person and that family? Another portion of this that is important is reentry planning. That's just as important as the planning of when a child goes into commitment. When we talk about when they re-enter into the community, what supports are going to be in place to ensure that when they re-enter into the community, everything that they have learned, everything that they have gained is not lost in a day. And that their families have the support to ensure that everything they have learned, everything they have gained are not lost in a day. And so I think the reentry planning portion of this is also critical. I do think the Road Act allows for the court to hear allegations of DRS failures to rehabilitate services. Rehabilitation every 4 months as opposed to 6 months will go a long way to making sure we're taking the necessary steps we need to take to make sure our youth are getting the appropriate services and have the appropriate level of placement that is necessary based on a young person's individualized rehabilitation plan. And I think the oversight piece of this, which is making really reimagining what oversight looks like in regards to and the independence would make a huge difference in decisions and how they are made and also how data is reported. That independent is necessary if we're going to get real true data. So I'm looking forward to hearing from witnesses today and working with this committee for us to have a better outcome for our young people, which I believe is the effort of all of us here at the council, but those people who are in the community every single day, working with our youth, working with their families. And I hope that that is where we will end up at the end of the passage of a legislation is a space in place where we look at rehabilitation and a whole family approach to our young people. Thank you.
Thank you, Councilmember. Councilmember Schuman?
Thank you, Chairman Mendelson, and thank you to the Attorney General for coming forward with this legislation and to the witnesses that we'll hear from today. And we're all heartened that we've made some progress in bringing down violent crime in the last year, but we all also know that we have an enormously long way to go in order to really address this. And part of that is getting at the root causes of crime. I visited the DYRS facilities and in talking with some of the kids there and asking them about what was their path to get there, and 14, 15 years old and there for armed robbery, armed carjacking, which school do you go to, one name of a school, another name of a school, I don't go to school. And we really have to get at all of that. And where we get to is a spiral downwards, and it can be a death spiral for our kids. So we really need to figure out a way to reverse that and to really get at rehabilitation. And we've seen, there's a recent study in 2022 that 92.7% of the kids who go into a facility like that are rearrested. And we have to change that. And we also see anecdotally reports of problems inside of the facility, a brawl that happened recently between two housing units. So there are real issues here that we need to address. I'm going to be very curious to hear the testimony from the various witnesses about how the proposals in this bill can help to improve matters, because I do think everyone shares the goal of getting to a place where kids are rehabilitated and are not reoffending. There are challenges of multiple kinds of steps in the process. Some of the government witness testimony goes to that, and we'll want to hear, how do we make this work in a way that is efficient and that benefits everyone? What are the things that are being done in other jurisdictions where it's working? to what extent is there an overlap between those things and what's proposed in this legislation? I'll also be very curious to hear the testimony on the role of the auditor going forward. I do think we are about to lose some oversight, a form of oversight over DYRS as that the oversight body expires. And the auditor could play an important role here, but I will be curious to hear how that fits into the whole landscape, because we need a landscape that's efficient and that works for our kids and families and that helps keep our public safe. So thank you for coming forward with the legislation and for the testimony that will come today.
Thank you, Councilmember Fruman. Councilmember Trahan White.
Thank you, Chairman, and good afternoon, everyone. Public safety is and has been a priority for the district. This administration, the council, and more importantly, the community of District of Columbia has raised its hand waving to say we need help to address these issues. While I hear the statistics of some of those key areas going down, we must never miss the fact that one incident or a homicide or robbery or carjacking is one too many. And I've been in the city long enough doing this work to know that we have to be careful. Also say that we're getting better, because as we get better, we loosen up a little bit and not put the necessary time, resources, energy, policy, and practice to ensure that everyday residents of District of Columbia are safe. DYRS has come out of the jury in consent decree, and I'm happy with that. But I want to ensure that we are continuing down this path, to stay on this path so we don't go back. The amount of assaults inside the facilities, drug use, and staff turnovers is still alarming. I believe that Director Abed has done a number of things to go in the right direction, but we have to push a little harder. I think the Road Act is one of many steps in helping to get us in the right direction. I want to thank Attorney General Brian Schwab for his leadership in that. But we have to ensure that there's a real plan that's implemented in this particular legislation that calls for accountability and to get real data, information in a timely manner where we can monitor and make adjustments to ensure that we are making this facility a real rehab place for our young people. I think that DYRS faces a number of challenges even still with the staffing issues there, only to learn that there has been staff hired, but at the same time, we're still losing staff. Man, I don't know, are we quite there yet? But I do know that with the right focus, we can get there. I think the Road Act is a great piece of legislation that focus on also accurate data and have real measurements. But I want to ensure that we don't let up, because sometimes, you know, as leaders in our city, we say that things are getting better when everyday citizens and residents don't feel it. Just the continuing assaults are still happening at the facilities. The drug overdoses, as mentioned, are still happening at the facilities. And two, there's zero. Then we should continue to stay focused and stay vigilant to ensure that our kids and our young people are able to come home. And there's a quote that re-entry starts at the point of entry. And so as they come home, to ensure, like you said, Councilmember Fruman, that we don't, that we decrease this recidivism rate for those who come home and go back in because they don't have the proper supports. And we have to stop as a city walking right past the issues that's affecting the culture and our oversight that's directly having an impact on the fights, the beefs, the drama that goes on in the facilities. There's a lot of stuff happening in the community that, as you know, spill right over into the facility. And so I want to thank you, Chairman, for co-hosting this hearing. I look forward to hearing from the community, the activists that I hear from daily. I've heard from staff as well. To make sure, and the government witnesses, to ensure that we are moving in the right direction, to ensure that every youth that's in our care get the proper treatment and care and love they need to be successful adults. Thank you.
Thank you, Councilmember White. Councilmember Bonds.
Thank you, Chairman Mendelson, and to my colleague who heads the subcommittee, the new subcommittee. Zachary Parker, and to the public, and particularly to our battery of witnesses that are here today. I want to identify with much of what my colleagues have already shared, so no need to go through all of that. We know why we're all here, and that is to put as much as possible together a process where our young people who find themselves caught up in the justice system can really have an opportunity to redirect what has been bad energy into what can be positive. And how do we treat this process when they are in the incarcerated environment? And what do we expect to happen when they re-enter the community? I think this is a very important subject matter that we're looking at today. I am very hopeful that there will be parts of the bill that can be implemented. I am not sold on all of it because I think we need more intervention. But I want to hear from the witnesses today to learn what you, the experts, in many instances, have to say and how we're going to move the agenda. For me, the bottom line is, how do we save our young people who get involved in the justice system? And how do they influence the other young people in their neighborhoods? And what can we expect to be the outcome? So I treat them as young people. I'm not wedded to the idea that the brain doesn't develop until you're 26. But I will say that it is very, very important that we look at this holistically. I see this bill as an opportunity for us to have that second, third, fourth look at how we do business in the District of Columbia and how we treat our young people. So I thank you for the opportunity to be here. I am really here, all ears. I want to hear what the experts have to say. And if there are some parents, like I see Parent Watch here, I am all ears as to what she has to say. So thank you very much, Mr. Chairman, and I won't hold you up any longer.
Thank you, Councilmember Bonds. So we're going to proceed to the witnesses. Whitney Lachheim, who's Chief Operating Officer at Open City Advocates. Raymond Nagu, who's Legal Director at Open City Advocates. Robert Vincent Branham, who's Chair of the Ward 5 Leadership Council and the Public Safety Committee, or the Public Safety Committee of the Ward 5 Leadership Council. Eduardo Ferrer. And I will stop there since we have the table full. And I appreciate folks who come in person. Ms. Lachheim, you're up first, and good afternoon.
Good afternoon, Chairman Mendelson and members of the Committee of the Whole. My name is Whitney Lachheim. I'm a resident of Ward 6, a mother of 2 teenagers, and for the past 19 years have served as the co-founder and chief operating officer of Open City Advocates, which provides legal representation and holistic advocacy to youth who have been committed to the DC Department of Youth Rehabilitation Services, or DYRS. I strongly support the ROAD Act. I have been working with children committed to DYRS for more than 20 years. The incarceration of youth is a grave matter. Despite the flowers out front, the inside of the Youth Services Center is comprised of cinder block walls, cold cells, and plastic mattresses. YSC is the sound of Sally Port doors slamming and children banging their fists on their small, scratched windows asking to be seen. We have clients who have spent months at YSC, receiving few services and decompensating while they languished. We're disappointed that we've sometimes had to bring DYRS to court to challenge this kind of warehousing of our clients. Incarceration stunts the development of our young people at a crucial moment in their growth, one that can't be fully recaptured later. A teenager who's being told what to do at all times has no opportunity to be a normal adolescent, to practice independence, develop autonomy and mastery, or choose their peers. DYRS and all of our district government needs to recommit itself to treating kids as kids and using the least restrictive environment consistent with public safety. That's not happening right now. On my reading, the Road Act is a minor change to the law that would clarify DYRS's obligations to the children under their care for all involved. It provides mechanisms for accountability with an emphasis on DYRS doing what its own policies say should be happening, but has not been occurring, especially when it comes to individual development planning, reentry planning, and kids awaiting placement. This legislation is necessary because we as a city are failing to uphold our own values when it comes to the confinement of our city's children. DYRS has always been required to complete an individualized treatment plan, but in all the time we've been practicing, we've never seen one. An individualized treatment plan should outline a child's educational, psychological, social, and economic needs and background, along with a specific plan for DYRS to tailor its services and placements to the child's individual needs. While we sometimes receive a completed needs assessment through our routine records requests, I can't remember a single instance in which we have received an individualized treatment plan. The Road Act addresses this individualized rehabilitation plan and requires it to be completed, reviewed, and amended regularly with an eye to satisfying the child's needs and goals in a holistic way. Given the traumatic nature of detention itself, I hope this will enhance DYRS's commitment to less restrictive settings. Since our youth are drawn into delinquency through the same systematic deprivations that make all human beings act inappropriately, a validated individualized rehabilitation plan should seek to address those root causes and remove the barriers to youth success. The Road Act would not make it harder for DYRS to do its job. To the contrary, when DYRS employs a team approach and is transparent and collaborative to meet the needs of a child, it makes DYRS's job easier. In my experience, DYRS hews more closely to its own rehabilitative policies when it collaborates with family, service providers, attorneys, and the youth themselves. DYRS has not been clearing the bar it has set for itself. The Road Act gives clarity to DYRS's standards, helps DYRS to be more transparent, and gives more opportunities for other team members, such as parents, attorneys, the court, and DC Council, to collaborate and provide oversight. This will only result in better outcomes for our youth. Thank you for the opportunity to testify today. I am available for questions.
Thank you, Ms. Lackheim. Mr. Nagu?
Yep. Good afternoon, Chairman Mendelson, members of the committee. My name is Raymond New. I'm a resident of Ward 2 and the legal director of Open City Advocates. In my role, I routinely work with clients at the two DYRS operated facilities, the Youth Services Center and New Beginnings, as well as DYRS youth who are placed in local committed group homes and out-of-state facilities, including in Maryland, Pennsylvania, and Florida. We applaud AG Schwab and his office for introducing the Road Act as a way for the district to better meet the needs of youth committed to DYRS. On the whole, the Road Act provides a framework that is targeted to efficiently and effectively ensure that young people committed to DYRS are placed in the appropriate placements and receive the appropriate services. In recent months, the awaiting placement process has been plagued with issues, which has resulted in committed youth waiting egregious amounts of time, sometimes up to 8 months, for an appropriate placement. To put that in perspective, the average length of stay at New Beginnings is approximately 9 to 12 months, although for some youth, it's much longer. But what this means is that there are some youth who are simply awaiting placement for nearly the entire length of the treatment program at New Beginnings. The Road Act would ensure that upon commitment, young people are not confined to an inappropriate secure placement such as YSC for longer than 30 days while awaiting placement. We know that YSC, which is where most committed youth await placement, was designed to be a short-term detention facility and is not equipped to provide meaningful services to youth, which DYRS itself has acknowledged. While the agency has said that they are making efforts to reduce the length of time that young people are awaiting placement, the Road Act would codify that awaiting placement at YSC for longer than 30 days is presumptively inappropriate unless there is good cause shown. This would go a long way to ensuring that committed youth are transferred to appropriate placements quickly. And in implementing this provision, we'd encourage DYRS to consider its several community placements as options for committed youth to await placement. The Road Act would also require that DYRS engage in meaningful discharge and reentry planning for youth as soon as they are admitted to a placement that is outside the family home, including secure and out-of-state facilities. Discharge planning is important to ensure that services and programming are available to youth immediately upon their return to the community. As it currently stands, we've noticed that discharge planning does not occur until just before the youth is scheduled to discharge from a facility. There's also a lack of transparency regarding the discharge process and timeline. This often results in delayed discharges from out-of-home facilities, even when a young person has successfully completed their treatment program, and leads to a gap in services upon discharge. We've noticed that this is especially an issue when it comes to school enrollment, with some clients not getting properly enrolled in community schools for up to several weeks after they have returned. While we understand that some delays are unforeseeable, it's imperative for the agency to engage in robust discharge planning well in advance of a youth's anticipated return to the community. This is the only way to ensure that crucial services, including access to education, are maintained as a youth transitions from one placement to the next. The Road Act would require DYRS to start engaging in discharge planning immediately upon a youth's admittance to any out-of-home facility, including residential facilities, group homes, and therapeutic foster homes. This is best practice for reentry planning because it looks at a youth's treatment plan holistically instead of focusing narrowly only on their current placement. In other words, it allows and in fact requires that the agency look further ahead into the youth's case and provide a continuum of care that is consistent with DYRS's mission. We strongly encourage the agency to include the youth, their family, and their attorneys in this discharge planning process so that a young person's entire team can be part of their successful transition back to the community. Overall, the Road Act would provide clear guidelines to the agency, committed youth, their families, and their advocates about the process and timeline for placements and discharge. Thank you.
Thank you. Mr. Branham.
Greetings and salutations and good afternoon, Mr. Chairman and members of the committee. I thank you for holding this hearing on Bill 25-826, Recidivism Reduction Oversight and Accountability for DYRS Act of 2024. I also commend DC Attorney General Brian Schwab for preparing this legislation. I come before this committee to support this bill. I have made a submission to the committee and will let it speak for itself. This bill is a step in the right direction to direct DYRS to develop post-prosecution and release programs for juvenile offenders. DYRS must develop with community partners measures to rehabilitate and prevent recidivism among our young people. While there may be concerns of governmental duplicative oversight efforts, these issues, along with the what and the how of oversight and accountability, can be overcome via positive interagency cooperation and agreements. Mr. Chairman, as a district resident, I must comment on the overall premise of this bill, holding people and institutions accountable for supporting troubled district youth. Moving forward, while I believe in redemption and forgiveness, I also believe in integrity and honesty. I am not a priest, a preacher, a rabbi, an imam, or a church deacon, but I do believe in decency and in God. The council hearing for this bill was originally scheduled for review by the former Committee on Recreation, Libraries, and Youth Affairs. It is not intellectually honest to discuss recidivism reduction, oversight, and accountability for DYRS for our youth if adults are hesitant, silent, or otherwise intellectually they enable offenses committed by adult elected officials. District young people who come involved with DYRS and our courts are developing their bodies and their minds. They are searching for guidance and require support to mature physically, mentally, intellectually, educationally, and spiritually. The recent arrest of a council member on federal bribery charges is disturbing and frightening. I do not make any determination on guilt or innocence. All persons have the presumption of innocence until proven guilty in a court of law. However, elected officials and government officers are not children. They are adults who have been entrusted to serve others with honor and integrity. Our young people need to be lifted up and drawn to goodness, purpose, and respect for the common community good, not individual greed. Adults must show them the right path. If I can rephrase the song, "I Look to You" by Whitney Houston, our young people live and grow and see how adults live. Some feel lost without a cause and pray to heaven. Hear me now. After giving in to certain bad behavior and feeling winter storms have come into their young lives, and their lives have been darkened by the sun. After all they have been through, and they hang their heads down and cry, who on earth can we turn to? Those of us who hold ourselves as community leaders, teachers, preachers, and elected officials must be there and respond with love, open arms, and with empathy in our hearts, and say not only you can look to us, but we must also show them the way. Mr. Chairman, I support the bill, and with appropriate modifications and clarifications, I urge the council to adopt it. I also urge my district residents to vote for Kamala Harris and to vote no on Initiative 83.
Appreciate you threw in a couple other tangential issues, Mr. Ferrer. Oh, but before you go, so you read a statement that's different than the resolution I have. If you could submit that.
Yes,
statement to-
the resolution I incorporate in my,
I understand.
statement. I have it copies here.
That's a beautiful thing. If you would give it to us after you get out. Mr. Ferrer.
Good afternoon, Chairperson Mendelson, Subcommittee Chairperson Parker, and members of the Committee on the Whole. My name is Eduardo Ferrer. I'm a Ward 5 resident, the Policy Director at the Georgetown Juvenile Justice Initiative, and an Associate Professor in the Georgetown Juvenile Justice Clinic. Thank you for the opportunity to testify today in strong support of the Recidivism Reduction Oversight and Accountability for DYRS Act of 2024, or the ROAD Act. I want to thank the Office of the Attorney General and General Brian Schwab for his leadership and for introducing this act. The ROAD Act includes a number of common sense, research-supported reforms necessary to rehabilitate DYRS and ameliorate specific shortcomings at the agency that prevent it from effectively living up to its mission. I urge the DC Council to pass the ROAD Act this council period. I will focus my oral testimony on the awaiting placement crisis, but have submitted longer testimony for the record. The awaiting placement crisis. DYRS's failure to timely and effectively plan predisposition and failure to timely place committed youth post-disposition has resulted in an awaiting placement crisis at the Youth Services Center, DC's youth jail. Yesterday, 27 of the 95 youth detained at YSC were post-disposition youth committed to DYRS awaiting placement and services. The size of this awaiting placement population at YSC has increased dramatically over time. For example, on February 7th, 2023, the awaiting placement population was 15 youth. A year later, the awaiting placement population was at 40. While the awaiting placement population has decreased some since February, it's never fallen below 20 and was above 30 again just earlier this month. A deeper dive into the data prepared by the Office of Independent Juvenile Justice Facilities Oversight provides even more troubling trends. Since 2022, mean length of stay and awaiting placement increased from 35 to 46 days, and median length of stay increased from 18 to 41. Additionally, in 2023, 94 youth spent more than 1 month detained awaiting placement and services. 51 youth spent more than 2 months, and 29 youth spent more than 3 months. This does not include any of the time that they spent detained pre-trial. DYRS itself acknowledges that the average length of stay for awaiting placement youth surpassed 100 days in May 2024, and it remained over 60 days in August of 2024. To illustrate how this awaiting placement crisis was created, it's helpful to compare what the pre-commitment process used to look like versus what it looked like recently. And I've provided more detail, but I'll quickly summarize. Previously, there was a lot more planning that used to take place before disposition. Before disposition, a young person would often have their risk assessment instrument done. There would be a determination of their level of placement. A number of packets would get sent out to different facilities. A youth family team meeting would be held to discuss whether they had been admitted and the appropriateness of those facilities, the appropriateness of commitment itself, the availability of community-placed services, and then all of this would be presented to the judge at disposition. Now, most of that, if it's happening, is happening after the young person has already been committed to the agency. Despite the fact that DYRS is still receiving notice of intent to commit from the court well in advance of any disposition hearing. So recently, we've seen this real shift from heavy planning, intentional planning, meaningful planning up front to now waiting until a commitment decision has been made. And that's contributing in large part to the awaiting placement crisis. The ROAD Act is designed specifically to address those issues by returning a lot of the planning to the predisposition stage, where then when the young person is committed, there's a better sense and a better understanding of what they need, where they're going, and how quickly they can get there. The Road Act is critical to reestablishing controls, best practices, and improving the way things are functioning at DYRS while reducing the awaiting placement population. I'll just say in closing, and I'm happy to answer any questions, but what's happening at DYRS right now is not the result of love, but the result of lack. Lack of planning, lack of services, and lack of urgency. If we loved all of our kids the way that we love our own children, we would want the very best for them. We would be acting quicker. We'd be putting in place the needed services. We urge the DC Council to pass the Road Act, which will put us back on the road to that path. Thank you.
Thank you, Mr. Farrar. Thank you, each of you, for your testimony. We'll try 5 minutes, see if that works. So I have a lot of questions and I'm gonna not ask them. First of all, every one of you testified in support of this bill. Am I understanding correctly?
That's
Or
correct.
speak up if I've got it wrong. Second, Mr. Ferrer, I wanted to say while you were speaking to what used to happen, why isn't this happening now?
It's just a breakdown in the process. It really has. It was not formalized in the law. It was the policies that were put in place actually to prevent what's been happening now. So many, many years ago, what would happen is we'd show up to disposition and the judge would say, I'm going to commit this young person. And DYRS would be like, whoa, no one gave us a heads up. Now this person who we haven't worked with really, we don't know their family, we don't know what they need, is committed to the agency. And so the court said, okay, we're going to instill this notice of intent to commit process. So before any disposition, when a judge is even considering committing a young person, we're going to give DYRS a heads up, and then DYRS is going to put in place a plan for what it would do if committed. And so the process was to do all of these steps prior to so that they could present that plan to the judge.
Sure, so you're explaining, but you're not
Mhm.
answering my question, which is why is this not happening now, other than you're saying a breakdown? Is the agency overwhelmed?
I think part of it is for sure staffing. I think the agency has some theories as to why this process is breaking down. I do think staffing is contributing, communication,
As in not enough staff?
as in not enough staff in
This
the.
is not a budget hearing, but has the staff at DYRS been reduced?
My understanding is that they had a number of folks leave recently in both the pre-commitment and the case management units.
Well, they could leave because they're unhappy. That's different than they left because we cut the budget, we being the government.
My understanding is FTEs have not been reduced, that those FTEs are being
So they're
replaced.
vacancies.
Correct.
I mean, what I've heard about the current director is that he's good and that when he was in Maryland, he was good. Invitation to disagree?
I think I've seen a real breakdown in the process since February of 2023. And that has really allowed the awaiting placement
How
process.
many
to balloon.
directors have we had since February 2023?
We had an interim director and then Director Abbott.
Ms. Cairns was not a interim.
Correct. She left in February of 2023. So since she left, I've seen a significant increase in the breakdown.
Okay. I saw a figure the other day at CJCC, but I think that had to do with Title 16 youth,
Mhm.
that they are held on average 3 years. Do I have that right?
I have not seen that data.
2 years. Do you know?
I do not know, but that,
You
it's a
probably-
very different matter just because they are pre-trial and adult matters. It was very different from the commitment, which is what I'm familiar
You
with.
don't work with them because they're Title.
Only if they're also committed previously.
I will say, my understanding though is their population is typically half the size of the population of the awaiting placement population. And under DC law, you can't commingle the awaiting placement population with youth who are pretrial
Sure.
detained.
I'm gonna run out of time here. The, do any of you know how many youth total are DYRS? Now, that would be both New Beginnings, not both. That would be New Beginnings, YSC, but also community placements, and I don't know if there are any other ways that they would be under DYRS.
I believe I saw in the executive's testimony today that it was 175.
It sounds low to me. Do you think that's correct?
That would be 175 committed youth. So that wouldn't include youth who are detained pretrial or the Title 16 youth. So it'd be 175 plus around another 60.
another
60.
So you all support this legislation. Do you think the notion of having some oversight with the DC auditor, do you think that's duplicative and therefore unnecessary? The argument being that we've got the Inspector General, the auditor already has the ability to audit. The council provides oversight, and if you want to criticize the council, you're welcome to do, I'm seriously, you're welcome to do that, because I think we need to know what's going on. Do you think that this is duplicative to suggest that we have a new deputy auditor for independent juvenile justice facilities oversight?
I do not think it's duplicative. I think it's necessary. We need
Why?
rigorous independent oversight over DYRS that's regular and continuing, that has access not just to the data on an ongoing basis, but also access to the facilities to be able to go in unannounced and make sure that they are living up to really the spirit of the Jerry M litigation, which lasted 35 plus years. And I do not think more ad hoc audits or periodic oversight would be sufficient. I think we need someone laser focused, doing continuous rigorous oversight of the agency.
And you all are clear, without doubt, that these requirements for individual plans and for, I don't have the word in front of me, predisposition, exit placement, that's not being done.
Correct. And it's definitely not being done in a timely manner. And we're going to run into a big issue soon as well, where we're going to miss a huge opportunity. If DC submitted a Medicaid demonstration waiver to be able to take advantage of a waiver that the federal government's encouraging that would allow you to turn Medicaid on 90 days prior to releasing an individual from incarceration, that would allow us to turn Medicaid on, to get physical screenings, behavioral health screenings, connect young people to therapists so that they can start with therapy in placement and then continue with it through back into the community, a really soft, smooth handoff. And if we don't do this planning, we're not going to be turning Medicaid on when we should be. We're going to be missing a huge opportunity.
Meaning that we will not get federal support for 70% of the cost.
Correct. And we'll continue not to do planning until a young person is already back in the community and seeing huge breakdowns in terms of them being reconnected to an educational placement, let alone an appropriate educational placement. A lot of our young people are students with disabilities, and so they need a lot more lead time to make sure that they're getting the right placement once they're being released from a facility, and that's not really happening at the moment.
And the youth, the risk assessment, that's not being done?
The DYRS recently switched to the YLS CMI, which is good, but it's not incorporated anywhere in law. And our understanding is that there has been pretty significant pushback to the use of that tool within the agency itself. It is the gold standard to use a validated risk
What
needs
does that
analysis.
mean? They adopted this YLS CMI,
Correct.
but there's pushback.
Yes, my understanding is at the staff level, they aren't thrilled about using the new tool. And so there's been pushback.
I can add to that. They are often either not doing it ahead of time, so they might choose the placement and then do the YLS, which is backwards. Or they may only do it part way by only interviewing the youth and not the rest of their family or other providers. So we've been in conversation quite a lot with DYRS to encourage doing it with fidelity, because we also really support the YLS in its theory, but it has to be done before the placement's decided, early in the process, preferably before disposition, and with fidelity.
So codifying this would weaken the staff opposition.
Yeah.
I think so.
And clarify what their duties are, that it's not, it's part of a whole continuum. I think the beauty of this is it shows that from the beginning to the end, there can be a single plan, that you don't have to reinvent the wheel at the time of reentry when they're supposed to get out, but you have a plan already. And it's really a continuum of that plan. So I think it would also just clarify everyone's understanding of how this works.
One last question, and this is sort of a yes or no across the table. So are these, I'm going to be polite, these shortfalls, would you say that they are contributing to increasing the rate of recidivism?
Yes, I would say that longer terms of languishing in secure detention is causing harm and is is traumatizing our youth directly and not giving them the support they need when they get out to help them actually achieve their goals.
Mr. New?
Yes, I think that the lack of discharge planning in particular and reentry planning is a significant factor in recidivism. In recidivism, not having services in place, not having school placements in place, not having the support that young people need when they re-enter the community. It's a crucial time, and not having that planned long in advance is detrimental to their treatment.
Mr. Brown?
I defer to the three, thank you. I would defer to the three experts directly in the field. I have no reason to doubt their conclusions. My presence here is based on my previous work in the community as a commissioner and with the Fifth District Citizen Advisory Council, and working with young people at that time.
Thank you, Mr. Ferrer.
Based on the research, I would agree and say yes, but I would also point out that I think one of the other huge factors, which is not the subject of this hearing, is the lack of meaningful continuum of community-based services. So what are those young people either, why aren't they getting what they need in order to avoid being committed in the first place? And then what are they getting back in the community once they return home?
Of course, that could be covered in discharge planning. Councilmember Parker for questions.
Thank you. I'm gonna pick up where the chairman left off, Mr. Ferrer. You talked about the implementation of the YLS CMI, and DRS might point to that as a contributing factor for delays. Do you have data, or where would one find data for the young people that have received an assessment versus those that have not?
That would have to be directly through DYRS.
And so that is not publicly made available even to advocates and or legal representation for the young people?
Not to my knowledge. We can ask for it in individual cases. Sometimes they are willing to give it, sometimes they are not. But in terms of the aggregate data, we do not have access to that.
You talked about the Office of Independent Juvenile Justice Facilities oversight and the critical need for that. I want to go a step further. That office is functioning now. As you might imagine, there are some others that would say this is a waste of money. That office is not producing what we need. How do we ensure that the office has sufficient teeth so that it's more than just data and reports, although that's important, but that they can contribute to holding DRS accountable?
So that's actually one of the reasons why I do think having it in a place like the auditor, it is the right place for it to be seen as independent, not having a political agenda, really focusing on the research. I think what I really like about the Road Act as well is it would expand the role. They're really facilities focused now and just on 2 facilities, but it would expand their reach to look at all facilities as well as potentially ask for the data that you just inquired about. How many YLSs are being done? How many are not being done? When are they being done in the process? And then to be able to equip the council, the executive, the advocacy community to use that data to then advocate for the changes that need to be done. But I would advocate for them having a really independent role, which is why I think the auditor's office is such a great place for it.
One of the pieces of the Road Act that I'm particularly appreciative of is the accountability on DRS for young people that are not receiving services for more than 30 days. To the word that was used, those that are sitting languishing in a cell. And that is not only cruel, but I think criminal, because we know many of these young people have health needs as well as education needs that are not being met. What data is made available to you all as experts, advocates for the services provided to young people awaiting placement?
It's really about us asking. So if in a particular client's case, we might ask either the client or DYRS about specific services that we know they need. Education across the board we ask about. So we often hear that because of staff shortages, they might not be able to go to the school. So teachers have to go to the unit, or they might have to, if they're on lockdown, try to teach them through the door. We sometimes hear that they don't have the specific mental health services that have been recommended for our clients at YCI. I mean, actually, I would say always. They don't have those specific ones, the very intensive ones. You want to add on?
Yeah, if I could add, I think whatever services are available at the Youth Services Center, they are not considered services that a young person would receive in their treatment program. So even if a young person spends 3 months at YSC awaiting placement, they're, getting some access to some limited mental health services. The time that they've spent there, those 3 months doesn't count towards their
That's
treatment
right.
program. They're gonna need to go to a treatment program, complete that entire program, before they can be stepped down.
And I think that's a really important part. The clock doesn't start until they're actually placed.
Right.
And so those months of detainment at YSC, for some, they're not receiving any services, but also the clock hasn't even started. It seems like you're going to jump in there.
Yeah, just to add briefly and to really understand what that means for a young person is every month that a 15-year-old, a 16-year-old, a 17-year-old is in awaiting placement is 0.5% of their life. So if they're there for 3 months, that's 1.5% of their life. And that doesn't include the time that they spent detained before that, or then the next 9 to 12 months that they're going to spend out at a facility. So it has a huge impact on a young person's development to be in a place where they're not getting services, where they're not getting what they need in order to develop healthily from a adolescent development standpoint.
And two things I will say, one additional question, but a point I want to make clear to those watching. We are not shying away from needed accountability when it is appropriate. What I think everybody is talking about here is how do we actually lean towards rehabilitation so that we don't have a number like 92% that are leaving and or coming back at different stages of the process. One last question I have is just around how do we ensure this isn't just enacted legislation and that we have timelines on paper that DRS is still blowing through and not honoring? What should the council look toward to ensure there is actual accountability for the agency? And I'll just quickly go down the line and maybe we'll start with you, Mr. Burke.
Sure, I think it'll be twofold. One, I think it'll happen in individual cases through the court process. And then second, it'll happen through oversight, both in terms of hopefully whatever office gets created at the deputy or at the auditor's office, as well as continued council oversight using the information that comes out of that office to make sure that DYRS is held accountable.
The strong word would be oversight, oversight, and oversight.
I mean, I would just push I want to hear you next, but young people there are supposed to receive services now. They're supposed to receive an assessment now. And we know DRS is not necessarily doing it.
I think the Road Act puts important parameters on specific timelines and ways that and a process that the agency is supposed to engage in. And so one way, that oversight could happen is getting data on whether they are meeting those specific timelines and whether they're meeting those specific parameters. So you asked about the individual plans. We could ask the agency, in what percentage of cases has this timeline been met and in what cases have they not been met?
I'll add two things. One, DBARS does have its own quality assurance, and I think this will help them and decide of what they need to be reporting on and looking at carefully to monitor their own care coordination and their pre-commitment units. And then two, youth and families will have this information too. Youth are excellent advocates for themselves. So they will know, hey, it's day 28. I need this. And they can talk to the care coordinators and those around them. And of course, we would help them do that. But I have no doubt they will advocate for themselves.
Thank you all for your testimony today.
Thank you, Councilmember. Councilmember Pinto.
Thank you, Mr. Chairman, and thank you all so much for your testimony and the important work that you do. I want to ask you a little more about this oversight piece, and maybe Mr. Ferrer, I could turn to you. This is, I guess, in part a philosophical question, but in part a practical one. Isn't oversight the job of the council?
I do think it's the job of the council, but I think that the deputy auditor's office, or yes, the deputy auditor's office that would propose would be an incredibly valuable tool that the council could point to sharpen its own oversight.
And I guess when do you think that sharpened tool should be utilized? Like this has come up as an idea for a number of different agencies that are having challenges of, okay, what if we set up another oversight body? But the metrics that you all just went through, and I heard some great ideas about, what percentage of cases it's really happening in, what are the outcomes? Mm-hmm. Those are traditionally questions of our body, whether it's during performance oversight time or otherwise, to make sure that our agencies are meeting the standard of the law and the outcomes that we set out for. So I guess when do you think that threshold distinction should be made to set up a whole separate oversight body?
I think in this particular case, I would point to the regularity of how important it is that the data comes out. OUC might be another example like this as well, but over the council oversight, performance oversight typically takes once a year. So when we look at performance oversight answers, and I actually do cite answers often in court, but it's a one-time snapshot that I'm relying on from typically, the winter timeframe. Having an office that, such as the one proposed in the Road Act, would allow regular reporting and updates, as well as having an office that, to be completely frank, is responsive and transparent. So if there's particular data that's needed in June or July, we can then request the data from the deputy auditor's office and utilize that data to ensure that we as advocates are also holding DYRS account.
Thank you. And this can be kind of to anyone on the panel, but when it comes to the individualized plans, is there any benefit of having a distinction for those plans, whether you're a youth who is in custody, versus, or a youth who's at New Beginnings versus a youth who may be in a safe house or another type of facility or at home during this time? Or is it important to have consistency for the same type of plan for rehabilitation regardless of what your setting is?
I think that ideally an individualized plan would be just that and would take into account specific circumstances of the young person. A young person who is at home is going to need different services than a young person who's at New Beginnings. And I think this underscores an issue that we've been seeing across DYRS, which is a lack of creativity and a lack of individual thinking in terms of a young person's plan. A lot of time it seems as if there's a cookie cutter approach to young people. They're in a secure facility, then they get stepped down, and then we have the same kind of conditions of supervision that everyone receives. And there's not a real kind of creative thinking about what exactly is this young person interested in? What do they want to do? What are their hopes? What are their goals in life? And how can we incorporate that into their plan? So to answer the question, yes, I think it should be tailored to their individual context.
And just to quickly add on that, this is why it's so important to do a validated risk needs assessment tool and why it's so important to the legislation. Because without knowing what needs a young person has, you really can't put together a sophisticated, individualized rehabilitative plan that's going to go directly towards reducing the risks of recidivism. And so utilizing a tool like that prevents us from doing what happens now, which is we take the services that we have and we pigeonhole kids into those rather than looking at what a young person needs and making sure they get that.
Thank you both for that. And just in my last couple of seconds, Mr. Ferrer, when you testified very helpfully during the hearing I had on the Uplift bill, one of the things we were talking about then was a kind of robust plan for each juvenile. And one of the arguments or the proposals from Uplift was to do that earlier in the process and to have DYRS involved. And there was a lot of opposition to that bill. And a lot of the testimony I heard from you and others was, look, we already do this and we already have the right parties involved in this at the court. So what's the distinction between that conversation around the timeline and the conversation today when it comes to the individualized plans?
One of the big distinctions is what population of young people you're talking about and where they are in the process. So at the point that the Uplift bill would have involved DYRS, the vast majority of those young people who would have been meeting DYRS would never been committed to the agency. So it just makes no sense for DYRS to do planning at that point. However, once DYRS receives a notice of intent to commit from the court and commitment to the agency is either right around the corner or a real possibility, then it makes sense for DYRS to step in and start their planning process, because pretty soon thereafter, they may be the ones leading the charge in terms of implementing a plan for that young person and their family.
I see. Okay. Thank you very much. Thank you to all of the panelists. Thanks, Mr. Chairman.
Thank you, Councilmember Pinto. Councilmember Allen.
Thank you, Mr. Chairman, and appreciate everybody's testimony. There's been a little bit of conversation around transparency and reporting out. I think it's important to note when we talk about dashboards, and goodness, government loves dashboards. But simply reporting out failures isn't actually making any change. And so having the way that I think that is intended within this legislation is by positioning oversight within the auditor's office. It is to not just create a dashboard, but is to actually help sharpen the tools of oversight. And I think we've seen the auditor do that very effectively. I can tell you, I have used the auditor's work product many times to help sharpen that oversight. And I think that's the intent here. And so there can be great value in that, but obviously it takes the council's oversight job to help create that change and reform. In terms of the data, continuing that theme for a second. So when we look at that, the oversight office's information, you kind of pegged February 2023 as a note here. When we look at the YSC commitments, February 2023, we're at 62. Today, we're at 97 for a 98-bed capacity facility. I'm curious, what I don't see anywhere is a reporting out of the numbers on our out-of-district placements. So for youth that are sent somewhere else. And I was curious if you have any data that you can share about what you've seen or what you're aware of in terms of either trends or where that is reported, or should that be included in whatever reporting mechanism gets created in oversight so that we can have a better handle on how many of our young people are being sent out of the district. And I guess maybe I'm kind of looking at Mr. Ferrer, but would welcome anybody who feels they can jump in on that.
I do have that data that DURS recently shared with us, but I don't remember the answer to that. So we can share it with you afterwards.
Okay, excellent. And I know our DURS partners are here, so when we get back to that later on, perhaps you can be ready to share some of that.
And they do have a population data tab on their website. I cannot remember off the top of my head whether it includes out-of-state residential placements, but it might.
Okay. Should that be built in so that it's more upfront and that is part of what our monitoring and our reporting should include?
Yes.
Okay. One of the things I'm also concerned about is the ability to monitor if there is a facility outside the district. And let's be clear, I'd prefer not to have anybody go outside the district. If there is a placement that's outside the district, are we hamstrung from an oversight perspective by the ability of any third party or oversight to be able to inspect conditions or of the facility itself or of the young people?
We've struggled with this in part because sometimes it's DBHU contracts and so, or DC Healthcare Finance. Sometimes in the past, it's been DYRS. It depends on the funding mechanism for how that young person got placed there. I do think we could do a better overall job as a city in making sure that all of our contracts with out-of-state providers allow this right of access, allow a right of records. I mean, we had a case where for 9 months we were stonewalled. A young woman was down in Georgia and all we wanted was give us the rehabilitation plan. What are you all doing with her? The judge was asking for it. OAG was asking for it. We were asking for it. And the facility just basically ran out the clock until they said, oh, she's been healed. Now she gets to come home.
And that lack of transparency is deeply troubling, but also the fact that we're going to that we have anybody who's placed outside the district should be deeply troubling because any amount of rehabilitation is going to be harder when it's not here. Any connection to family, to community is going to be harder when they're not here. So all of that is the reason why we want to minimize that. And obviously I'd love to eliminate that. So my time is going to start running out. I was going to ask if you can I'm going to ask you to preempt a little bit. I'm assuming later today, we might hear from the agency either criticism of the legislation or opposition of the legislation. What do you think we're going to hear and why do you disagree?
I can answer that. Part of it, I expect they may say they're already working on it and trying to do what's already in here. And I see that, but I do think that adding more opportunity for collaboration and other people to be involved will make it easier. And I don't think that just because they're struggling doesn't mean we shouldn't add more help and clarity and transparency. It's just the opposite. I think we see a struggling agency, we all need to get on board and help. And that's what I think this does.
Thanks. I know my time is ticking down. So Mr. Chairman, thank you very much. Thank you all.
Thank you, Councilmember Allen. Councilmember Lewis George.
Thank you, Chairman. My questions have been asked and answered by my colleagues, but thank you for this panel.
Thank you. Councilmember Fruman.
The same, like, thank you very much. But the questions I was going to ask have been asked.
Councilmember Tran White.
Yes, thank you, Chairman. There has been a lot of great conversation and suggestions as relates to reporting and accountability. One of the greatest things I'm concerned about is implementation. Because we can get an idea of what is done, what is being done, what is not being done. But I don't know if that changes what's happening every day. And that's my greatest concern. I sent a letter to council members and also the director of bid 2023 asking for a plan from the director, being as though he was new. And I went back and just looked at it, and I think it was item 9C, one of his priority areas. Let me just list them: facility safety and security, process for placement and community placement agreement, and community supervision. And number 3 is what I want to zero in on, was treatment planning, length of stay policy, and release from commitment decisions. And hearing from you, Mr. Ferreira, you were saying basically that some of these things are not happening in the hearing now. I think you said it lacked love, it lacked a plan, and it lacked services. So if you can speak to any improvements that you have or have not seen real quick, because you spoke to those in brief.
Improvements, I'm not sure that I can really speak to. I haven't seen those recently, unfortunately. And this is transparently not just a DYRS issue. When DYRS is doing reentry planning, it has to rely on a number of city agencies in order to put together a real wraparound plan around that young person. So whether it's DBH's core services agencies providing behavioral health, whether it's the schools timely responding to enrollment and IEP requests and things along those lines. There are a lot of different pieces that go into reentry planning. And it seems like all of those pieces right now are really breaking at the seams when it comes to our young people who are committed. So this is why it's so critical that that planning process start a lot earlier than it's starting now.
And ideally, you said, I guess you said historically, there were some measures in place, but that has broken down over time. I wanted to zero in on assessments, because you first have to assess what the problem is in order to come with a viable solution. Where do you think the breakdown is coming in and timing for receiving and getting those assessments done?
What we've seen is real staffing issues. So I've had clients who have been told prior to commitment that, you know, the soonest someone could come see them is not for a month or 2. And by that point, they're already committed and now they're in a waiting placement posture. And so I do think part of it's driven by staff, lack of staff. I think part of it is driven by this idea that folks didn't want to implement the YLS CMI. And so there has been pushback claiming that they somehow need a psychological evaluation from the child guidance clinic to be completed before the YLS can be completed. And that's just not what the YLS requires. If you look at the manual, it would be nice to have that, but you can fill out the YLS with collateral interviews with the parent, the child, the probation officer, a school teacher, looking through their records, et cetera. And when you look at the 3 case studies in the YLS manual itself, I don't believe any of them rely on psychological evaluations. So these can be done without them.
Thank you. I do know the courts have been really pushing the district to get our young people to different placements, even outside of our traditional YC and New Beginning facilities. I know you spoke about that extensively over a number of hearings that I chaired. Have you seen any improvements in moving young people along where they need to be?
I think the data is, according to Director Abed's testimony, it appears that he will state that the awaiting average length of stay has decreased from over 100 days to over 60 days. I think that's still incredibly too long. It's much longer than it was historically. And so I think we need to drive that down a lot further.
Thank you. Thank you for everyone for testifying today. Thank you, Chairman.
Thank you, Councilmember White. Councilmember Bonds?
Thank you very much, and thank you to the panel for your insight and for your expertise that you've applied. I wanted to ask about, and this is to the so-called experts who have been going in and out of the facility. So, Mr. Brennan, no reflection on you. You made it clear you're just about the community. So my question is, what are the barriers to providing a quick turnaround as it relates to getting young people really situated once they're in the facility? And as we're thinking about helping them to go through the reentry process. So what do you think are the barriers?
I can name a few. One of the barriers is, as Mr. New said, a lack of creativity in finding community placements. So we've heard from DYRS that their solution to the awaiting placement is to get more contracts with out-of-state placements. But really would urge DYRS to be more creative with community-based placements, including foster homes, of which they used to have quite a lot. And services that would support youth going home to their families. We also have seen that in some cases, youth are, their YLS puts them at a community appropriate placement level, low or medium, where they are appropriately served in the community by their own assessment. And DYRS has decided to place them at a high instead. They have gone through an override process to put them at a high. So I think DYRS could decrease the number of times that it does that and follow its guidelines to place youth in the community when they think they can safely be done. You want to add
Okay,
anything?
so you're saying, when you say the higher and the lower, you're saying that there are young people who can just be returned to their neighborhood?
Yes, or the community in some way. Maybe it's a foster home in Maryland, or maybe it's a grandmother who's not where they were, some way they can be in the community based on their own needs.
I see, okay, yes.
I think when it comes to discharge and reentry planning in particular, what we've experienced is it's just an agency unwillingness to engage in discharge planning early on. There have been moments where we've talked to clients, care coordinators, their case managers, when a child is maybe a few months away from discharge or they're on track. And we've just been told time and again, it's not time for that. We can't tell you, or it's not time for us to discuss what the plan will be after they are discharged from this facility. We have to wait. And then it becomes, months and weeks and then days before a scheduled discharge. And then they'll maybe hold a meeting and talk about the reentry plan.
All right, has that been your, you've
That-
observed that as well?
Absolutely. I agree 100%. I would add kind of two other barriers from the reentry, who's providing services to the young person when they get back in. One, this Medicaid rule that doesn't allow you to use Medicaid services in facilities has been a real barrier, because what we would ideally love is for a young person who's in a facility to be able to start working with a therapist prior to discharge and then just continue on with them in the community. That would be the ideal. And so this demonstration waiver that DC applied for will hopefully knock down one of the barriers, but only if we actually take advantage of it, which goes back to the earlier planning. I'd say the other piece of it is really the lack of community-based services, both before kids get committed and once they are committed. If we had a more robust continuum of community-based services in DC, fewer kids would end up at DYRS, and the young people at DYRS would be better served once they're returned to the community. And even for those committed, more could be served in their community despite being committed, because we'd have the services to mitigate that risk.
I
And so
hear
we're
you.
struggling there.
It's all good stuff, and we could talk another hour on those, but they're not going to give me the time to do that. But what I am also concerned about, another area that you mentioned, you said, well, the young people come and there's no plan of action. Well, almost all of our young people come through the school system, and each of them probably has a individual education plan. So there is a plan for their education. Many of them are in households that have a social worker. And so I'm just wondering if those plans cannot be implemented or continue with the implementation through their tenure in the detainment or the confinement.
With the individualized education plan, they absolutely should be. Federal law requires that. And so they should be making those accommodations when they're in school. And I would argue making those accommodations throughout the entirety of their time in the
Well,
facility
So
itself.
my point is that they have those plans. So how do we get the plans to follow the young person wherever they are?
That would be great.
I
Okay.
do think that if implemented with fidelity, the YLS could do that because it's supposed to look at their records. It's supposed to look at what's going on in their life. So that it could be done with what the information they have. I also think that better coordination between agencies is important, like with CFSA, if they are under CFSA. We've seen a general lack of coordination between the two agencies when a youth is under both. So I do think that could be improved dramatically. And the Council of Court Excellence recently put out a report on that. Well, no, it was the auditor, actually.
Yeah,
who
you,
put out
you
that
have
report.
convinced me we're talking about an ombudsman individual or office that can help facilitate making sure that all of the information that is needed to work with the young person follows them while they're institutionalized. So thank you. Thank you very much. Thank you, Chairman.
Thank you, Councilmember Bonds. That's going to complete all the questioning for you all. Thank you very much for your testimony and your time. And Mr. Branham, remember to give us your fuller statement. Thank you. I'm going to call the next group of witnesses. Irene Jacobs, who's policy manager with Black Swan Academy. Kristen Eliason, who's head of services for the Network for Victim Recovery of DC. I'm told they're both virtual. Tracy Velasquez, who is policy director at the Council for Court Excellence. Dr. Carmen Johnson, who is she's the founder of Helping Ourselves to Transform. Austin Steele, also with Helping Ourselves to Transform. Catherine Joe, also with Helping Ourselves to Transform. Nasser Mathis, with Helping Ourselves to Transform. And Natasha Levine, with Helping Ourselves to Transform. And I'm told they're all virtual. You get a gold star for being here. I'm going to start with Irene Jacobs. Ms. Jacobs, and she is
Good
participating online.
afternoon.
Yes, we hear you and see you.
Thank you. Wonderful. Good afternoon, Chairman Mendelson and members of the Committee of the Whole. Thank you for the opportunity to testify today. My name is Irene Jacobs. I'm a clinical child psychologist with a specialization in youth risk and resilience. And I'm testifying as representative of the Black Swan Academy, a nonprofit aimed at granting youth opportunities to gain civic engagement skills for empowerment. I am here to uplift the demands of the Black Swan Academy's Black Youth Agenda titled "We All Rise When Black Youth Thrive," as it pertains to the recidivism reduction, oversight, and accountability for DYRS Act. This agenda was created in collaboration with middle school and high school youth and raises the unique concerns of Black youth living in the District of Columbia in order to create positive systemic change through public policy. The agenda item I'd like to talk about today is our Safe Passages for Youth Passage campaign, which calls for the council to address crime and violence by investing in the community and promoting non-carceral rehabilitation plans for our youth. It is important to note that the combination of brain development and the context in which someone lives can influence the level of risk that they present. For young people living in the district, there are systemic disadvantages related to their basic needs being unmet and dehumanization, creating a school to prison pipeline and recidivism. Black Swan Academy youth are calling for a redesign of the system in order to secure more processes of protection for youth reentering society. Research indicates that further integration into the justice system increases recidivism rates, and conversely, more robust community resources decrease recidivism. Creating a formulation for each child means that we move away from harmful labels to being more child-centered and toward inclusive approaches to care planning for our youth. In the Black Swan Academy's climate survey, nearly 1/3 of youth reported witnessing unsafe situations in their neighborhoods and unsafe conditions. Black youth in economically disadvantaged communities are also disproportionately exposed to community violence and drawn to crime and violence. These factors impact their health and increases their risk for post-traumatic stress symptoms, as well as a lifetime of system involvement. These disproportionate vulnerabilities and exposure to community violence are rooted in systemic racism, structural oppression, and systemic divestment in predominantly Black neighborhoods. Our youth deserve to experience true safety, and this means supporting their growth, learning, and development, even if they have been brought into custody. This can happen by identifying and supporting non-carceral approaches to care, healing, and validating, as well as addressing the root causes of juvenile delinquency. We know that incarceration does not equal rehabilitation. As a preventative measure, positive youth engagement includes DYRS creating opportunities for youth. A majority of our Black Swan youth report that having recreation activities available for youth after school can be an effective way to keep youth safe and out of trouble. We are asking for more interagency support and the advancement of the ROAD Act and towards creating community resources for our youth and creating more youth safe spaces. When it comes to the ROAD Act, discharge planning and transitioning to community spaces must include resources embedded in youth neighborhoods. Opportunities for enrichment and recreation are known as stepping stones and will continue to create a healthy development and resilience of our youth. The ROAD Act is a promising step that has the opportunity to build community-based protections, familial support, and individualized care that youth committed to DYRS deserve. Thank you for your time this afternoon.
Thank you. And Ms. Jacobs, I don't have a copy of your statement. If you could provide it, please.
Absolutely, thank you.
Kristen Ellison?
Thank you, Councilmember Mendelson, and members of the committee for considering my testimony today. My name is Kristen Eliason, and I am testifying on behalf of Network for Victim Recovery of DC as its head of services. Since 2012, NVRDC has supported over 10,000 crime victims and survivors in the district through its free advocacy, legal, and therapeutic services, which include our youth services. In February 2021, the entire DC Break the Cycle legal team joined NVRDC, and since that time, we have been privileged to be able to provide our services to youth aged 13 to 24, which fills a critical gap. In FY23, we served over 220 youth impacted by violence, and in addition to providing services in the aftermath of crime, we have begun prevention efforts. Through a grant from the Federal Office on Violence Against Women focused on serving youth, we have developed and facilitated trainings for youth touching upon crucial topics such as consent, healthy relationships, dating violence, and sexual assault. This is in addition to providing training for adults and professionals who support youth. Our youth services have also been enhanced by our current partnership with the DC Office of the Attorney General, which allows us to facilitate restorative justice practices with youth. We have completed 2 youth healing circles, which are a facilitated space where youth can speak about their own experiences and their understanding of violence, accountability, and harm, with another scheduled for October of this year. NVRDC's work aims to co-create ecosystems of healing and restoration that create safe communities for all, and we believe that early intervention, breaking cycles of violence, and focusing on effective prevention is critical for this to occur. This is why we want to thank the DC OAG for their leadership in wanting to increase safety for youth who intersect with DYRS and ensure it is a protected space for all. In addition to the proposed oversight of DYRS, we would also like to see an expansion of options provided to all youth, those who have experienced harm and youth who have caused harm as well. Approaches such as restorative justice can minimize the impact youth may have when they interact with the legal system. This impact is felt in detained youth experiencing high rates of rearrest, being less likely to graduate from high school, and higher rates of experiencing depression, post-traumatic stress, and suicidal ideations or thoughts. Additionally, we want to ensure that this bill takes into account survivors' rights and experiences so that they're included when speaking about accountability, prevention, and justice. Therefore, NVRDC respectfully recommends the following shifts to the bill. First, requiring trauma-informed training for all DYRS staff to ensure all youth are engaged with in a trauma-informed manner. While most people who experience crime and trauma do not go on to commit crimes or complete crimes, we know that most people who cause harm have a history of trauma and adverse childhood experiences or adverse experiences. This tells us that DYRS staff are engaging with youth who may have unaddressed trauma and youth who may be responding to trauma cues, what are commonly referred to as triggers, including the very experience of being detained or court involved. Notifying the survivor that a predisposition hearing is happening and allowing for them to submit a type of victim impact statement that may then be considered in the development of a risk needs assessment. If the hearing results in having the youth return to the community, giving 14 days notice to the survivor and having a rebuttable presumption that this can be skipped when there is a clear and convincing and narrowly tailored reason why the survivor shouldn't be notified and could pose a risk to the youth. When looking at the individualized rehab plan, taking into consideration if the youth participated in any restorative justice processes, having the deputy auditor consult with victim support services to ensure that survivors are being notified throughout the process and being treated in a dignified and appropriate manner, a survivor being able to request review of the plan for the youth who caused harm, and a restorative justice option and process available for youth and clear delineation roles. The power of restorative justice is well known, and we know that it is shown to have greater victim and survivor satisfaction, increased perception of fairness and justice. Thank you for your time, and I'm happy to answer any questions.
Thank you, Ms. Eliason, and I do have your statement. Tracy Velasquez?
Excuse me. Thank you, Chairman Mendelson, Subcommittee Chairperson Parker, and members of the committee as a whole. My name is Tracy Velasquez, and I am the Policy Director at the Council for Court Excellence. CCE is a nonpartisan, nonprofit organization with the mission to enhance justice in the District of Columbia. Based on our experience and research, CCE supports the underlying goals of the ROAD Act. In our 2024 report on crossover youth, we noted that DYRS and other DC agencies are not adequately serving youth who are involved in both the child welfare and the juvenile justice systems. One area of particular concern was the lack of early identification of crossover youth. Jurisdictions with practices and policies specific to crossover youth have seen improved outcomes, including reduced recidivism. However, without early and appropriate assessments, these youth cannot receive effective, targeted support and services. Our report notes, quote, "It is unclear whether DYRS assessments are sufficient to understand the needs of youth who have been in the child welfare system." Our report additionally notes that DYRS reported that only 45.3% of newly committed youth received a complete case planning process within 90 days of their commitment start date. This means crossover youth are waiting for months for a case plan that addresses the significant trauma they have experienced. Of course, all youth who become involved in the DC justice system would benefit from more timely assessment and effective case management, as this legislation aims to ensure. CCE also supports the proposed legislation's goals for increased oversight of DYRS. Of particular concern is that the current oversight agency lacks enforcement power of its recommendations. For example, a 2022 report proposed that DYRS, quote, "publish critical incident and assault rates by facility on a monthly basis to provide a higher level of transparency to the public about the conditions of confinement at YSC and New Beginnings." However, as these recommendations were not enforceable, DYRS has chosen not to make this data publicly available. An increased number of youth in confinement creates even greater urgency for independent, enforceable oversight. As was mentioned earlier today, the YSC population yesterday was 95 youth, compared with 52 youth in February 2023. And provisions in the Secure DC passed earlier this year may contribute to higher populations of youth in facilities moving forward. While much of the focus of recent public attention on DYRS has been on criminal justice outcomes such as rearrest rates, it is important to remember that recidivism is just one outcome measure and does not actually address whether the district is improving the well-being of committed youth themselves. A recent CJCC report noted that justice-involved youth in DC had 3 times as many unexcused absences and were over twice as likely to be homeless. An oversight body with more authority could require that a variety of measures of youth success beyond recidivism were regularly reported by DYRS. We view the proposal for ODCA to assume oversight of DYRS as a reasonable intermediary step and we would welcome the chance to work with council, OAG, and community partners to develop a plan for permanent independent oversight. Our findings from the crossover youth audit brought home the interconnectedness of the various youth serving systems, including, importantly, Child and Family Services Agency, CFSA. This suggests to us that the district should seriously consider a single entity to provide oversight of all agencies that intersect with DC's children. I must also note that improved case management and better oversight of youth in custody is necessary but not sufficient to ensure the district's most vulnerable youth become thriving adults. As was mentioned earlier also, incarceration is associated with a variety of negative outcomes for youth, including higher rates of rearrest, adjudications and convictions, decreased chance of graduating from high school, and lasting health impacts. The expansion of prevention, intervention, and diversion programs is ultimately needed to improve outcomes for district youth. Our data overview published this week, which should be on all of your inboxes, showed that the vast majority of youth participating in diversion programs in 2023 were not rearrested. Over 9 in 10 youth were not rearrested who were diverted. We urge the council, the Office of the Attorney General, and other district agencies to continue to work to keep as many youth as possible from not being committed to DYRS in the first place. Thank you again for this opportunity to present testimony, and happy to answer questions later.
Thank you, Ms. Velasquez. Dr. Carmen Johnson.
Thank you for the opportunity to testify on the ROAD Act. Thank you, DC Council, for having me. I am Dr. Carmen Johnson, founder of Helping Ourselves to Transform, an organization dedicated to supporting impacted individuals through education, reform, and advocacy in Washington, DC, and Maryland. We believe focusing on youth is essential to reducing repeat offenses and making a lasting positive impact on this community. Providing proper parental involvement, education, healthcare, and community support is crucial to youth development and success. I am also a member of the Council for Court Excellence in Washington, D.C. Earlier this year, CCE released a report called the Crossover Youth Audit, which found that DC agencies, including DYRS, are not doing enough to help youth involved in both the child welfare and juvenile justice system. Identifying these youth early and giving them targeted support is key to reducing repeat offenses. However, DYRS has struggled as only 45.3% of newly committed youth completed case plans within 90 days, far below the 80% target. I support this bill call for increased oversight of DYRS as current efforts lack the power to enforce change. For example, OIJJFO October 2022 report showed the need for more transparency in critical incidents, but DYRS didn't release the data because there was no requirements to do so. While oversight is important, it needs to be paired with programs that focus on prevention and diversion to really make a difference, as incarceration often leads to negative effects like repeat offenses and lower graduation rates. The DC auditors assume oversight is a reasonable temporary step, but a permanent independent oversight body is needed. Our findings from the crossover youth audit highlights the need for a single group to oversee all agencies and that interact with DC youth, including Child and Family Services, to provide full services or to provide full support. Helping Ourselves to Transform support the ROAD Act with focus on diversion programs and individualized rehabilitation plans to prevent repeat offenses, promote reintegration in services, and accountability for our youth. Thank you again for the opportunity to testify. And I just want to say that I have over 30 years working with youth and young people in our community. And I do believe, and I know emphatically, that the youth are our future. Thank you.
Thank you very much. Austin Steele.
Good afternoon, Mr. Chairman and the other members of the council. Thank you for this opportunity to testify this afternoon. My name is Austin Steele. I'm a junior at the University of Maryland, College Park, and I'm also an intern with Helping Ourselves to Transform under the leadership of Dr. Carmen Johnson. an organization that is dedicated to promoting and facilitating the successful reintegration of incarcerated people back into society. Helping Ourselves Transform believes that every returning citizen deserves an equitable second chance. This equity is created through education, social and legislative reform, and the work of public institutions and non-for-profit organizations in promoting rehabilitation and reintegration. We believe special care must be paid to vulnerable groups like young offenders to reduce the threat and impact of recidivism. The key harms of recidivism are twofold. The first harm is the vicious cycle of offending and incarceration that prevents rehabilitation and increases the number of people in detention. Second is the harm that reoffending creates for society, with an ongoing flow of offending threatening the safety and well-being of the DC community and beyond. Legislation aimed at limiting recidivism is not giving amnesty to an offender. It is an intentional effort to protect our communities from the far-reaching impacts of criminal offending. Any attempt to limit recidivism in young offenders must focus on positively shaping their long-term future. I believe the Road Act is a strong step in the right direction, and I personally agree with the statement made by the Attorney General. The creation of an oversight body for the DYRS is fundamentally a good idea for several reasons. Firstly, an oversight body ensures that the DYRS are held accountable for its actions and decision-making, promoting transparency. Furthermore, the Road Act and its oversight body ensures that the rights of young offenders are protected and young people receive an appropriate level of care and guidance. The creation of an oversight body also sets a higher standard of care and supervision that can be applied consistently across all cases in DC, creating fairness and unity across the district. I also believe the implementation of individualized rehabilitation plans across all young people in the DYRS's care is an important tool in preventing recidivism. The creation and use of these plans ensure that progress can be observed and scrutinized. These plans would allow the DYRS to address behaviors of concern and watch for signs of reoffending. It would also help provide guidance to DYRS employees on how to treat or work with a young offender, creating a consistent standard of care for a young person when dealing with any DYRS employee. I believe that the Road Act helps limit recidivism in several ways. The Road Act ensures that targets for re-entry are met, ensuring that a young person is well equipped when reintegrating back into society. The key to limiting recidivism is through the building of necessary life skills and the creation of a strong support network. The Road Act ensures both of these requirements are met. I believe that the passing of the Road Act would promote the building of skills through these individualized rehabilitation plans and would ensure that the DYRS adequately prepares young people for reintegration. Thank you very much for your time this afternoon.
Thank you, Mr. Steele. Catherine Joe? I believe she's not here. Nasser Mathis?
Greetings, Chairman Mendelson and council members. I, Nasir Mathis Chambers, am a sophomore at St. Mary's College in Maryland and a member of several campus organizations, one of which includes a sitting senator of the Student Government Association. I also proudly take the role as lead intern for social justice and civic engagement with Helping Ourselves to Transform under the leadership of Dr. Carmen Johnson. As a lifelong resident of Washington, D.C., and a member of the district's youth community, I am writing to express my strong support for Bill 25826, the Recidivism Reduction, Oversight, and Accountability for the DYRS Act of 2024, or as known as the Road Act. I believe that this legislation is essential for ensuring the well-being and success of the young people in our city. The Road Act provides a much-needed framework for reforming the Department of Youth Rehabilitation Services and improving the outcomes for the youth in its care. By strengthening oversight, improving rehabilitation plans, and granting the district court more authority, the Road Act will help to create a more just and equitable system for young people. I am particularly encouraged by the focus on personalized rehabilitation plans, as this will ensure that each young person receives the support that they need to succeed. As a former Washington, D.C. Ward 8 member, I've seen firsthand the challenges that many young people face. The Road Act offers hope for a brighter future, and by providing a more effective and supportive system for those who need it the most. I urge you to support the bill, and I urge you to support the vote in its favor. Thank you for your time and consideration.
Thank you, Mr. Mathis. Natasha Levine.
Thank you for the opportunity to testify. My name is Natasha Levine, and I am testifying in favor of the Road Act. I am an intern at Helping Ourselves to Transform under Dr. Carmen Johnson, and I'm currently a sophomore studying law and society as well as criminal justice at Oberlin College. As a student in these fields, I've come to understand the destructive effects of recidivism. Recidivism, or the tendency of previously convicted individuals to reoffend, possess serious challenges, not only for the individuals involved, but for society as a whole. It undermines the criminal justice system, creates new victims, and disrupts community safety. In Maryland, for instance, the 3-year recidivism rate was 40% in 2024, underscoring the urgency for reform. Although agencies like DYRS are intended to reduce recidivism, they have yet to fully achieve this goal. The Road Act is crucial in addressing this issue through a focus on rehabilitation, which is essential in breaking the cycle of reoffending. The Act calls for significant reforms in DYRS's supervision and intervention practices to improve public safety and reduce recidivism among committed youth. It also strengthens the district court's district court's authority to intervene when DYRS fails to provide adequate services, and it mandates independent oversight to enhance accountability and transparency. I firmly believe the Road Act will enhance the effectiveness of DYRS and reduce the number of future victims. Thank you for considering my testimony in support of this critical legislation.
Thank you, Ms. Levine. So correct me if I'm wrong, but each of you testified in support of this bill, even though one or two of you had some suggested additional changes or revisions. Anybody disagree with that? I don't think I have any other questions at the moment. Councilmember Parker, do you have any questions?
Yes, just a few. Ms. Jacobs, if you're still there, you testified on behalf of Black Swan and for more support for youth re-entering society after detention from DYRS. Do you care to elaborate, maybe providing 1 or 2 examples of what that support might look like? Ms. Jacobs, if you're speaking, we can't hear you.
Yeah,
Okay. Can you hear me now?
Yes, yes. It seems like you're going in and out. How about it seems like you're breaking up. Maybe you have a bad connection.
I'm gonna try.
I'm gonna move to the next person and try to come back. Ms. Velasquez, I wanted to come to you. You mentioned that we need to focus on crossover youth within the care of DYRS. What might this look like in particular? That's one general question. And then 2, what counter accountability systems are in place from the CFSA side to ensure young people in DYRS's jurisdiction are receiving support, care, et cetera?
Great. Thank you for the question. Yes, in our report called A Broken Web, we talked about a number of ways that DYRS and in this case CFSA primarily could improve outcomes for crossover youth. And the first really is identification. The YLS actually has not been shown to adequately predict risk for crossover youth. So I think that as they look at the YLS, they also need to look at, are we also looking at making sure we're identifying youth who have been victims of abuse and neglect? And are we understanding the risks and the needs of this particular group? And one of the challenges we faced is sort of the undercounting of this group by these agencies. When we asked them for how many crossover youth there were, they were like 4. We're like 4. And we worked with the courts to look more deeply at this. And what we found was that in a snapshot of youth in 2022, there were 93 crossover youth. And those were youth who had active involvement in CFSA or DYRS or other delinquency systems. 59 youth who had active delinquency system involvement. So it's actually a fairly sizable number of youth. Oftentimes their CFSA case has been closed, but that hasn't diminished the reality that they have suffered extensive trauma, most likely because of the negative adverse childhood experiences that they've held. So identification and then really collaboration and working together. This starts basically at arrest, honestly. Many jurisdictions work to identify youth early because we know that sometimes incarceration can be particularly harmful for youth who have been in the child welfare system because of the trauma that they've exposed. So really identifying those youth, seeing if they can be diverted early. And then when they are in the system, looking at if they do end up being, say, committed to DYRS, ensuring that programming is sensitive to those needs and of those youth. And that includes such things as making sure they're getting trauma-informed care. Someone mentioned that, but also understanding the need to build up their positive childhood experiences. And that's something that I think all of these individual development plans can help do, is say, this child, what do they need? Do they need the sort of positive experiences that they lacked growing up to help them thrive as an adult?
And that second question,
Yeah.
I'm thinking
Sure.
of the question Councilmember Bonds asked earlier. In theory, if they were in CFSA's care, they should have already had some type of individualized plan or support plan. What mechanisms are in place from CFSA's side to ensure that those young people at DYRS are receiving the care and treatment that they require?
Well, unfortunately, the answer is it doesn't seem like it's very robust. Like there is some crossover youth around the handful of youth who are, involved in both at the same time. But in terms of DYRS knowing if youth have been in CFSA, there's really no mechanism for them for knowing that. One of the recommendations of the report was to have better utilization of the ombudsperson for children. They have a responsibility for oversight of the crossover youth issue, but what we found is that the agencies have not been providing the robust data on these youth that would help us understand whether the district is doing its best to help these youth move past these really negative youth experiences they had as youth, and also helping their families as well.
Really helpful. Thank you all for your testimony, and sorry about your connection issues, Ms. Jacobs.
Councilmember Pinto. Councilmember Pinto. All right, we're going to skip her for a moment. Councilmember Lewis George, if you have any questions.
Thank you. Ms. Ellison, Kristen, thank you for your testimony. You mentioned you like the bill to include a restorative justice option and process for our youth. Can you talk more about sort of how restorative justice and why it would be beneficial for both those who caused and experienced harm?
Absolutely, Councilmember. Not going into kind of too much of the broad kind of overview of what restorative justice processes look like depending on who's involved, but I think there are a variety of modalities that can benefit both people who cause harm and people who experience harm. And what we know from research is that most folks who've caused harm likely have experienced harm themselves, and there isn't people who experience harm or crime victims in one bucket and people who cause harm in another bucket, right? There's a lot of crossover. So in terms of different modalities, something like what's commonly referred to as a victim offender dialogue, where the person who's caused harm or the youth that's in the system and the person who experienced harm can hear from each other about their experiences. The person experiencing harm talking about the impact that the harm or the crime, the unlawful act had on them, both in kind of that acute experience and then long-term, the experiences that they've continued to have or the harm that they've continued to experience as a result of that crime. And then the youth who has caused the harm, being able to hear from that person to understand the impact, but also to be able to be in this process of what support do you need to not cause harm in the future, and what support does that survivor need to heal from that process. We've done at MVRDC healing circles where we hear from youth about kind of what they need. And we've done support healing circles with someone who's experienced harm and all of their support system. So I think something similar could be done for someone who's caused
Got it.
harm.
Okay.
Yeah.
That
So
makes
there's
sense.
a variety of things that can be done, but essentially the goal is to help people understand why they've caused the harm or the impact of the experience, and hopefully
Yeah.
help people move forward. Yeah.
Thank you. I appreciate that suggestion in addition to the work that's happening here. Ms. Velasquez, it's great to see you again. Thank you for your testimony, and thank you for your organization's work on the insights in the auditor report on crossover youth. One thing you said in your testimony, you supported increased oversight over DRS and spoke of the need for sort of a single oversight entity for all agencies that interact with DC's children. As you know, the bill currently proposes the auditor's office to assume the responsibilities of the Office of Independent Juvenile Justice Facilities Oversight. There have been previous discussions about DRS oversight being placed under the Ombudsman for Children, which is an independent legislative oversight body like the auditor, which is in the committee that I chair. Can you share your thoughts on whether the auditor or OFC would be the best place for DRS oversight?
Well, I would say that I don't actually feel like I can give it should be this or that. I mean, obviously, we're very, we have worked with the auditor in the past. We are really confident in her office's ability to do this type of work. I also look at the work that the Ombudsperson for Children's doing, especially around crossover youth, and having a single entity that was asking for data might also be beneficial, so that it would be all sort of unified in one place. It would be ideal to build up that office with people who have understanding of child development and positive child development, so that they are looking at these agencies and saying, for example, is CFSA doing a good job of keeping youth from crossing over? Because that's the ideal, is we want fewer youth who have been in the child welfare system to end up in the juvenile justice system. So, thinking about, and also, how are our education systems working with these kids? So I would say that we would love to have a conversation. I think, having it start in the ODCA is, they have the capacity probably to take this on sooner. But, talking about long range and involving community members in this conversation, I think is something that we would support and be happy to, offer any help we could.
Awesome. I appreciate that answer. In fiscal year 23, it looks like only 8 youth were considered dual jacketed, meaning they're simultaneously involved in CFSA and DRS. Of course, there are many more youth involved who have been involved with each agency at different points. Do you think it would be beneficial for the district to instead sort of count and develop strategies for all dual jacketed youth, which I think would include sort of youth at risk of entering both systems, youth who move from one system to the next, and youth who were involved in the juvenile justice or abuse and neglect system in Virginia or Maryland?
I would, yes. And I would also say involving court social services as well, because many youth are on probation. And what you want to do is make sure that they don't, go deeper into the system, right? So involving them in these conversations. As I think and hopefully many people here, half of the youth who are in foster care, DC youth, are in Maryland primarily, and some in Virginia. So there's also a need for interagency collaboration. We don't know how many of our foster youth are in Maryland's juvenile justice system, for example, or vice versa. So I think the more we can, look at this as a broad tent issue and think about how do we work with CFSA and DRS, especially to identify these youth, and I think that early assessment and intervention is critical. So
Thank
Thank
you.
you. Thank you,
Thank you,
Councilmember.
Chairman.
Councilmember Fruman?
Thank you, Chairman Mendelson. One of my questions was going to be your views on the single agency. So thank you, Councilmember Louis George. Saved everybody some time. A different reference that you made in your testimony was to other jurisdictions that you thought were doing this well. And that really piqued my interest, because I'm curious who's doing this well, to what are the characteristics of the way in which they're doing this? And it's broad, but my basically only question. And to what extent are there differences in the legal infrastructure in those places as compared to here? So if I can get your views.
Well, I suggest you talk with Director Abed when he speaks also, because actually Maryland did some good work around crossover youth in Prince George's County and Montgomery County. There's also been good work in Fairfield County. It really depends on the jurisdiction. Some have had a really strong court-led effort because you have judges who are like, we want to really make sure we have one judge, one family, right? So a family gets involved in CFSA, and then if a child then ends up being involved in the juvenile justice system, they have the same judge, they understand the issues. Some have really also tried to have almost like a family court or a drug court model where you have wraparound services, which is really not too different from what they're looking at for all youth in terms of this having this pre-disposition type of a hearing, but maybe even earlier. Some have really focused on the very front end, so at arrest, at the decision-making point of what type of disposition should we have for this youth? So having the prosecutor's office involved. So, we are really excited to continue conversations about this with the district. And, we had a number of recommendations that, potentially could become council-led efforts as well. So happy to discuss it moving forward.
So I don't know if you've had an opportunity to look at the testimony from the witnesses from the executive, but one of the things that they talk about is that there's a number of different things out there, and so they see redundancies. I wonder if you, when you look at the landscape of what the district is doing now, you see redundancies in this space with the proposals, or you see these proposals as really filling a gap that's not there now that needs to be addressed?
Around the Road Act generally, or? Well, I did have a chance to look at Director Abed's, and he mentioned this need to really push for even farther back this issue of assessment. I mean, we know that CSSD does an assessment at basically at intake. This seems like a good chance to maybe work together with CSSD and make sure that at a youth intake, we really understand their needs. So maybe, to speaking to crossover youth, maybe it's one of those issues where like this youth could be extreme risk if we commit them and send them to New Beginnings. We won't know that if we've already committed them, right? So, to the extent that the director, recommends pushing this even farther back than the Road Act, I mean, that seems like one opportunity. But again, it's our multi-jurisdictional system, right? Where that's the federal CSSD is doing that. So, I would be interested in the court's, thoughts about how do we better integrate what we find out at intake that can be used to build upon it. I mean, we do know that, youth, just like anyone, like how many times are you going to assess them and make them ask these questions? So if there is a way that this can be a more unified process where the families are involved and you have the results of these risks and needs early in the process, I think that would benefit youth and, potentially, to my point, keep some of them out of New Beginnings, which costs $131,000 a youth a year.
All right, well, thank you very much.
Yes.
Since Councilmember Lewis George asked my other question, I'll leave 40 seconds on the table.
Thank you for the time. Councilmember Trayon White.
Thank you, Chairman. I don't have any particular questions for this panel. I was intrigued by some of the responses and concerns I have that are consistent with some of my concerns. And for the sake of time, we just want to digress on this panel.
Thank you. Councilmember Bonds.
Thank you. Thank you very much. Ms. Fellows, thank you very much for that last statement you made about how if we could have all of this information at the beginning, we might get the products that we're trying to, that we aim for. I believe that too. And so I think that we need to have a mechanism for that. You also talked a little bit about And this I thought was pretty interesting. There seems to be a disregard of the DC code that strictly limits the use of seclusion in the confinement process. It's primarily used for those individuals who maybe have been involved in violent outbreaks, I think it was, or when there's staff shortage. And so I wondered, do you have any indication of the frequency that this occurs? And then I think it mentions specifically with the girls. No, it's not your testimony.
Yeah, I was gonna say, wow, that's really interesting, but I don't think I said that.
It's not, it's yes. Ms. Olson, it's your testimony. If you're still on.
Councilmember, was that question directed to me?
Yes, yes.
Can you
I was-
repeat it? I'm sorry.
Yes. You mentioned in your testimony the use of seclusion, and I wondered if you could expound on the frequency of your findings. You indicated it was frequently used as a way of separating maybe those who are involved in violent outbreaks, or used when there's staff shortage for the girls.
That wasn't in my testimony, Councilmember. It might have been another person's testimony.
Okay, all right. Well, I was curious about this very much so.
Josh says he thinks it's DRDC's testimony.
All right. Okay. All right, well, who's the witness for that? I thought it was, nope, okay. I'm very curious about that, and I'm curious about it because if that is occurring, and of course, you know, that's a violation of our law, I wondered if we have some solutions that we can use that would replace that, because it sounds like when it's a law that it is something that's very harmful to the young people. So I'm just wondering about that. So that was the nature of my question. I don't have any other questions, Chairman. Thank you very much, and thank you for understanding that I may be confused with all the pieces of paper I have here. Thank you. And the witnesses.
Thank you, Councilmember Bonds. That's going to conclude the questions that we have. So I want to thank everyone who's online, and thank you especially for being in person. And you all are excused. We're going to turn to the government witnesses. We have 5, and I'm going to handle them this way. I'm going to ask Kathy Patterson and Katerina Semyonova to come forward. Ms. Patterson is DC Auditor, Office of the District of Columbia Auditor, and Ms. Semyonova, and I'm sorry, I'm mispronouncing that, is Special Counsel to the Director for Policy and Legislation at the Public Defender Service for the District of Columbia. They both online. Why am I struggling with your last name? Semyonova. Semyonova. I apologize in advance.
They're
Have a
gonna
seat,
have a hard time.
please. All right, so you brought reinforcements. And Councilor, or excuse me, DC Auditor Patterson is
Thank you,
participating.
Mr. Chairman. That old title is still a fun one. Thank you. Good afternoon, Mr. Chairman and council members. I'm Kathy Patterson. I'm the auditor of the District of Columbia, and I appreciate having a chance to testify today on certain provisions of Bill 25826, the Recidivism Reduction Oversight and Accountability for DYRS Act of 2024. As has been stated, the legislation would amend Title 16 of the DC Code to reform supervision and intervention at DYRS. It would also establish a permanent position of Deputy Auditor for Independent Juvenile Justice Facilities Oversight in the Office of the DC Auditor. My testimony today reflects my role as the director of that small independent agency housed within the legislative branch of DC government, and also draws on my experience as a 3-term elected member of this legislature. The bill would create the new position of Deputy Auditor, would define the required experience a candidate must have, require reports on any complaints received concerning DYRS, requires auditors to monitor the individual rehabilitation plans required by DRS, and now, quoting directly, assess the department's policies, procedures, programs, and practices. The Home Rule Charter makes very clear that the Council of the District of Columbia has ample authority to enact these provisions. DC Code states specifically under powers of the Council shall have authority to create, abolish, or organize any office, agency, department, or instrumentality of the government of the district, and to define the powers, duties, and responsibilities of any such office, agency, department, or instrumentality. If the council is going to task the Office of the DC Auditor with any additional responsibilities, and clearly it's your prerogative to do so, I ask, please legislate only the what, and please do not legislate the how. And if and when you legislate the what, please do not legislate new responsibilities that conflict with our Home Rule Charter mandate or assign to us responsibilities that should reside elsewhere. And what do I mean by what versus how? If the council, for example, wanted to give the Attorney General any new responsibility with regard to an issue, my guess is that you would leave it to the AG duly elected to determine how to approach that issue. And I simply ask to defer to the DC Auditor, whom you appointed, in a like fashion with any newly mandated responsibilities. One stated purpose in the legislation is to require ODCA to assume the responsibilities of the current Office of Independent Juvenile Justice Facilities Oversight pursuant to the Jerry M. case. And as you know, Mr. Chairman, the council approved a provision in the FY25 Budget Support Act of 2024 that houses this office at ODCA throughout the new fiscal year. It also requires the director to issue a report with recommendations for where and how the ongoing responsibilities of that office should be fulfilled going forward. I recommend that the council delay consideration of this portion of the legislation until you have received that report from the Juvenile Facilities Oversight Director that you requested in legislation just 2 months ago. That legislation was developed, that language was developed with representatives of the council and the staff of the Office of the Attorney General, as well as Mark Jordan, the current director. I certainly don't presume to speak for Mr. Jordan, but based on discussions earlier this year, I believe such a report could consider options such as these. 1, transferring data collection and reporting functions to the Criminal Justice Coordinating Council, which already has that as a major part of CJCC's current mandate, and adding information on DYRS facilities, population, critical incident and assault rates, staffing, health and safety, and other issues would be consistent with the CJCC's ongoing mission. 2nd, transferring or consolidating the important unannounced visits and ongoing monitoring to another entity, could possibly include the Corrections Information Council, which is currently mandated to monitor conditions at U.S. Bureau of Prisons facilities. There could even be a recommendation to create a council office of oversight with the explicit role of continuing oversight that's deemed necessary when parts of our government exit from oversight by the judicial system or other parts of the federal government. If the council chooses to move forward without benefit of that report due in April, and if it is the intent of the council to have my office assume the responsibilities of the Independent Oversight Office, I recommend short, simple language in the place of the 5 pages in the bill as introduced, to say simply that the Office of the DC Auditor shall for the next 3 years regularly monitor and publicly report on the durability of the reforms in the conditions of confinement that the Department of Youth Rehabilitation Services achieved under the Jerry M. V. District of Columbia Work Plan and Consent Decree, and the department's progress in achieving work plan goals that the department had not achieved prior to January 6, 2021. That language could continue the good work the office has been providing, would leave the how of that to my discretion, and would be time limited, with the assumption that DYRS, the administration's leadership, and effective oversight by this council would ensure continued compliance with the terms of the Jerry M. settlement. The end of the Jerry M. case and any other receivership brings with it questions of what happens next and where does responsibility reside for any ongoing monitoring. There's precedent for different kinds of follow-up when receiverships or consent decrees end, and it seems appropriate that the council may want to at least consider formalizing what have been different approaches. For example, when the council enacted the District of Columbia Jail Improvement Amendment Act of 2003, it came after the federal court ended its oversight of conditions of confinement at the Central Detention Facility. There had long been a court monitor conducting regular visits to the DC jail to look at health and environmental conditions. That 2003 legislation required DC Health to conduct 3 inspections a year to essentially replicate the kind of oversight that had been done at the court's behest. ODCA reported on this executive branch oversight in a 2019 report on conditions of the jail. We noted that DC Health was using standards developed by the American Public Health Association and the American Correctional Association. We reported that DC Health examined 39 APHA standards and 24 ACA standards. And in March 2018, we reported DC Health found that the Department of Corrections was out of compliance with 7 of 24 ACA standards and 6 of 39 APHA standards. And I mention this because it's a very specific example of oversight that can be mandated, that can occur, and that can go forward. That requirement remains in force, and the information is supposed to be made available to the council and the public. It's my understanding that inspections were conducted in 2022 and 2023, and those reports were submitted by DC Health to the Executive Office of the Mayor in June. I did inquire last week, and they still had not been submitted to the council. So my point is that the statutory requirement remains, and DC Health at least is complying. And there are many other kinds of post-receivership oversight. The Evans case, which went on for some 40 years, had for almost half of that time a requirement by the court that before exiting, the district needed to prove that it would have evidence-proven oversight looking at these issues once the court case ended, and it did not end until there was that assurance. One of the things that occurred in 2001 was a consent decree creating the DC Quality Trust, which was funded by the DC government for a time, and another step taken was creating the Developmental Disabilities Fatality Review Committee, housed at the Office of the Chief Medical Examiner. It's my understanding that the Ombudsperson for Children office was created at least in part to keep track of the commitments made in the LaShawn case. And there have been other examples. My own office has done monitoring reports looking at some of these kinds of issues, including what has happened with the use of force commitments made by the police department following 8 years of partnership with the Department of Justice. And we also did a report on the reforms at the Fire and Emergency Medical Services Department that arose from litigation that came from the death of David Rosenbaum. The Rosenbaum Task Force made those recommendations. And I cite these as examples of kinds of monitoring that can take place. In closing, I want to just note some of the comments that have been made by the witnesses thus far. There were comments made calling for rigorous independent oversight, for a single oversight agency, for a permanent independent oversight body, for a single oversight body for everything over DYRS. And I would just submit that the principal responsibility for oversight of government operations, including ensuring that reforms stick after the end of court receiverships, reside with this council, with the Council of the District of Columbia. And I would associate myself with comments Councilmember Pinto made that isn't oversight our job, and I would agree with that comment that she made. And in closing, my office does stand ready to implement and to respond to any council action that requires us to undertake additional responsibilities. And we will continue to provide the public and the council with audits and other studies designed to provide constructive support to legislative oversight. And I would be happy to respond to any questions on the legislation as it pertains to my office. Thank you.
Thank you, Ms. Patterson. Ms. Simonova?
Thank you. Good afternoon. I'm Katerina Semyonova, Special Counsel for Policy and Legislation at the Public Defender Service. With me today are Hannah McElhenney and Brittany Mobley. Ms. McElhenney is Deputy Chief for PDS's Trial Division in charge of the juvenile section and has spent more than 2 decades representing youth and supervising their representation in the district's juvenile court. Ms. Mobley is Deputy Chief of the Community Defender Division and leads PDS's Juvenile Services Program. JSP has provided legal assistance to youth since 1982 by staffing legal rights offices in the district's youth detention facilities. Decades ago, the council directed PDS to create JSP to address the horrific abuse that children faced in detention. JSP's continued access to DYRS facilities and its role in serving incarcerated youth gives JSP unique insight into the experiences and needs of youth. PDS strongly supports the ROAD Act and the intent it embodies to oversee the actions of DYRS and to refocus that agency on its core mission of rehabilitating youth. The ROAD Act does not impose new obligations on DYRS with respect to rehabilitating youth. Rather, it meets the needs of the moment by making DYRS's existing obligations more transparent, specific, and enforceable. The current situation for youth who are committed to DYRS is dire and demands legislative action. DYRS's failure is particularly acute at the Youth Services Center, where children are languishing in detention. DYRS places 3 legal categories of youth at YSC. 1, youth who are pre-trial and awaiting disposition in their juvenile cases. 2, youth who have been adjudicated as delinquent, have then been committed to DYRS by the court and are awaiting placement by DYRS into an appropriate rehabilitative program. And 3rd, youth charged as adults under Title 16. DYRS treats all of these youth as short-term residents and justifies the lack of services at YSC by repeatedly claiming that YSC is a detention facility, thereby implying that a DYRS detention facility either cannot or need not achieve the mission of rehabilitating youth. Over the last 15 months, the number of youth in the awaiting placement category at YSC has fluctuated, reaching 43 in February 2024 and is now at 28 youth. Youth who are awaiting placement routinely wait 6 months for DYRS to place them in an appropriate rehabilitative setting. Some have waited nearly a year. Under this DYRS administration, youth at YSC, including those who are awaiting placement, despite their readily apparent psychiatric needs, have no access to confidential and ongoing therapy or trauma-related care. Youth do little beyond attending school at the Maya Angelou Public Charter Schools program within YSC. While PDS has heard that a new programming unit will be established at some point in the future for awaiting placement youth, youth currently have no meaningful or regular rehabilitative programming. YSC has also been perpetually and dangerously understaffed by DYRS. This understaffing, along with the lack of programming, has led to fights between frustrated youth. DYRS has used room confinement or confinement on housing units to address the agency's understaffing, again fueling more despair and frustration for youth. While at YSC, many youth, particularly girls, end up on suicide prevention status and cycle in and out of the Psychiatric Institute of Washington. It's important to note that the current reality, which the ROAD Act addresses, was not always the case. Youth at YSC had a variety of available programs, and DYRS case management was typically more effective in expeditiously moving youth into programs. This was possible because the court process gives DYRS ample notice and time to plan for placing youth. Court-involved youth are supervised by the Court Social Services Division of Superior Court unless and until the youth is committed at a disposition hearing. Commitment transfers the responsibility for care and supervision to DYRS. To prevent delays and gaps in this service, a process was created to notify DYRS that a youth was likely to be committed. This notification triggers DYRS's obligation to meet, evaluate, and prepare a plan for the youth. The process begins with Court Social Services, or OAG, filing a notice of intent to commit prior to the youth's disposition hearing, which is akin to a sentencing. At the time that youth have their disposition hearing, as a result of the notice of intent to commit, all agencies involved, including DYRS, have known weeks in advance that the youth may be committed. During this time period between the notice and the actual disposition hearing, DYRS should be preparing for the youth's commitment by employing experts to determine the appropriate rehabilitative care for the youth, ordering assessments, and completing the youth level of service and case plan, the YLS, finding a place in an appropriate program, and planning for the youth's transfer. Nearly always, youth who are facing commitment are already detained at YSC. Therefore, DYRS case management has complete access to most of the children for whom a notice of intent to commit has been filed. Despite the sufficient notice, DYRS's pre-commitment process is now failing. DYRS is not assigning pre-commitment workers to youth after receiving notice of intent to commit. Young people at YSC describe waiting weeks to even meet with a DYRS pre-commitment worker. One DYRS caseworker told a young person that it would be 2 months before they would be able to give them any answers about a potential placement because they had not yet started the YLS. Rather than having pre-commitment workers engage experts for psychological and psychiatric examinations, DYRS too often waits for the court-based child guidance clinic to complete its own evaluations. DYRS's reliance on the child guidance clinic, which focuses on court evaluations and community treatment, causes extensive delays in obtaining reports related to commitment planning. Youth who have had the necessary psychological and psychiatric evaluations still wait for DYRS to complete the separate risk assessments in the YLS that are required for program placement. Further, while youth wait, frustration builds, and with a lack of programming, youth are more likely to become involved in fights and have disciplinary infractions. This in turn makes youth harder to place in rehabilitative program and leads to rejection from programs and feeds a cycle where youth remain at YSC without services and predictably decompensate. The ROAD Act is a necessary and positive step that will break this cycle of inaction by DYRS. The ROAD Act requires DYRS to complete a validated risk and needs assessment within 72 hours of receiving notice of intent to commit for detained youth and within 5 days for youth who are in the community. The ROAD Act also requires DYRS to develop an individualized rehabilitation plan for each child, to inform parents, attorneys, and relevant agencies of a predisposition meeting, and then convene the predisposition meeting no later than 2 days before a detained child appears in court for disposition. The ROAD Act also sets reasonable timelines and clear standards for DYRS by defining terms such as validated risk needs assessment and individualized rehabilitation plan. It also guarantees that children, their parents, and lawyers will have the right to participate in these meetings. The ROAD Act also takes the rational and positive step of requiring DYRS to conduct assessments for committed children, regardless of whether they are in the community or in a non-community placement, at least every 90 days to determine whether the child is making rehabilitative progress, whether the services provided have been effective, and whether additional steps should be taken, and whether an individualized rehabilitation plan needs to be updated. DYRS currently uses a success plan to monitor the progress of youth. PDS has reviewed success plans that are only 1 page long and have no child-specific goals, contain platitudes applicable to all teens, and that only specify school-related goals as a metric of progress. Rather than relying on vague standards, the ROAD Act specifies the actions that DYRS must take. This is, again, a rational, achievable, and obvious part of DYRS's mission of rehabilitation. As of August 30th, 2024, there were 181 committed youth who were committed to DYRS. The total committed population is small and allows for in-depth case management. The ROAD Act also creates more accountability for DYRS by allowing a child, child's lawyer, and parent to petition the court once every 4 months to modify their dispositional order on the grounds that the child is not receiving the appropriate level of services. Under DC Code 162323, such petitions to the court are allowed every 6 months. This is too long for children to wait, and it allows the time of their commitment during which they should be receiving services to be squandered. The 4 months proposed in the ROAD Act is also too long. PDS recommends that youth be allowed to petition the court for review every 3 months, thereby aligning with treatment programs that function in 3-month cycles and serving as an appropriate check for youth who are awaiting placement. Finally, the ROAD Act makes permanent the Office of Independent Juvenile Justice Facilities Oversight and places that office within the Office of the District of Columbia Auditor. It is critical that the district maintain oversight over the health, safety, and rehabilitation of children in detention facilities. The district has a long history of placing court-involved youth in deplorable conditions where they are subjected to violence and are at grave risk of harm. Detained children can be as young as 12 years old and typically have complex needs. The OIJJFO has been essential in protecting these children. For instance, in 2024, OIJJFO raised alarms that understaffing at DYRS facilities remained a chronic problem and that appropriate staffing levels are essential for safety. In July 2024, OIJJFO reported that despite placing 72% of youth at New Beginnings on one or more psychotropic medication, DYRS failed to strictly adhere to its own policies regarding monitoring for potentially serious side effects. In the 3 years since the conclusion of the Jerry M. Consent Decree, the 3 years since the conclusion of the JRM consent decree have shown that real access inspections and robust oversight that can only be provided through a well-funded independent entity are necessary to protect the lives of district youth. Thank you for the opportunity to testify, and we welcome your questions.
Thank you. So we'll have a 10-minute round, and I have to reserve some time. I want to ask Councilmember DC Auditor Patterson some questions, but I'm going to start with the Public Defender Service. And where do I want to start with you all? You support the bill, and you go through some of the requirements requiring DYRS to complete a validated risk and needs assessment within 72 hours, et cetera. Road Act also takes positive step requiring DYRS to conduct assessments. I have in my mind that DYRS could say, well, this will be burdensome. Are these requirements what they have performed in the past?
So DYRS does perform has always, in my experience, performed some sort of risk needs tool. Most recently, in the last couple of years, the efficacy in which that's done has really gone down. As previous
Yeah,
witnesses.
but that's not quite what I'm asking.
Yes, no. My apologies.
So I forget the date when Ms. Cairns left, but there was testimony earlier that that's when things started to deteriorate.
Yes.
So before that point, were they doing these risk assessments within 72 hours?
Maybe not exactly linked into to that 72-hour timeframe, but as was testified previously, it was very often done prior to even disposition happening. Once a notice of intent to commit was filed, they had a different tool at that time. The SDM tool was something that was utilized at that time.
Sure, I'm not asking about the
Yes,
tool.
but I'm
just-
saying, and that is something that was a quicker tool that could have been done within 72 hours, but it was done prior to, more often than not, it was done prior to the disposition hearing.
Requiring DRIS to develop an individualized rehabilitation plan for a child, was that something that used to be done?
Yes, the answer to that is yes. DYRS used to be better at anticipating the kids who are coming to them. And the things that are in this Road Act are things that used to happen much faster.
Well, that's
sometimes
what
with
I'm
different
getting
names.
at. The things that are in the Road Act used to happen.
Yes, sir.
So that's not new.
Correct.
Maybe not precisely the same, but essentially the same.
Yes, different names, same idea.
So because, sometimes what we, the council, get is through the fiscal impact process that this bill is going to cost $100 million because these are new requirements that we're going to require them to hire 350 people. And if they've done it before, then that works against that argument.
Yes, there is a process laid out already where if DYRS attended and participated, lots of this would be happening naturally and wouldn't be occurring after the child got committed. It would be more efficient and less expensive to do it the way it used to be done.
What about, let me see, there's a recommendation regarding petitioning the court. Well, not every 4 months, but every 3 months. Let me see, right now the law says every 6 months. Would that add a cost to the agency?
Not if they were doing their job, is the short answer. That petition only happens when the child or their counsel feels like the child has been abandoned and is languishing. If that's not happening, we won't have any of those hearings.
All right, let me see, in this testimony, the Road Act makes permanent the Office of Independent Juvenile Justice Facilities Oversight. I'm not going to begin to repeat those initials. But the auditor, with regard to creating the independent function in her office, said we should wait for the report that the council requested when in the budget, we put this office back in existence in the auditor's office. So you're recommending making that Office of Independent Juvenile Justice Facilities Oversight permanent now. Why not wait?
It can be made permanent later. It can be made permanent now. Our position is that there needs to be robust oversight that has expertise, and that expertise it has really been developed by that office, and that it's essential that it remain in place. If it's made permanent later on, that achieves the same result, but there shouldn't be a lapse in the authority and the action of that office.
Sure. And I think the council, there was not hesitation in the council when we did what we did. But the question is whether we put it in this bill, when we mark up this bill, or whether we take it out of the bill with the expectation that we wait for the report that we get next spring when we have the budget and do it then.
I don't think we have a position on that. If that changes, we can add that to the written testimony, but our overwhelming position is that
has
it
to be
remain in
independent.
effect. And the vehicle through which that is done.
Sure. In your testimony, you made clear there are 3 categories of youth at YSC. The first category are youth who are pretrial and awaiting disposition in their juvenile court cases. Are those youth there longer than they should be? That may not be a good question.
I think it's a good question. I understand what you're asking. Children who have been who have already been found involved, they've pled or lost their trials, and they've already been identified as heading toward commitment, are at YSC longer than they should be.
Yes,
Because
but
the
that was the
commitment,
second category, youth who've been adjudicated. And then-
sorry, I'm so sorry. I didn't mean to interrupt you. The second category is kids who are already committed and are waiting for placement, I think. And our concern.
Sure, but the first category I'm reading here is youth who are pretrial and awaiting disposition. So they haven't been adjudicated.
I think the pretrial part of that is an error in the testimony. It's the kids who are predisposition who are waiting. If you're pretrial, I don't think any of us are saying that DYRS has a role in the pretrial case. Those kids.
I know, but I'm asking, so it sounds like they're actually sort of like 4 categories then. Pretrial and pre-adjudication. That's sort of the same as pretrial. But what I'm getting at is there, I got it that for those who've been adjudicated as delinquent and committed, that there are these huge delays. I get that. I'm asking about before that. Are there delays that could be shortened?
Yes, in between a finding of involvement, you're guilty, and your sentencing, there are really long delays that don't need to occur.
And whose fault is that, so to speak? Is that the
Probably
prosecutor?
everybody who's involved in the case at some level, but what we're talking about today and what we've identified is the kids who are going to be committed. We will show up for our first disposition hearing and no one is ready because that meeting between Court Social Services and DYRS has not happened. DYRS has not done the YLS. The evaluations are not finished. DYRS doesn't have a placement. So the judge will say, all right, we'll come back in 3 weeks. I want all of this to be done. And we'll come back in 3 more weeks. And DYRS will say, well, now we have the evaluations, but we have not yet had the meeting and we still haven't done the YLS.
And this
so-
is a category separate from the youth awaiting placement.
Correct. They're not even, those children aren't even counted in the numbers of kids awaiting placement because they haven't yet been committed and DYRS DYRS takes the position that they have no legal responsibility for those kids at
But
that
there's
stage.
still delays caused by DYRS for that group.
Correct.
Okay.
The confusion.
I'm running out of time here.
And I'm sorry, it should be 4 categories. So it's the youth who are purely pretrial, who have not been found involved and who have not entered a plea in the case. And then there are the youth who have been found involved and who are awaiting disposition, and those who have gone to disposition and who have been committed that are awaiting placement. And then the Title 16 youth court.
And these youth risk assessments and some of the other work that DYRS needs to do is delaying the categories 2 and 3.
Correct.
One more question for you, and then I have some questions for the auditor. YSC has also been perpetually and dangerously understaffed by DYRS. That's your testimony. Is that because the budget's inadequate or because there are vacancies?
I mean, DYRS's testimony in the past has been that it is because of vacancies. So it is, I don't know that they have testified that it is an inadequate budgeting issue. I don't know if Ms. Mobley has more to add on that.
I don't have specifically anything to add, but I will note is that there has been a lot of staff turnover, specifically at the facilities as well. So, you know, folks come, they go. There have been concerns about the quality of staff that's been hiring, the training that's provided. Some folks are hired in and then are quickly, they may not make it past the training or oversight, initial oversight monitoring period. I think it's complex.
All right, I have to ask some questions about the auditor, but I'm going to turn to colleagues, and then I'm going to come back to ask the auditor questions. Councilmember Parker.
Thank you, Mr. Chairman. I will start with the auditor. It is great to see you, albeit virtually. I will start here. It was quite the indictment, I will say, Auditor, where you said, at this moment, the council does not devote the portion of time and resources to oversight that it had done in the past when some council members and their staff conducted site visits to see for themselves the secure facilities where juveniles are held. I take that to mean, well, I'm asking you what you mean by that, and I'll be more precise. Do you have any objection to the Office of Independent Juvenile Justice Facilities Oversight being placed under the purview of your office? Because I was reading that and wondering if the implication there was, well, you all council should be doing this. You don't need this office. Am I interpreting that the right way?
I think what I take from a lot of the witnesses who've spoken already today is they're looking for more robust oversight, full stop. And I think the council has a major, the most important role to play there. That is the role of the committees on the council that have oversight for each individual agency, which you know, congratulations that you now have that oversight for DYRS within the committee of the whole. I don't have an objection to being given the assignment of having the independent office housed at ODCA. That was something that we developed and recommended to the council for this coming year. If the council in its wisdom wants to have that be a function that resides in my office in perpetuity, obviously we would do that. You're the policymakers and we will comply with that. But I think it's important to understand we don't have subject matter expertise per se. Our auditors and analysts develop that expertise when they take on an audit, but we don't have juvenile justice experts or housing experts, or we don't hire in that fashion. We hire people with the skills to do the audits. So if we continue with to continue what Ms. Semenova referred to as the robust oversight with expertise that's been developed, it would be my hope that we would persuade Mr. Jordan to continue in that role if that were to continue.
Understood. And I agree with you that the council's responsibility is to conduct robust oversight. I don't necessarily see those two things in conflict, having this office and the council conducting oversight, but I thank you for that clarification. I also take to heart your recommendation to wait for the report that we've already tasked this office to produce, which gets at the how. How might it be under the purview of the auditor's office? And I hope that the chairman and the committee of the whole will take that under consideration as we move forward. I wanted to switch gears to our friends here in the chamber. I wanted to come back to something the chairman was just discussing. So these 4 categories at YSC: pretrial, awaiting disposition, adjudicated, and awaiting placement, and those charged as adults. That awaiting disposition, I think, is the category the chairman was getting at. Do we have a sense, estimate, how many young people are in that category today?
I don't have the breakdown of that number. What I do know is right now there are 50 young people at YSC who are considered secure detained, which is they are held at YSC by some form of court order. So the breakdown within that 50 as to how many are pretrial versus awaiting disposition, I don't have that. I can fairly easily figure out that number and circle back with you.
I will say, it strikes me as odd that it seems DYRS can just indefinitely hold a young person until they place them. Is that legal?
So once young people are committed, the court turns over significant jurisdiction to DYRS.
But it sounds like even before they're committed, DYRS can drag out this process and say, yeah, we're supposed to do the evaluation, but that may take a month. We're supposed to have this meeting that may take another month. And if a child or a young person was committed for, let's say, 6 months, that can easily turn into 9 or 10 months, it sounds like.
Yes, and I will say, to be just frank, I think it is often this kind of back and forth with Court Social Services and DYRS as to who's going to take responsibility of scheduling the meeting, showing up for the meeting, having the meeting, preparing what's necessary subsequent to the meeting to attend disposition and provide sufficient information for the court to make a determination as to what will occur at disposition.
Got it. But I'm trying to get an understanding. Is it the Public Defender Services position that this indefinite holding of young people before placement and or before required assessments is legal?
May I jump in on that?
Yeah.
The short answer is no. There are statutory time and rule-based timelines for when we should be going to sentencing in cases. The reality is that it's complex in the cases you're talking about where DYRS is not ready. Because we can, as advocates, try to force the case toward disposition and ask the judge to impose a sentence. But if the judge does that and commits the child, then we find that children then wait in avoiding placement status even longer than they would have when they were still responsive to the court schedule.
I got you.
So I need to know where my client is going before the disposition hearing happens, or there's no sort of deadline of a court hearing coming up that will make DYRS act and do the things they're supposed to do. So if you went to the disposition hearings, sometimes it's the parties who are asking for a continuance because we need DYRS to get their packet ready and to know whether the child's accepted to a residential or not, or is eligible for community placement or not, before the sentencing actually happens. Otherwise, the delay is just much longer.
And it is my understanding this legislation would say if a young person is awaiting placement or at YSC and they are not receiving services for 30 days, that would be an allowance for them to be released.
No, so I do think I don't think that's what the Road Act says. I think what the 30-day time frame, and I think maybe what you're referring to is what was in Director Abed's testimony. My reading and understanding of the Road Act is if a young person, after this individual rehabilitation plan is created, the young person is gone to disposition and they are strictly committed to DYRS for a period of 30 days. At 30 days, at that 30-day timeframe, DYRS has a responsibility to implement what is in that plan. So what typically would happen, I imagine.
And what happens if they don't?
So at that point in time, I think their counsel could petition the court to say that they are not doing what they are supposed to do.
And therefore, I read that as this is an allowance for the young person to move beyond a secured placement. And I'm not necessarily saying that's good or bad. I guess what I'm getting at next is if we know there is an employment issue or staffing issue at YSC, I'm not saying we shouldn't do these things. What I'm getting at is what is the realistic expectation that it will happen? So yes, let's say we pass it, we fund it, we say this needs to happen in 72 hours, you need to have a plan. Young people need to have these services. I'm there, I'm with you. How do we ensure that a year from now, we're not at another hearing saying they're not doing any of these things?
That's a great question. Right now, DYRS has pretty much unparalleled discretion in terms of the placement and treatment of kids compared to other agencies like Court Social Services and CFSA. Judges are not involved. Once they commit the child, the judge doesn't get to say, you should be at a residential, you should be in a foster care, you should be at home with your grandmother. They also don't get to say you should get grief counseling services or mentoring. When DYRS is not providing appropriate care and rehabilitation, and we get to go back into court, it's not that we don't ask for release. That's what our clients want to hear. That's what we're doing. But that's not, judges have already decided that this child is the deepest end and has the highest needs. That's not what we ever get as a result of going into court. What we get is judicial involvement in the case where they say, this kid does need to go to a residential program. That's what has to happen next. Or this child has to move into the New Beginnings program at DYRS. The judge gets to start having a little bit of say inside DYRS's sphere of autonomy if DYRS is taking no action and not exercising that autonomy in a productive way. So that's what happens next. I suspect that if there was a lot more judicial involvement in cases, DYRS would be much more motivated to do it themselves effectively and earlier in the case.
Okay.
And if I just may add also, this part of the statute also allows for DYRS, if there are very specific things that can be identified as to why services haven't been able to be provided in that 30-day timeframe, DYRS can note to the court, good cause shown, that extends that timeframe. So this isn't a blanket. That's why I think this particular portion of the Road Act is very, very beneficial. It understands these unique.
Got you. I'm running out of time. I do want to honor the clock. One last question. You mentioned DYRS often waits on court guidance in order to complete the YLS CMI assessment. What is it that they're getting from court guidance that they would argue we need to wait for?
I think they're waiting for the unit of the court called the Child Guidance Clinic to perform psychological
I see.
evaluations or to make the
I see.
referrals. So they want those mental health assessments before they do the YLS, which would be lovely, but not necessary.
Thank you all for your testimony.
You know, there was one thing you said in answering Councilmember Parker, that you might want delay until DYRS has got their packet together to tell the court so that you know what the placement may be. That was yes.
Yes.
Okay, but then the statistics of these kids waiting is they've been adjudicated as delinquent, have been committed to DYRS, but are awaiting placement. So that seems to contradict.
Then I'm not being clear. I apologize. The Road Act mostly just describes what should be happening anyway. So when a child gets committed, DYRS should be doing this risk needs assessment, the YLS.
Yes.
They should be looking at the child's history and materials. They should be figuring out what level of placement, secure, medium, or low, and what services need to be in place. That's all what should be happening anyway. When I have a child who's predisposition and I know he's going to be committed, if I don't see those answers from DYRS, if they haven't done any work on the case at all, and the child gets committed, he is going to wait at YSC for months and months and months because DYRS is no longer accountable to the court's calendar. If we keep having hearings every 4 weeks for the judge to say to DYRS, what have you done since the last time we were here? I find that makes DYRS move a little bit faster because someone is checking up on their work.
I understand, but so then the figure of over the last 15 months, the number of youth in the awaiting placement category reaching 43, now at 26. So who are they? Are they the folks that
That are still waiting for placements? in the
you're
awaiting
still
placement?
waiting for the packet, or you're?
The kids who are still in awaiting placement, and Ms. Mobley may have better ideas than I do, those might be kids who are still waiting. Packets have been sent out and they aren't getting acceptances and they're just really hard to place. Girls are really hard to place, for example. Those kids could be still awaiting placement. It could be kids for whom the YLS hasn't been completed and they're just sitting waiting for a worker to be available to come to the
Are
YLS.
any of them kids that you're representing
In the awaiting
where-
placement? Yes.
of those 26?
Yes, judges don't always do what we ask them to do. So sometimes we ask to continue a disposition hearing and the judge doesn't and goes to disposition. Sometimes DYRS has come in with their whole packet, the child gets committed and then they still wait, even though the answer about what they would do if they got the committed child is ready. So we do represent some kids who are still in awaiting placement status.
I jumped in. You look like you wanted to add. Microphone.
Might be a lack of clarity and maybe I'm not helping, but I believe that the youth who are pending disposition, who have not yet been committed, that those are not counted in the 28 youth who are there now and in the 43 who were identified as awaiting placement. That the bucket of awaiting placement, that category is only applied to children who have gone to disposition where the court has ordered disposition and the court has said you are committed to DYRS. And so they are awaiting placement. But everybody else who has had their disposition hearing delayed, where they've had an adjudication, but they've had their hearing delayed because DYRS is not ready, those youth are not even counted in those awaiting placement numbers. Which was, I thought, the question that you were getting
So
at.
it says to me the number's higher.
Yes, if you were to include those predisposition, waiting for DYRS to commit the complete the packet and assessments, all of that. If you consider that as a larger bucket of awaiting placement, yes.
Have to.
I'm kind of cheating here because that was not mine.
You are indeed cheating. Just
But I am
to
the
be clear.
chair of the committee that's marking up this bill. So Councilmember
I'll
Pinto
remember
was
that.
next. Councilmember Pinto, are you here? Looks like she dropped off. Councilmember Louis George.
Thank you, Chairman. Madam Auditor, I wanted to come to you first. First of all, thank you all on your team and the Council for Court Excellence for your thorough and revealing report on crossover youth. I'm gonna have to ask a question about that later. I want to get to, because I am still, I guess, trying to get to where we are or what we are suggesting regarding the oversight body. So I think you mentioned at the end of your testimony, the council is this government's oversight body. So a single independent oversight body over DYRS is not necessary. I want to quickly actually talk about the Ombudsman for Children, OFC. OFC was created largely because the council was unable to conduct the robust level of oversight over CFSA that is required for an agency that has the ability to take children away from their parents. The council was unable to do so because district privacy laws prevent the executive from sharing the personal information and case details of youth and families involved in the child welfare system. So for the last 2 years, OFC has been able to conduct a level of oversight over CFSA in terms of both quality and quantity that the council has never been able to, because it is statutorily authorized to access person-specific information that the council cannot. So I guess my question then, based on that, do you think oversight over DYRS could be improved if Ombudsman for Children, a statutorily sort of designed independent legislative oversight body, assumed oversight responsibility over DYRS, which is perhaps the only agency with more power over children than CFSA?
I think I would take exception with the premise. And I'm not quite sure what the thinking was in believing that the council did not have access to personal information because of privacy laws. In the 12 years I served on the council, there was no information that I didn't have access to. And if the council can legislatively authorize the ombudsperson for children to receive certain documents, the council could certainly, if it was deemed it didn't have the authority today, give itself that authority. So I don't understand why it is that you believe the council was unable to conduct oversight that the ombudsman is able to. I'm just not sure. I mean, I appreciate the fact that you're an attorney, so you should know this probably better than I, but I never had that prohibition as a council member, so I'm not quite sure why or where was that from general counsel. I'm not sure where that came from.
Yeah, I mean, it's sort of, I guess, I wouldn't say general counsel, but CFSA does not share sort of personal information with us.
But they are legally bound to share information you ask them for, up to and including your ability to subpoena any information. You are bound by the same privacy laws that they are bound by. You can't take that personal information and give it to the man in the street, but you have the legal authority to receive it, to be aware of it, to look at it. I mean, one of the first things I did when I took over the Judiciary Committee as a council member was to read all the Child Fatality Review Committee reports that had been done the previous year, because that was an incredible education. And that there's no more private information in the district government than those reports. So
I guess that's never the position of the agency. Well, it's not the position of CFSA, it's not the position of the executive, and I hear them on that position as sort of what privacy information. CFSA will only give sort of CFSA person-specific information unless the person specifically authorizes CFSA to share that with the committee. The issue is that the child has the ability to say who their information goes to. because they have privacy laws. They have confidentiality. Parents have to sign waivers allowing us to give this information. So there's just barriers within privacy laws regarding, especially as it relates to children specifically.
And then that's something that you can change.
Perhaps I agree. I mean, we could change it. I would say we could change it, but if a family, if a child and their parents feel more comfortable giving it to an independent body versus giving it to a council member's office and their lay staff, I would agree with that family. Even if it were just me, I would rather give it to an independent body than give it to a staff member.
Well, I mean, you're the policymaker and you can make the determination that you hand that authority to the parent. I mean, I might disagree with that if I were a policymaker. I am not, but you are. So I appreciate that point.
And then in your testimony, you mentioned concerns about the council legislating the how of your office observing the Office of Independent Juvenile Justice Facilities oversight. Do you think the auditor assuming strong enforcement powers in this case over DYRS would violate your office's mandate under the Home Rule Act?
I don't think it would violate the mandate under the Home Rule Act. It could jeopardize the independence of the audit as defined by the Government Accountability Office when we're doing audits according to generally accepted government auditing standards. If we have a role that could be deemed to be administering an agency or assisting with the administration of an agency, we can't then audit that agency because of independence issues. And that has to do with some of the sort of professional rules and guidance that we receive.
Got it.
So that, I mean, that could be one not prohibition, but one inhibition. In terms of wanting discretion, if in fact it was determined that the council was going to have the Office of the DC Auditor inspect the individual case plans of young people within DYRS, which is part of the Road Act, we don't have that expertise in-house. I would contract for that. So that's the kind of discretion that I mean when we're given additional assignments. I want to be able to figure out the best way to do that.
Understood. That's reasonable. Are you aware of any improvements for how CFSA and DYRS are managing crossover youth cases since your office's crossover report was released?
No, I'm not. I would go to CC, to Council for Court Excellence, for that information.
Okay, thank you. I want to, my last minutes, come to the Public Defender Service. While I have you, since provisions of Secure DC have gone into effect, what have you all seen as far as representing young people? Are there any trends that you all have seen regarding the young people you serve? Have there been any patterns that you've recognized?
I don't think we have a trend to identify in terms of the legislation, how Secure DC impacted pretrial detention for youth, because that was principally where Secure DC legislated in the youth space.
Okay. Thank you. I appreciate that. I want to ask about some of the time. It used to take a long time. I don't know if this is still the case. And we used to do a duplicative sort of evaluations. At what point are we doing evaluations when youth come in? So remember, there used to be a psycho evaluation and a psychosexual evaluation and then an education evaluation. I can't remember all the names, but there was evaluations that youth got when they came in. And then are we doing those sort of as youth are come in pre-trial? Are we having those evaluations done pre-trial? Are the court asking for them pre-trial, or are we doing those evaluations post adjudication or as we await disposition? Sort of where are we in sort of the time of how long evaluations are taking? And then are we doing duplicative evaluations, meaning kids are getting evaluations when they come in, and then if a judge decides to commit a youth, are they re-requesting an evaluation of the same information?
So I'll try to be super brief. there are many evaluations, short evaluations that happen in the life of a case. At intake, there's a short mental health screening, there's a short CSEC screening. There are evaluations for appropriateness for diversion. There's a risk evaluation in JM15, little screenings. I think your question is really getting at these big psychological evaluations in psychiatrics conducted by the Child Guidance Clinic that take like 6 hours to interview the kid and produce like a 10-page report.
Yes.
Those evaluations do not happen in every case. In fact, if a kid comes in and is doing well on supervision and is likely a probation candidate, he doesn't get a big in-depth psychological evaluation because the question of what do you need is being answered by his behavior on the services. Kids who are having trouble adjusting and conforming their behavior to the rules of society do end up moving toward those evaluations because the question is, why, what's going on, why not? Those evaluations typically should not be ordered pretrial because in order to have full information, you need to know about the current offense. They are sometimes ordered pretrial to try to get the kid to the top of a line or a wait list later.
Right.
That creates duplicative evaluations because then after adjudication, you have to do it all over again and say, what does this offense add to our understanding of you?
Got it.
So they should be typically done after adjudication, but before a disposition hearing. Sometimes they are ordered earlier than that, and that causes them to be redone later.
And how long are those taking? Because I remember it used to take a long time, and that was a part of the delay as well, was waiting on these evaluations to be conducted and then come back.
My information is a couple weeks old. It was taking about 6 to 8 weeks from the day they were ordered until the day they were finished.
Right.
In part because of just a wait list getting to the child to do the evaluations, but then it also takes, I think it's like it's a time period turnaround after you do the evaluation to produce the report. But there is a long delay in finishing those.
Yeah. Thank you. Thank you, Chairman.
Thank you.
Thank you, Councilmember. Councilmember Bonds.
Thank you very, very much. As my colleague was speaking, I was dreaming out loud. And I was dreaming about whether or not public defender has the capacity to look at every young person who is either committed, detained, or held by DYRS at the front end. Do you have that capacity?
Well, I mean, the juvenile services program, the program that I manage, our staff, we have offices at the facility. So we do have contact, barring any immediate narrow conflicts, to interact and engage with every single young person that comes through YSC and New Beginnings.
Okay, that's for me, that's great news in my dream, because I'm wondering if you are not the facilitator for making sure that all of these, the tests, the information that we need, the school report, social worker report, are sort of packaged so that the agency has a beginning point, already has accumulated information about the young person and their family, so they can go forward from that and begin to look at a plan, particularly for those who will later perhaps be committed, or I think it's Title 16.
So what I will say is, quite often, my program and the attorneys on my team and our law clerks are in communication with the attorney of record for all young people at the facility, right? So as it relates to the awaiting placement population, our program really focuses on those young people in particular because of these long periods of delay. So in those situations, we're regularly communicating with attorneys of records to say, hey, can we support you here in advocating with DYRS to inquire as to what's going on, why there is taking so much time. As part of your dream, that would be lovely. And I think what we are hoping to do and what we currently are doing is pushing DYRS to provide answers and provide insight as to what's missing, where they are, what can really move this ball forward. In order for that to be effective, it takes, I think, a few things. DYRS to do timely assessments, do all of these things in a timely, efficient way, identify what's needed and follow up on those things. There has been challenges with DYRS and the agency being transparent with us as advocates for the young people, youth, and their families as to what's missing, what the issues are. So I think unfortunately, this may be a dream deferred until DYRS has more opportunities or does a better job of doing their part in completing this process for young people and their families.
And I hear you, but in the dream, you would be, you know, the entry point. Okay, and as the entry point, you would have access to all of this. And so then you would then monitor whether or not or how the young person's stay is, whether or not they're getting their medication. I think I heard that from some of our witnesses today. My point is that we need a process that handles that entry point. And if you don't have the information, we're not going to get the outcomes that we need while the young person is actually confined to the facility. You have the ability to do that. And I'm just wondering what else would it take in order for you, almost like becoming an adjunct professor of a program, if you know what I mean, in order to make it happen. And if you've given some consideration to that, because to continue to say that, you know, we're waiting for the agency to do this, that, or the other, and we know that there are many parts that have to come together. And the issue is, for me, at least what I've heard today, is staffing. It's staffing. The right staff, the number of staff that you need. I think the will is there, but, you know, we'll see. We have many more witnesses to come before us, but just wondered.
Yeah, I would just say, you know, with all due respect, the agency has the responsibility and has the ability to do this right and get the information if they want to. They know what information they need for this young person to take those next steps. So for the Public Defender Service, right, our role and all we truly can do, right, is advocate for our clients and ask DYRS to do what the law already requires them to do, which is address the needs of young people in their care, provide true rehabilitation to youth as a whole, and support families with this young person. And how they've identified that they should be doing this is by way of a pre-commitment process. They are working, I think, on building up their pre-commitment team to pull all of this information and kind of be that entry point that I think you're referring to. In order for it to be effective, though, they have to move quicker and efficiently and do the things that they have told young people and their families that they will do for them.
All right, and have you identified some very specific barriers to why it is not getting done within a reasonable time frame?
So we've heard a few different excuses. We've heard the staffing issues. We've heard, quite frankly, there have been several care coordinators, case managers that have been really transparent with their disappointment in having to complete the YLS because it is a more robust tool that requires a lot of, if done with fidelity, talking to families, talking to parents, doing interviews, and making a really thoughtful understanding and assessment of young people and their families. So there have been some care coordinators who just say, it's too hard to do. It's time consuming. There are reasons we've been told that, you know, some folks, they've got a lot of kids on their caseload. I've heard care coordinators say, if I spend so much time with you, then no, I'm not going to get to work on any of my other kids. So you're just going to have to wait your turn. So I think it has to, in part, be a agency shift in understanding as to what our young people and their families deserve, and that they deserve to be prioritized and move through this process. But it seems to be quite often more so a blame game within agencies and with other agencies as to who should be taking priority rather than focusing on making sure that the young people's needs are getting addressed.
Thank you. Thank you very much. Chairman, I don't have any other questions. Thank you all.
Great, thank you. I did have some questions for the auditor. Ms. Patterson, you pushed back pretty hard on this being put in the office of the auditor. Let me start with what my theory is, which is that if we are going to codify what DYRS used to do and what there's been testimony is reasonable and necessary. You've got to do a risk assessment, you've got to do an individualized rehabilitation plan, you've got to do a discharge reentry plan. How do we know they're going to do it? And you can say, well, we'll do it through a council oversight. But actually, if you look at other agents, you look at our government in other spheres, but also other governments. Well, Congress has got a General Accountability Office that looks at a whole lot more than just audits. Almost every, maybe I shouldn't say that, a lot of agencies on the federal level have an inspector general for each agency. In addition to congressional oversight, we have an inspector general for the district. We have a DC auditor established in the Home Rule Act. We have, for instance, with the police, we have the Office of Police Complaints, as well as Internal Affairs, as well as a deputy auditor for public safety. I think that if we're going to require these basic materials, risk assessment, rehabilitation plan, reentry plan, we got to have a way of knowing whether they're happening. Now, it may be the language in the bill is far more expansive, like maybe looking at the quality of the plans and reading each one. Maybe we don't need that, but I think I need something more than the annual oversight hearing to know that these discharge reentry plans are happening on a regular basis. And you could say, well, the council committee can have hearings more, oversight hearings more often. Some committees have a lot of hearings and they still don't catch everything. I should actually put that differently. I think there's a value to numerous eyes looking at this. So that gets me back to, if not the Office of the Auditor, then who? We create another $700,000 agency? I don't think so. I just want somebody who's looking to see whether these risk assessments are actually happening.
Let me try to respond to that in a couple of ways. One of the things that we have done a few of in recent years is what I refer to as legislative compliance audits, where we take a major piece of legislation. We took the 2008 energy legislation. We looked at the NEAR Act and really go do an audit. We do an audit of the implementation of the provisions of the law. That's something that we can do as a one-time thing. If you enact the DYRS reform elements of the proposed legislation with all the elements that you were just describing, you could also require us, 3 years following implementation, long enough for it to be implemented, to do an audit and take a look at, has this been implemented faithfully? That's the kind of work that we do. We take a look at whether something is consistent with law and regulation, and we have our findings and we have our recommendations. So that's one thing that we certainly could do. It's the ongoing monitoring that is not necessarily the kind of work that we do. We don't do casework. We don't take individual complaints like individual council offices do with constituents. There are just a lot of things that are incorporated in the incredible expansion of the role of the Independent Juvenile Justice Facilities Oversight Office. It's much broader in the bill as proposed. That kind of monitoring, it's just not what we do. We certainly can. I would want to create probably a separate division within the office independent of the audit shop, but that's not the nature of the work that we do today. It isn't to say that we couldn't do it. It's just not exactly what we're doing today.
I understand. And I think that when you do that kind of a detailed 3 years into it, analysis of the implementation of a law, that there is value to that, but that's not what I'm thinking. So I'm looking at the bill. The deputy auditor shall regularly monitor and publicly report on the durability of the reforms, monitor and report on any systemic problem. That's not really what I'm interested in. And we have to figure out how we're going to mark up this bill. What I'm interested in is simply knowing if we say that there has to be a risk assessment within 30 days, or a discharge reentry plan within 30 days, and I don't remember the exact timing for these things. I want to know if those are happening, that's all. And my guess is at some point you may figure out that they're not doing it very well, and then you may want to do a more detailed audit. But somebody has got to look and see if we're going to require these, if we're going to require these basic assessments or plans.
I
Somebody's
mean,
just gotta see
another,
where they
another
stand.
approach you can take is to look at requiring a dashboard and requiring that information to be published. And not any of the details, not any of the personal information, but, you know, how many in the door, how many out the door, what happened this month, what happened last month. You know, it's possible with, you know, data capabilities we have today to create some kind of a dashboard that gives you a real-time report on that. And I will, you know, note something about some of the oversight that Councilmember Pinto has been doing with the OUC. One of the things pushed for in that agency was a new dashboard with data. One of the most useful pieces of information that's up on that dashboard is how many shifts had enough people on them, and they've been reporting that in, you know, monthly. That's useful information that shows you they're still lacking staff. I'm just trying to give you some other ways that you can get the kind of information you're looking for, if what you're looking for is what are the metrics on whether they're doing what the law requires.
You look like you wanted to say something.
Just that you can get quantitative information, but you cannot dig deeper into the quality of the assessments that are being done if you just have a dashboard. So you cannot go ahead and look at the service plan and see what is in it and whether those services are being provided, whether they are effective, and whether this core mission is being served of rehabilitating youth. And I think we're dealing with a small number of youth, unlike thousands of calls that might come through to the 911, you're dealing with a small number of youth, and how the small number of youth who are committed are being treated in terms of the plans.
So you're pushing back on where I am, which was pushing back on where the auditor is. You want a bit more qualitative.
An independent office with expertise that can deeply examine these issues and provide the sort of the structured oversight for this vulnerable population.
All right. This is clearly something we're going to have to wrestle with. Thank you. Let me just check with staff. All right. Thank you all very much. And Auditor Patterson, thank you very much.
Thank you, Mr. Chairman.
I'm going to go to the next group of government witnesses. Deputy Mayor Lindsay Appiah, Deputy Mayor for Public Safety and Justice, and Sam Abed, Director of Department of Youth Rehabilitation Services. No, it's a different committee. Give me just a second. Thank you. So which one of you is going to go first?
I'll go first. Good evening, Chairman Mendelson, members and staff of the Committee of the Whole. I'm Lindsay Appiah, Deputy Mayor for Public Safety and Justice. This evening, I'm here to provide executive testimony on Bill 25826, the Recidivism Reduction, Oversight, and Accountability for DORS Act of 2024, or the ROAD Act. Reducing crime and violence continues to be one of the most pressing responsibilities we have as a government and the mayor's highest priority. Mayor Bowser frequently emphasizes that to advance safety in our city, we must work to restore balance in our public safety and justice ecosystem. We have worked alongside council, community, and a broad range of stakeholders to recalibrate the accountability arm of our ecosystem through the enactment and implementation of critical legislation that is helping us to decrease crime across the district. As of September 23rd, homicide is down 29%, assaults with dangerous weapons are down 27%, and total violent crime is down 34%. We recognize the tremendous work being done across the ecosystem to make these reductions a reality, and thank all the selfless public servants who are working extremely hard to make our city safer and stronger. We're encouraged by these reductions, but we know more must be done to continue to drive down crime in our city. This is particularly true in relation to juvenile crime. There are still far too many youth perpetrating and being victims of crime. For example, while we're seeing a 54% reduction in armed carjacking and 49% decrease in carjacking offenses overall, there's still been 58 juvenile carjacking arrests. Additionally, there have been 52 juvenile gunshot wound victims, with 9 fatally wounded. And while this is a decrease from 2023, it is simply still too much juvenile crime and death. We're committed to working with council on additional legislative and policy proposals that aim to reduce crime and recidivism among youth in the district. However, we must proceed with an appropriate amount of agency deference and respect for subject matter expertise. We must focus on proposals that will not detract from agencies carrying out their core functions by adding additional administrative burdens that will not lead to youth crime reduction or better outcomes for justice-involved youth. I'll now turn to the bill being discussed today. The executive is committed to partnering with council on policy proposals that help support committed youth. However, we do not support this proposal as introduced. First, the ROAD Act overlooks that DWRS has ample oversight and creates a duplicative and extensive deputy auditor for independent juvenile justice facilities oversight. And second, and more disconcerting, the bill fails to take a comprehensive system-wide approach to youth in the juvenile justice system. Duplicative oversight. Section 4 of the ROAD Act proposes creating a new position in the Office of the DC Auditor, the Deputy Auditor for Independent Juvenile Justice Facilities Oversight. The creation of this position is duplicative, unnecessary, and unwise during a time of more constrained financial resources in the district. The district government was designed with several oversight bodies, each with oversight over DYRS, Council, the Office of the DC Auditor, and the Office of the Inspector General. Council conducts performance oversight hearings of the department and can schedule additional oversight roundtables throughout the year. In fact, this May, the Committee on Recreation, Libraries, and Youth Affairs held such an oversight roundtable on matters involving DWRS. Currently, pursuant to DC Code Section 1-20455B, the DC Auditor is tasked with conducting thorough audits of the accounts and operations of the government of the district. The OIG is tasked with conducting independent fiscal and management audits, inspections, and investigations of district government operations and ensures district agencies, including DWRS, are effective, efficient, and free of fraud, waste, abuse, and mismanagement. When the Jerry M. consent decree ended after 35 years in 2020, then Attorney General Carl Racine lauded the decision as a major milestone and noted that the termination of the consent decree would ensure that, quote, the district and DWRS will have the important flexibility and independence in continuing to provide needed services to our youth. As part of settlement negotiations aimed at bringing decades-long court oversight to an end, Mayor Bowser established the Office of Independent Juvenile Justice Facilities for a 3-year period by mayor's order in 2020 to ensure that progress made under the consent decree was sustained and continuously improved in the best interest of court-involved youth and their families. Now that JJF, is sunsetting, current oversight bodies can and should assume those duties performed by the office, as was contemplated by the settlement at the time of the OIJJF's creation. During the 4 years since its creation, the OIJJF has maintained a budget averaging $700,000 per year while publishing just 6 reports. This proposed position by OIG is an expensive and unnecessary senior level position that will not move the needle on youth crime reduction. In addition to the bodies mentioned, CJCC, the Criminal Justice Coordinating Council, also monitors DWRS as part of the Juvenile Justice Delinquency Prevention Act. In its monitoring role, every year the CJCC conducts a thorough review of juvenile justice practices by a compliance monitor to ensure that the district, and most specifically DWRS, is complying with nationwide standards for juvenile delinquency prevention, youthful offender rehabilitation, and juvenile justice system improvements. Additionally, the Public Defender Service, PDS, for the District of Columbia Juvenile Services Program also monitors DWRS by serving as the legal ombudsman for youth in the district who are securely detained or committed to DWRS. In that capacity, JSB has unfettered access to DWARES secure facilities, maintains offices at the secure facilities, and has access to the youth residing within those facilities. While there are currently 175 committed youth under the supervision of DYRS, there are many more youth involved in the juvenile justice system. According to data published by the CJCC, thanks to the passage of the Secure DC Act, there were also at least 180 youth under active probation agreements under CSSD supervision at the end of June 2024, and 170 pretrial youth with ongoing consent decrees, deferred prosecution agreements, and deferred disposition agreements being primarily supervised by OAG at the end of calendar year 2023. Currently, there is limited oversight or visibility into the rehabilitative care, treatment, or outcomes of these juvenile justice system involved youth. It's our belief that to ensure reductions in juvenile crime, there must be more robust oversight over the largest bulk of youth in the juvenile justice system and the entities tasked with serving them. So while the executive is committed to transparency and accountability, we believe that additional oversight, as outlined in this bill, will lend to role confusion and lack of clarity of responsibility for the multiple oversight bodies currently monitoring DYRS, while not addressing a critical component of juvenile crime reduction and prevention, greater oversight for those tasked with rehabilitation and supervision of non-committed juvenile justice system involved youth. Piecemeal approach to juvenile justice. An additional concern with this bill as written is the lack of a comprehensive approach to the care and treatment of all youth in the juvenile justice system, including through the imposition of universal standards of validated assessment for treatment planning. Currently, DYRS engages in comprehensive case planning for youth, which begins even before youth is committed and continues throughout a youth commitment. The executive believes all youth involved in criminal conduct should benefit from the same standards of assessment and treatment. This includes youth under consent decrees, deferred prosecution agreements, and deferred disposition agreements. However, it's unclear what assessment tools are utilized and which rehabilitative services are being provided to those youth pursuant to these agreements. In May, at the Committee of the Judiciary and Public Safety hearing on Bill 25-791, the Utilizing Partnerships and Local Interventions for Truancy and Safety, Uplift Amendment Act of 2024, I discussed that the complexities of the district's criminal justice system are magnified in our juvenile justice system. This is because of the inherent difference in young people and the role that the system plays in both holding young people accountable for crimes they commit and safeguarding and providing for their mental, emotional, and physical needs. In the district, young people charged as juveniles are prosecuted by the Office of the Attorney General, adjudicated by the Federal DC Superior Court Family Court Division, and supervised by the executive through DYRS or the Federal Court Social Services Division of the DC Superior Court. Additionally, they can be diverted through a host of routes, which include the Superior Court's Juvenile Behavioral Diversion Program and Here Opportunities Prepare You for Excellence, Hope Court, OAG's DDAs and DPAs, and the Department of Human Services Alternative to Court Experience Program. But these complexities do not change the needs of youth for appropriate assessment and treatment of the static and dynamic risk factors that inform the likelihood that youth will engage in future delinquent acts, protective factors relating to the youth and their environment that reduce likelihood that the youth will engage in future delinquent acts, criminogenic and non-criminogenic needs factors, and other factors that inform the specifics of a robust individualized treatment plan. We need a holistic and data-driven approach to help drive down crime and keep all of our kids safe across the city. Youth who are detained, committed, or diverted, non-justice involved youth, and those supervised the court. While I will always agree that we should keep striving to do better, this must be done across the entire ecosystem and not simply targeting one area of the juvenile justice system while overlooking others. In closing, I'd like to express my gratitude to the staff at DYRS, from the youth development representatives, the medical and behavioral health professionals, the treatment specialists, the juvenile justice institutional counselors, and the administrative staff who support them. In my 9 years at DYRS, and now I guess you add this as well, serving as general counsel, interim director, I saw the staff's tireless dedication to serving and supporting the rehabilitation of youth in the district. I want to thank Director Abbott for his leadership. Lastly, I want to thank all of the witnesses who appeared at today's hearing and communities members who have helped shape their perspectives. We look forward to working with council to improve our juvenile justice system across the district. I'll now turn to Director Abbott to provide more detailed information on how DYRS is working to ensure the rehabilitative needs of DYRS committed youth are being met so that they achieve long-term success. Thank you.
Please proceed.
Thank you, and good evening, Chairman Mendelson and the committee as a whole. I am Sam Abbott, Director of the Department of Youth Rehabilitation Services. Today, I'm testifying in opposition to the ROAD Act. Before I begin, and I'm going to be giving a shortened version of my written remarks, I feel I must address the characterization of our recidivism rate that's been used, specifically citing a 92 or 93% recidivism rate for our youth. The report that the AG cites for that rate is not reporting on recidivism at all. The definition of recidivism is a re-adjudication for a new offense in the community. This is a definition that has been adopted by virtually every state in the country. And there is a white paper that the national organization, the Council of Juvenile Justice Administrators, has put out, and it specifically excludes things that are included in that report. Specifically things like offenses that occur while a youth is in custody and for supervision violations. And I can give you examples of that, and I'm sure we can discuss it, but an offense can occur the moment a young person comes into our care and custody. And if somebody is assaulted, if a staff person is assaulted, the first hour that they're there, that individual has the right to charge the person that assaulted them with an offense, and they would be considered a rearrest. That is not recidivism. That is just something that happened in a facility. Likewise, when we're talking about youth that are in the community, if they have a supervision violation, I'll give you an example. We have a rapid response team where we supervise youth on GPS with GPS monitoring. If they fail to comply with the requirements, for instance, they cut their strap and abscond from supervision, we will request a custody order to bring them back in. But that is not a new offense that was committed. That is a violation of our rules. All of those things are counted in that number. That is not recidivism. That is us holding youth accountable. And I don't think that we would want to stop doing that.
So looking at that CJCC report, then the correct number would be 47.6%?
No, the number that is cited on our on the dashboard by CJCC for rearrest rates is 21% for rearrests. What I would submit to you is that we need to have re-adjudication rates as the actual measure.
I'm
So-
looking at the 2018 report, and it says conviction or adjudication, and it's 47.6%. It also says for arrest, 92.7. The 92.7, you just explained why you think that's inappropriate, and I don't disagree. But then but you did say recidivism is based on an adjudication or a conviction. And so
In the
here they
community.
have conviction or adjudication, and it says 47.6%.
Yes, it's a new adjudication for an offense in the community. Of course, they're going to have a high rate of conviction for an offense that occurs at YSC. We have everything on camera. And so if you punch somebody and we have it on camera, I would expect that you would be convicted for that. But that is not recidivism. It has to be an offense in the community. That first day or that first hour, we haven't done anything with that young person. And so that should not be counted as somebody that has been through the program and that has been through our treatment, then being counted as a recidivist.
Just one note too is, Chairman, you point out it's a 2022 report on youth from 2018. And while I don't discredit, and it is important that we look at what's happening historically over time, the number that Director Abbott just quoted is how kids are doing now. And so if we're talking about how we legislate the posture of the agency currently, then I would posit that we should be looking at current data. From 2018 to now, we all know there are many things which have impacted us, including the pandemic, which has changed many things in juvenile justice. So if we are going to look at recidivism rates, let's look at the last couple of years or however we look at it And I'm not discrediting the work that was done, but as CJCC pointed out, that's a 2018 cohort. Many things have happened over the past 6 years that inform what is happening now. And so the rates that Director Abed pointed out for rearrest for last year that are now being published by CJCC on the dashboards give us I would believe, more current picture of how are young people under the supervision of the current conglomeration of DWRS. Because if we're talking about 2018, well, Director Lacy would have to own that, right? Like those who aren't here for what happened with those young people.
And Mr. Chairman, I'll just point out that Director Love did send an email out to all of the members of the CJCC explaining what that report was. And I'd be happy to share that with you as well.
So you were about to give your statement.
Yes. So Mayor Bowser, Deputy Mayor Apia, and DYRS share the goal of ensuring accountability and oversight, reducing recidivism, and achieving positive outcomes for youth who are in our care and custody. However, the ROAD Act, though it purports to have these same goals, creates roadblocks that add confusion to an already confusing system for youth and their families, undermines a youth and family's confidence in the district's juvenile justice system, and creates unreasonable requirements that call on DYRS to take on the role and responsibilities of other system partners. The ROAD Act also does not acknowledge nor consider the ways in which DYRS is already deepening our unwavering commitment to improving youth outcomes and strengthening oversight and accountability. Since I joined the agency in June of 2023, I've made creating a culture of data-centered accountability that is focused on effectiveness and outcomes a top priority. The DYRS team is actively doing the work of furthering our continued commitment to setting high standards through policies and quality assurance, and embracing oversight from the executive, council, and the community to ensure that our work is positively improving the lives of the youth in our care and custody. In my testimony today, I will outline the work currently underway at DYRS to increase accountability and improve outcomes that have already netted early results, and share with you a better path forward for achieving our shared goals of supporting youth and their families so that they are on the road to success. I've also submitted a more detailed written testimony that I alluded to earlier for the record, which discusses potential negative impacts of the ROAD Act. DYRS is committed to setting the highest standards of excellence, accountability, and oversight for the work that we do. This commitment is reflected in the work already underway. In DYRS's fiscal year 2025 budget, there is funding to fully staff a new Office of Policy and Quality Assurance and to expand the capacity of the Office of Research and Evaluation. Thank you again to Mayor Bowser and Council for making those vital investments. With that additional funding, we are setting the foundation for strengthening of internal agency functions so that we have clear policies and procedures, internal systems of accountability to ensure excellence across agency, department, and programs, and high-quality data with regular reporting and analysis. The Office of Policy and Quality Assurance team has already begun working on developing the policy and procedural framework needed to properly instruct our staff on their roles and expectations. From that framework, we'll develop quality assurance measures to internally audit our work to ensure it is being done with fidelity. We will, if we find that it is not, we will have in place the procedures for corrective or disciplinary actions to be taken to address those challenges. With the framework for our work and the tools to enforce it, I am confident that accountability will flow as a result. My goal is not to be punitive. However, if shortcomings persist after they have been explained in procedure and highlighted as deficient, then the agency will not hesitate in taking fair and needed actions to correct and put us back on track. The work that we do at DYRS is too important to respond in any other way. Another priority and expectation that I have set for the entire agency is that we will create and fully embrace a culture of transparency and oversight. I welcome oversight from the executive and from council. I recognize that while it is my job to manage my team and its work, it is your responsibility to review that work and ask important questions about our results. I firmly believe that if we do not hold ourselves accountable for outcomes, then there's little hope that we will achieve our shared goals of public safety and youth success. We embrace oversight because it's an important part of ensuring that we are achieving our agency's mission and goals in alignment with our values. We have already begun to see the positive impact of our work thus far. Specifically, we are seeing results from prioritizing and implementing data-driven strategies to improve agency operations in ways that lead to positive outcomes for our youth and community. One specific example of this work we have done to address the amount of time youth are awaiting placement. Objective data is an important part of evaluating our performance and outcomes. I've been engaged with partners such as the Criminal Justice Coordinating Council to ensure that we are taking a nuanced approach to our data collection and analysis. To that end, we have taken a deeper look at data regarding the average length of time youth are awaiting placement. I prioritize this issue because once youth are committed to DYRS, we must get them into their treatment program as soon as possible. This allows for the youth to be put on a path to success within a timely manner. The time between when a youth commits an offense and when the system responds should be minimized so that youth connect their disposition to their offense and we achieve a deterrence effect. When we looked at the data regarding this issue, we found the average length of stay for youth awaiting placement peaked at 102 days in May of 2024 and has been decreasing for several months. In August of 2024, it was 63 days. This represents a 38% decrease. This is great progress that reflects the hard work of my team at DYRS to get youth placed as soon as possible and the work we are doing to put in place internal data systems to be able to collect and monitor important metrics so we know if we are being successful. I acknowledge that there is still work to be done, and I also acknowledge that the progress made would not have happened without the dedication and expertise of my team at DYRS. The youth and families that we serve deserve a juvenile justice system that puts them on a road leading to success and positive outcomes without placing further confusion and obstacles in their way. They deserve a juvenile justice system that is effective and unified. Each stage of the juvenile justice system flows into and should inform the next. DYRS is the last stop in the district's juvenile justice system. A better approach is to unify the system under one agency that is accountable to the oversight of the mayor and the council. In a unified system, the information gathered at intake into the delinquency system through the use of a detention risk assessment instrument and an intake assessment tool would both guide the respective decision point and develop the majority of the risk and needs assessment at the very beginning of the process. The remaining work will be to take that information and develop a recommendation for the court for both a plan of community supervision and a plan for commitment to an out-of-home placement. This allows the court to make an informed decision on whether to commit, knowing what the plan for either option contains. In a unified system, there is less confusion and frustration for youth and families. In a unified system, families are fully engaged partners throughout a youth's movement through the stages of the justice system. This fosters trust and confidence in the system and its ability to positively serve the needs identified for their child and put them on the path to success. With a system that is unified and focused on accountability and oversight, we will see the lives of youth positively transformed so that recidivism decreases and the success of our youth increases. Thank you again for the opportunity to share with you today the important work that is already underway at DYRS. I continue to also be thankful for the leadership of Mayor Bowser and Deputy Mayor Apia and their support of DYRS. They have a deep commitment to providing the highest quality services to district youth within the juvenile justice system. The executive sets high standards that DYRS shares and that DYRS is ready, willing, and able to meet. It is my hope that we will leave this hearing today joined in our commitment to journeying down the road of juvenile justice system unification and not down the road of further confusion and fragmentation because of the ROAD Act. I welcome your questions and discussion.
Thank you. I got a little confused following you, but that's because you jumped a bunch of pages toward the end. You said you were going to do that. We received one document from you, which is 12 pages. When you said you had more detailed, I assume that that's what this is.
Yes, I'll give you a copy of the written testimony.
No, I have it right here.
Oh, okay. I'm sorry.
Yeah, it's just that at some point you kind of skipped ahead and I got lost, but that's on me. Although I will ask, we got this afternoon, I believe. All right. I think it came to us, when I say this afternoon, maybe afternoon. Does that sound right?
I believe it was sent from Opla. Yes, they're shaking their head and saying yes.
Today. Yes, our rules require the day before. So I've not had the ability to read this before the hearing, which puts me at a little bit of a disadvantage. Deputy Mayor Pia, we did receive your statement yesterday, so I was able to read that before the hearing. So that puts me at a little bit of a disadvantage. Director Evad, How many vacancies do you have in your department right now?
So we have currently
Microphone,
4 SYDR.
microphone, please.
Sorry. Yeah, 4.5, so we have a half position, but 4.5 YDR positions, and we have 2 supervising SYDR positions that are currently vacant. And that's out of a total of, I believe, 228 total positions. For YDRs, 31 SYDR positions, so very few vacancies.
That's in the entire department.
That's not for the entire department. Those are for the secure programs. For the case management or the care coordination team, I believe we have currently 3 vacancies.
So your testimony is that there's less than 10 vacancies for the entire agency?
I haven't checked every single aspect of the agency for that, but those are the critical components that we track regularly. We may have vacancies in some of the headquarters positions. We do have a couple of other vacancies, yes. But for those positions, that's the number of vacancies we have for the supervision of youth. I can come back to you with the total number of vacancies.
Is the agency under budgeted?
We're not under budgeted. In fact, in the upcoming budget, the council gave funding for additional 21 YDR positions, as well as additional positions for our data research and evaluation unit, and I believe for a couple of other areas as well.
That was mayor's proposal as well as what the council adopted, an increase in your budget.
That's correct.
These numbers are a little different than what you said in your statement, Director Avid, but I'm looking at the PDS testimony. Over the last 15 months, the number of youth in the awaiting placement category at YSC has fluctuated, reaching 43 in February 2024 and is now at 26. Youth who are awaiting placement routinely wait 6 months for DYRS to place them in appropriate rehabilitative setting. Some youth have waited nearly a year. Is that inaccurate?
That's not accurate currently. That is not accurate currently. We did have longer lengths of stay when I first started, but we have reduced those lengths of stay. So the average length of stay now has come down to 63 days. I believe.
I said 26. Oh, no. I didn't say the average. I just said the number of youth.
The number of youth awaiting placement today is 28 youth, 26 males, 2 females.
Well, that is kind of what I read, and you said it wasn't accurate.
No, I was referring to the length of stay information that you mentioned as well.
Some youth have waited nearly a year. That's not accurate?
That's not currently the case. That is the case when I started, but we have reduced those lengths of stay.
Okay.
So
Now,
yes,
why should we feel good about 60 days?
it's progress. It isn't where we should be, but it is progress.
Can I note
Okay.
one thing, Chairman? One of the challenges that we had that council that has helped us to push down some of those numbers is placement. For those young people who are awaiting placement, they are awaiting placements primarily in contracted facilities because we have New Beginnings is the only facility that the district fully controls, correct? Right? Like others are all contracted facilities. And certainly post-pandemic, it was a challenge. A number of our contracted providers no longer would accept our youth because many closed and could only then accept youth from their state. The district's always at a disadvantage because we don't have a whole state like Maryland. We have one facility. So one of the things is and really some of the thinking and what has been helpful is the juvenile crime emergency that was done that allowed us to work with OCP to try and really work with providers to expedite bringing on additional providers across the continuum from group homes.
Yeah, but if you're getting a pained look from me, besides the fact I have to be mindful of the clock,
Sure,
I'm not sure that I care why. It didn't used to be, and it's too long.
agreed.
That's what's important.
We agree.
So the youth that are waiting 60 days on average, that means some are longer, some are shorter. That's deleterious to their rehabilitation.
Agreed, and that's why it's a high priority for the agency to drive that number down.
Okay, so the department, just to kind of step back conceptually, so the department, my language, a little stark, the department went into free fall 15 months ago, maybe a little bit longer. And so it's now improving, but it's still in a really bad place in terms of these juveniles. And so therefore we shouldn't pass the legislation.
I can speak to pre 15 months ago. Obviously, the director can only speak to his time there. As I was there until 21 and chief of staff during that period, know that much of what you're seeing is what was the same during the pandemic. There were long lengths of stay for a number of reasons, including many of those youth need Title VIs or Article 6s, which means they need hearings before the court. The court being or having less of people on.
These are people that were just hanging out, so to speak, at YSC.
I wouldn't say that what they're doing is hanging out at YSC because that would denigrate the work being done there. They are at YSC.
Are they
Yes.
getting programming at YMC?
They are getting
Yes.
some programming. It's not a treatment facility. But yes, they are getting education services. They are getting access to programs, recreational programs. They're getting access to,
So I'm wrong in
Behavioral
my
health
impression
specialist.
that, I'm wrong in my impression that it's overcrowded?
it's not overcrowded. It's not overcrowded. It is
Well-
full, but it is not overcrowded.
What's the capacity?
Capacity is 98 beds,
And what's the population?
94 today.
Yes, last week?
This is today's count. It's not,
Last week, what was it?
it's been around that number. It's been
Thought I heard
in the
something.
90s.
I thought I heard somebody testify it was over 100 recently.
Not recently. There was a time months ago, yes, we were over 100. That has happened.
Okay, and there are fights there.
There have been, and those have dramatically reduced.
Wait a minute, I was at CJCC just a week ago, 2 weeks ago. We were talking about the Title 16 cases.
That's correct.
And that ties up an entire two wings.
That's
of-
correct.
So that reduces your capacity by 20%, 25%.
2 units, correct.
Reduces your capacity by 25%. All right, so let's do the numbers again. If your capacity is 99, you've reduced it by 25% because of these Title 16, then that means that your capacity is closer to, help me here, 70% or 75%, and you got 98 units.
No, included in the 98, we include the Title 16 youth.
Yeah,
So
but
that
the Title 16 are how many?
he can give you the breakdown, but they're included in that 98
It's
number because for
25?
us, it's single bed count.
16.
There's 16 today.
16.
Yes, which is still 2 units because it's an 11 bed facility or 11 bed per unit.
Okay, you're making me work here. So there are roughly 99 juveniles there,
Today, there are 94 youth in
90.
total.
94
YSC.
youth. Okay, I'll subtract 16. Those are the Title 16 people.
Correct.
Okay, so 16 from 94 is 78? 78.
Correct.
And your beds have been reduced by roughly 25% because it's 2 of the 8 units. So that means that your beds are 75%. That's the capacity, 75. So you got 78 youth and 75 beds. That sounds like it's like a little bit over capacity? You want me to do the
No,
math
because
again?
I don't,
Well,
Very
Deputy Mayor, I listened to you for an hour at CJCC a week ago talking about how these Title 16 people are tying up the facility, correct?
They take up an inordinate number of bed days.
2 units.
Yes,
2 units equals 22 beds.
right.
Okay, so you're, instead of having a facility designed for 100,
it's
you
think it's
have
98.
78.
available.
Mhm.
Correct.
And that's how many folks you got there. That sounds like you're
At capacity.
at the seams.
Yes.
Okay, and I suspect that some days it's a little more.
Yes.
That's
Some days
correct.
a little
At single
less,
bed,
some days
right?
a
Like,
little
and so
more.
we go to congregate
Okay.
care and other
So
things.
when I
we talk
hear about the place kind of busting at the seams, and then I hear that there are fights, and I hear that these people, these kids are there for 60 days, that sounds like a long time to me. So I'm just not looking at the glass being Thank you, half full. I'm looking at being half empty. I don't know. I got my metaphors messed up.
No, you, glass half empty. It's half empty.
Yeah, I mean, 60 is too many,
We
way
agree.
too many.
One of the things that I would
And I've
say is
just
we
listened
propose doing
to-
assessments at the beginning of the process, because if part of it is needing assessments or other things during a waiting placement, as part of our uplift proposal, we ask that we be allowed that DYRS in lieu of CJ or CSSD be allowed to do the assessments at intake, which would then accelerate the process as they move throughout. And that is a legislative proposal made in the uplift bill.
Who does these are the risk assessments?
Currently, it's done by Court Social Services Division. So we don't, there's no control that this body or the executive or anybody
The
else has
YLS,
over.
the YLS CMI 2.0 is done by,
YLS is done by DYRS, but initial assessment of young people as they enter the juvenile justice system is done by Court Social Services
that's
Division.
pre-trial.
At arrest, yes.
Okay.
So many of the assessments that we use
But you're
when we
not
get to
getting, you're
committee,
not getting the risk assessments done timely.
So
You're certainly not getting them done as quickly as you used to. You're not getting them done. Why is the solution here to do these pretrial assessments that have less value in terms of the rehabilitative needs of the youth?
No, what I'm suggesting, Mr. Chairman, is that the tool like the YLS needs to be done at the very beginning of the process. So the first, if you can think of the system as a series of critical decisions, right? So the first, once you get arrested, the first critical decision that needs to be made by the system is, do we detain that young person tonight?
Well, what's keeping you from doing it at the beginning?
because they're not under, because youth they're not under the jurisdiction of the district. They're under court social services that is under the jurisdiction of the court. So it's federal. So we have no ability to make any decisions about those young people until they're committed. So all the way throughout their adjudicatory process, the executive, the council does not have any jurisdiction over those young people. So what we're asking is actually to try and create some jurisdiction.
Who did you ask this of?
You all, or the mayor, in the mayor's uplift bill, it's a
yeah.
legislative proposal
I
that
think
we
the
made.
uplift bill is the one that says all truancy will be referred to DHS, right?
So there's that portion, but on the juvenile justice
I just
portion.
want to go there for a second, this well thought out legislation, that all truancy will be referred to DHS. And when we decided we were going to pilot 5 schools to DHS, they said, whoa, that's too many, we can't do it. So much for that proposal. You may
Well,
not
I'm
be
talking
part of
about the
that 'cause that's the
proposals and-
education cluster. I'm just saying, you
Correct.
know, because we handle education. That was a proposal on uplift that wasn't ready. So let me see, who's doing the prosecutions?
The prosecution's done by the Office of the Attorney
And
General,
who's the Attorney General? That's DC or federal?
DC.
Okay, so you could go to OAG and say, hey, look, well, let's have DYRS do the risk assessments now.
We legally don't have any jurisdiction or authority. It's
Who has
currently
jurisdiction?
the Court Social Services Division, which is a
So the
division. of-
prosecutor can't do a youth risk assessment.
Not that I'm aware that they have that jurisdiction or ability
they
to
have-
do so.
Jurisdictions do all kinds of things.
The
I'm a little bit
prosecutors
over
do
my
not
time,
have.
so let me turn to my colleague, Councilmember Parker. I'll come back.
Thank you, Mr. Chairman. Director, it's good to see you. And I do want to start by acknowledging the positive direction that the agency is going in. I think we can celebrate that while acknowledging there's a lot of work still to do. So you should be proud of that. I do want to take issue with your definition of recidivism. I'm not going to split. To me, it sounded like splitting hairs, and I get it. We may want to focus on the number that makes us look the best. But for me, I'll give you an example. I think that 92% rate is staggering. I hear you, though, that if a young person is in DRS facilities or care and they violate a condition of their commitment, and they are therefore rearrested, that shouldn't be defined as part of our broader recidivism rate. What happens though if their fight breaks out, they are committed at 6 months, the last week of their stay, they get in a fight? To me, that says what we've done for these last 6 months has not worked. They are still prone to bad behavior, and now they're being punished again. So I'm just throwing that out there that yes, we can split hairs about how we define it. I think whether it's 25%, the numbers I have are 92%, roughly 70% are arrested, and about 50% or so, the number that the chairman cited, are being committed based on new charges, which is still way too many youth in the district. I'm gonna move on though. I think given our work together over the next few months, it's gonna be important that we align on how we're defining recidivism and what we're gonna be doing to move that number in the right direction. Because I do have faith that you have been working and moving things in the right direction. You cited since May, there has been a positive movement in the lengths of stay at YSC. What would you contribute to that decline in the lengths of stay?
First and foremost, getting the continuum of care, starting to get that put together. We did not have access to enough.
Can you say more? When you say continuum of care, what do you mean by that?
Yeah, these are the private provider programs that we need to have contracts with. And as the deputy mayor explained earlier, some of these contracts were either lost because during the period of COVID, there was a big reduction in the use of incarceration, naturally so, across the country. That put a lot of providers out of business. And they had to downsize their operations, and some of them would only serve youth in the jurisdiction that they were licensed within. Others just refused to take some of our kids, or the agency let the contracts expire because they weren't utilizing those contracts because of that great reduction in the number of commitments. So we had to build that back up. And we have expanded or added 12 additional programs since that time. But we still need more because it's not just the number of beds, it's about the type of beds that we need. And so the CJCC actually has a grant that we supported from the federal government, Department of Justice, OJJDP. It's a $500,000 grant to help us build out that continuum of care. And that would serve not just DYRS, but CFSA and other.
I'm
health
assuming when you say that, you're talking about those in confinement at the facilities or at DYRS facilities or
So
in community
the
as well.
continuum of care in juvenile justice can be, we say it's everything from home to a foster home, to a group home, to a therapeutic group home, to a residential treatment center or secure facility, to a psychiatric residential treatment facility. So each of those is the continuum of care, that young people need different levels of placements, but within that also different levels of therapeutic intervention. And so he's saying continuum of care, we're talking about really providers and placements that are able to serve both the use level of supervision that's needed, which could be everything from home to as well as services.
And this is a good segue. So one of the reasons you cited for a delay in placement is because of those out-of-state providers, they're not taking DC youth. And while that may be getting better, that is the justification for the delay. And I think that may have some credence. Earlier, we heard from an advocate that testified that said, well, even at New Beginnings, that there has been a delay. So even where we have jurisdiction of placement, what is the explanation for why we're seeing such a lag from where we were several years ago?
So we can place much faster at New Beginnings. And we do place kids faster when they're going to New Beginnings. But even when we're doing that placement, I think there's been a little bit of muddying of the water between what is an assessment, a risk needs assessment, and then additionally, the psychological assessment. And so those are the two components that you need to make a placement. So yes, we have to do a YLS assessment, but we also, and that's critical, that's a critical piece, but we also need to have those psychological assessments to make the placement.
I got you. And earlier you're referencing that a key delay is that the information that those psychological assessments from the courts are delayed, which is therefore delaying your ability to place the young people.
Yes.
Got it. You answered the chairman to say the average length of stay today is 63 days. I went back to the oversight responses and our goal is 30 days. So Director, what would you say is going to be the charge to get us to that 30-day benchmark?
So the charge is that we have to speed up the process of doing our own internal assessments. That's the YLS. We also have to work with our partners at Court Social Services Division and the Child Guidance Clinic to get their assessments done faster as well. And then again, continue to expand that continuum of services so that we have a range of providers. Because another source of delay is I may have a contract with a private provider that serves this particular youth's needs, but they may not have a bed available. So I need to have other options for that same type of program.
I was surprised to hear, although happy to hear about limited vacancies within DRS. That is a movement in the right direction as well. I just want to make sure I'm clear. So when we say there are no vacancies, I know before there were a lot of people calling out, a lot of people on medical leave. Are you counting those individuals as being part of the staff?
So those are not vacancies. So those are filled positions that are occupied by somebody
When
on.
you say we only have 3 vacancies, I'll ask it a different way. How many individuals are showing up for work? Do you have those numbers, the total staff capacity, and how many people are showing up to work?
I need to come back to you with the current count, but historically, since I've been here, we have had a high number of staff that are unavailable for duty. And so to address that, we have actually hired a return to work coordinator. And this is a staff in our HR department that is dedicated to reviewing all of those files, the medical files, and ensuring that we get those people back to work if they're eligible
Yes.
to come back to work. And if they're not able to, then we need to free that position up and go and hire.
So I would like those numbers. If you could share what is the capacity for those different divisions? I believe YDR, SYDR, and the case management team were 3 of the ones that you
It's
referenced.
usually usually our YDRs is where we see our most unavailable for duty. So how we measure it is obviously our FTE count, but who's unavailable versus available. And
Yes,
so we can get
yeah.
those across.
I would just throw out there, it is not surprising that in a high trauma environment, you have individuals calling out. And I would venture to guess they're probably not getting paid a whole lot of money. And we are seeing this in other agencies. So we will look to working on how we can work on that. I want to keep going. Another critical, well, let me go here first. I did not hear from either of you a clear objection to the timelines being imposed on DRS in this legislation. Is that fair?
So we're saying we want to do an assessment. I'm not going to oppose a short timeline. I can let the director speak as to whether that's practicable.
So I do want to address that the 72-hour requirement for completing a risk needs assessment. To do a risk needs assessment, the YLS,
yes,
you do need to have a meeting with the family. And to organize that meeting, get it scheduled, bring them in, have that conversation, and then synthesize the information. And what I mean by synthesize the information, we don't just rely on the care coordinator to simply do the YLS. We have put a quality assurance piece on top of that. And in other words, we send that to a contractor who is certified by the purveyor of the YLS to review that assessment.
Are you suggesting 72 hours is not enough time to
It is
convene
not
that
enough
meeting?
time.
What would be a more appropriate time?
So typically, if I compare it to my previous employment in Maryland, we had 30 days to complete those assessments. But the difference is we started that assessment process at intake. So intake into the delinquency system. The moment that you come in, that's when the clock starts, when you get arrested. And so we have time to schedule a meeting with the family, bring them in, have those conversations, do our quality assurance piece.
So if we were to fix that part, the 72 hours may be more plausible, you would argue.
Well, it wouldn't be like the 72 hours. The key is to have all that information predisposition for the court. That's when we have to have that information.
I got it. A couple of more questions. I do know I'm over time. I'm going to turn it. But what I'm hearing, just zooming out, is there isn't direct opposition to the time. We may want to massage the timelines, but doing things in a faster pace is fine. Although there is a direct objection to this independent.
We really want it at intake.
right?
Yeah,
Like-
so yes, if the rule stood 72 hours from notice of commitment and we were able to do it at intake, absolutely, that wouldn't be a problem. Because we would have that assessment done way before we get to the point of
I want to just end on this last question, just for the sake of time. A big part of this is around services provided to young people in the care of DYRS, and the fact that they're not happening while young people are awaiting placement largely. They're largely not happening at YSC in general, as per the testimony we heard today. Can you speak to that, Director? And do you have any data? Because what I've seen is, whereas it used to take 30 days to say, all right, this young person needs to be connected with DBH or another provider, and them actually being connected is now taking a lot longer.
So when you talk about services, and particularly we're talking about services at YSC, those are not treatment services. We have not put that person into a
But you're holding young
treatment
people there
program.
at times.
But
for
we do
6
have
hours.
other
There are
services.
there are almost 180 committed youth, and while every youth matters, when we say that kids aren't getting there, that means that 160 other youth are in the custody and care are committed to DYRS. So we do need to work on the population of the awaiting placement. But I don't think that we judge the services being delivered throughout the entirety of DYRS's who the committed young people are
And
out of the
that's in part
20th
because
facility.
being locked in a cell is very different than being in a group.
I
unit.
totally understand. I'm just saying, like, if we're making legislation about the agency and it's how it's performing, I think we need to look holistically, and that's somewhat of
I
our
wouldn't
discussion.
object to that point, that we should be thinking about all of the young people in DRS's care. I'm assuming the Attorney General would agree with that. But for the young people at YSC in particular, it troubles me to think that a young person is sitting for 6, 7, 8 months and they are needing mental health services and not receiving them.
No, they're getting mental health services. They are getting education services. They are getting substance use services. Sorry. Yes, we have credible messengers that work with them.
I'm going to turn this. Do you have any data for instance, I forget the number you said, 96 young people that are at YSC today? 94. Do you have data on how many of them have received services versus are awaiting services that you can follow up with the committee?
See, I think this is getting two things confused. When they're awaiting placement, they're awaiting placement to go to a treatment program, but they are still receiving services. Every kid is receiving services. All of them are going to school every day. All of them have to, are availing themselves, and they don't have a choice. They have to go. It's compulsory.
I will say, Director, respectfully, I find that very hard to believe that we are hearing pretty blatantly from everyone, young people are not receiving services. I know just anecdotally from our schools, a young person may have an IEP and they're not necessarily receiving services. So I find it hard to believe that every young person at YSC is receiving services, even though everyone is testifying to the contrary.
I would welcome your visit to YSC to meet with our education partners at the See Forever Foundation to see that we implement IEPs for every kid. Absolutely, that is happening. And we can show you those metrics. Absolutely.
I want to come back just to put a pin in this. If you can follow up about services, I believe that Maya Angelou is doing a great job. But in terms of mental health services and other required services that young people in the care of DRS, specifically at YSC, are receiving, and if they are not yet committed and therefore you would argue they shouldn't receive those services, you can denote that on whatever the statistics are. Is
We'll
that fair?
respond to that.
Okay.
Absolutely.
Thank you.
Councilmember Louis George.
Thank you. First, I'm going to put my hat on as Family Services Chair and CFSA, if I could. In fiscal year 23, only 8 youth were considered dual jacketed, meaning they were simultaneously involved in CFSA and DRS. Of course, there are many more youth who have been involved with each agency at different points in time. Does DRS attempt to identify youth who have been involved with CFSA? How and at what point in the process does this happen?
So dual jacketed is referring to youth that are engaged in both systems currently. And I think the deficiency that was identified in that report is that we should be looking at young people if they've ever had involvement in the child welfare system. That is absolutely correct. We should be doing that. That is not how the system is set up to do it. The right place to do that, again, is intake to the delinquency system. The whole concept of a crossover youth practice model, and I'm sorry, Councilmember Freeman's not here because
So when you say intake, it should be done at intake of delinquency, you mean when the youth comes into an arrest occurs and the youth is pretrial. You believe at that point, we should be,
at that point,
social services should be the
well,
point. Who
I
does?
think it should be us. And that's
Okay.
why I'm advocating that we have that role. But it's that intake decision of diversion that we need to be mindful of. That is the point where we can divert a kid that has been involved in CFSA back to the child welfare system and avoid the collateral consequences of being in the justice system. If you're doing it after commitment,
Yeah.
then you've already missed all the opportunities.
Working with CJCC, because we talked about how can we get that data, because
Yeah,
it's
yeah, I
not-
just wanna-
you know, it's
yeah.
like tricky to be able to
That's right.
cross-reference anywhere. And so that has been one of the discussions. Are there like data barriers, and how do we, obviously asking if a family's
Right.
involved is an easy way to do it, but it isn't. You've talked about privacy, you know.
That's right.
So
So right now, we currently don't have a system where a youth who is CFSA involved would be known to DYRS unless somebody else has flagged it before. It's in that juvenile's case file when you get it for a commitment,
Essentially, yes.
essentially. Okay.
Yes.
And so basically, if once you find out sort of during the assessment of the family, you find out, oh, by the way, they were CFSA involved, you sort of, in your experience, sort of what is DRS, I guess, what accommodations do you all make for dual jacketed youth?
So there isn't much left to do once they've been committed to us, because now a court has already found them
Yeah.
responsible for a crime and committed them to us for services. So typically, when we look at a crossover youth practice model, and I'm going to use the Georgetown model because that is local and it's one of the best in the country, you would have to do intake essentially jointly with CFSA. Right? To understand who is involved in both systems. Then you have authority to make a diversion decision. And we make that first decision to say, should we even let this youth come into the delinquency system, or do we need to move them into back into
Yeah.
the child welfare system? If they are going to move into the delinquency system where they're going to be involved in both systems, then we need to link them by having one court have supervision of both the child welfare and the delinquency case. That will make sure that all of the orders are in line, that they don't conflict with each other, that there isn't any confusion, because we're going to do joint hearings. And so
Got it.
that one judge can hear both cases and order each agency to do distinct work that is related to their areas without any duplication of effort and without any cross purposes.
we are trying a little grassroots work where most of the kids who are in our critical incident protocol, which means they've been a victim of assault or involved, have a touch somewhere. And so what we've started to do over time is we'll get notification from MPD about a child and ask, we literally are on basically a text chain together with DHS, CFSA, DYRS, the education agencies, to say, does anybody know this young person or family working with them? Because even if they're going to touch juvenile justice system now, if they've been in PCAS or some other part of the system, their family has information. And so now I get a weekly report from DHS, any kids that have been referred because they're missing, but we also know that they've touched here, to figure out who should be the one to make contact with the family because they already have relationship.
Correct.
Right.
Okay.
So we're doing that. It's very grassroots, as
Got
we
it.
will do, but yeah.
Okay. So as that grassroots thing is happening,
Yeah.
based on the auditor's sort of recommendations, we need somewhere to house that. Like, somebody has to house it, essentially. And right now, it sounds like you're housing it, I guess.
Well, the mayor was the one who started and is on that chain and make sure people are doing, and I'm not joking. She'll be like, who's seeing this kid this weekend?
Yeah.
I mean, really, like,
So,
but yes, it does need
that's
to
what
be an agency.
what you're
And
doing.
DHS has taken the lead on
Okay,
putting
DHS is
together
taking that lead right now.
right, and distributing it to us, and then
Okay.
the PSJ agencies step in then.
Okay. Based on the auditor's May report, I think what she was recommending is sort of a joint response, a sort of, doing that, like a crossover youth jackets being in one location, it including everyone. And it says both agencies should sort of prioritize crossover youth identification, coordination. It sounds like that hasn't been done yet, but that
They're
is something
working on
you
that
are
with
working,
CSA.
you're going to work towards doing.
Yes, absolutely. We're working towards that. And we're also partnering with CJCC. So there are two really high quality models. I mentioned Georgetown because I'm more familiar with them, but there's also a model from the Robert F. Kennedy Foundation that is also well respected. And we are inviting those two to come in, present to the whole team.
Got it.
So that we can bring a TA provider and put this together correctly.
Got it. All right, taking off my family services hat, putting on my facilities hat. During my facilities tour of YSC and New Beginnings, I was sort of concerned about the lack of clarity around facilities responsibilities between DYRS and DGS. At that time, I spoke to both agencies about sort of us reaching a written agreement, sort of who is going to be, who's responsible for which facilities needs. Do we have that written agreement done? And when can I expect that written agreement to be done between both agencies? So I know who is going, what DGS is going to be responsible for as far as facilities and what DYRS is going to use as their own budget, which you all were using a large amount of your money that you shouldn't have been, just saying, to do facilities things that were for DGS to do. So that's why I asked for a written agreement.
So I believe that is either completed or almost completed, but I do need to check with my team. I did not check on the
Okay.
status of that for this hearing.
Great. Get back to me about that. And I want to make sure, are all boilers fully functional at New Beginnings?
Yes, they are.
Okay. And do you all monitor the conditions of out-of-state facilities that you send youth to, or is that a possible, is that possible and do you do it?
Yes, I mean, currently we do monitor through our care coordinators. They do visit. However, the Office of Policy and Quality Assurance is going to be tasked with that responsibility.
Got
And
it.
so what I've detailed them to do is to create a monitoring tool so everybody understands what the standards that we expect are. And we will go and we'll be monitoring all of those facilities.
Great. Get back to me on the facilities thing, we'll do it. Taking off my facilities hat, putting on my disabilities hat. I also have disability rights. The chairman obviously loves assigning me things. So the committee received written testimony from Disability Rights DC, noting concerns with how youth with disabilities, including those with mental health diagnoses, are treated by DYRS staff, particularly in regard to non-permitted uses of dangerous restraints and seclusion. As you know, I oversee district's disability-focused agency, including the Office of Disability Rights. So accessibility and disability rights across our government has sort of is a top priority. As of February this year, DYRS was one of only 4 district government agencies that did not submit its ADA self-assessment and compliance plan to ODR, as every agency is required to do. Has DYRS submitted these legally required plans to ODR since February? And if not, when can we expect these plans to be submitted?
I was not aware of that, but I can check on that.
Okay.
This is an ADA self-assessment.
Yeah, so basically under Section 2 of the Disability Rights Protection Act of 2006, each agency has to submit that report. And so based on what information we received from the Disability Rights DC noting concerns, if you submitted that report, you would actually get to the crux of the issues that are happening within the agency.
Can I just note one thing that is not just for the record, which we know, one of the ongoing challenges in the country, but certainly here as well, is psychiatric care for young people. So I will always say that the YSC, this was something that we worked on a lot with the court, but that the YSC is not the right place for many of our young people with psychiatric needs. But they are there, right? Because there's not alternate placements and there's lack of psychiatric care. So the more we can work together on psychiatric residential treatment facility, either here or a wider range, this is a nationwide issue, but I point that out because it is oftentimes that DYRS staff are handling young people who really need a higher level of psychiatric care than what should be happening at the detention facility. It becomes like a psychiatric hospital because we can't get acceptances at other psychiatric places. So I put that there as well. And that doesn't mean that they get to not comply with appropriate standards of care for young people or otherwise, but it does pose real challenges for staff and just and for the young people as well, so.
Okay, thank you. I've taken off all my possible hats of my others. I'm gonna get back to this definition of recidivism on my next round, if I have enough round.
You'll have an extra.
Thank you.
Councilmember Vons?
Thank you very much, Chairman, and thank you all for being here. We have many questions, as you can imagine. I wanted to start with understanding your total population that you're responsible for as it relates to the District of Columbia. What is that number? And what categories do they fall in? We've heard several things about the population.
So we currently have 175 youth that are committed to us. So some of those youth are in our facilities and some of them are in the community under supervision. And then we also have 76 of those youth are detained. And I'm sorry, I have to, sorry. Yes, in addition to that, we have, well, 94 minus.
He's trying to do the math.
You have not, you said earlier you have 94 that are in your facilities.
At the YSC total.
Okay,
So he's
all
trying to
right.
subtract the committed from that population because there's pure committed, of which there's 175. There's then the detained population who are pretrial or pre disposition, which in juvenile world is sentencing. And then there's the Title 16 youth. Those are the populations of youth that DYRS serves. So he's got a sheet with all of the breakdown as doing the numbers, but those are the 4 different populations.
All right, I guess I'm,
Skip the answer.
oh, he's still working it. Okay,
So it's the 175 committed youth and then 74 youth that addition to that are detained in some capacity that are not committed to us.
And then on top of that, the Title 16?
That's including Title
that's,
16.
yeah. Well,
Oh, yeah,
are
that's
they?
not kids in shelter, but they're not under ours.
So where do I find the number that you gave us earlier, the 94
It's
clients?
daily.
Yeah, we have it on our website.
No. What I'm asking, you said you had 94
That's at the YSC.
plus the 16 or minus the 16?
Yeah.
Okay, minus the 16. All right, so that's, okay. All right, and so you have a total of 175. And so what I'm trying to understand, of the 175, how many fall into this category of Title 16?
None, 175 are purely committed.
Okay, of the, well, then how many fall into the category of delinquent or they are committed?
That's the 175.
That's
Okay,
committed.
now I'm understanding, okay. And then the pretrial detainees.
So that is the 74 youth that are in detention that are not awaiting placement.
Okay,
Yes.
okay. Now I understand your numbers. Thank you so much. My question is, really and truly, how are each of those categories treated? And what I'm asking is, do you have all the assessments done for your 74? And because we've been talking a lot about, okay, you do not. So what would be very helpful is to understand these different steps of intake and how many of those different categories that are assigned to your facility and at what stage in the process is their so-called application at the time. So how many are you waiting for psychological assessments? How many, you see, we're trying to understand in order to think about the timeline that is realistic under current circumstances, what can we depend on?
We can break down, so the detained is one category, but population of those who we've received a notice of intent to recommend commitment, which is really at the point when DYRS should be kicking in, those would be in that they may be detained, they may not be detained, but more than likely they are. So we can get the number of those who are still not committed yet, but there has been a notice of intent to recommend commitment because that would be part of the population of which DWR should be starting case planning for.
Okay, where I'm going, I'm trying to understand whether or not the condition that, or the treatment that you're planning to give to these categories influences the timeline in which you get the information that is necessary to apply the treatment. And of course, bottom line is, then I would like to know what is the status of their receipt of services? Because what we're hearing from you is a little different from what we've heard from panels of experts. And sometimes what we hear from parents.
And we can break down what we mean by services, because when you say this, you're talking about a wide range of things. But one of the things that we also could do is break down.
That's fine.
Yeah.
What I'm asking is, what are the basic services
Sure.
that you're required for anyone who comes on your premises?
Yep.
As we're thinking, the public is thinking about what are they doing with the children that they have under their care? It's they're under your care when they're with you.
Yes, and we can give you all of that information about what we're doing with kids at the different phases. Absolutely. I believe that's consistent with what Councilmember Parker has requested.
I'm asking it a little differently so that folk can
Absolutely.
comprehend, hopefully.
But you're
It
not
just-
doing rehabilitative services on the kids who have not been, I want to say
Right.
designated.
That's correct, right? Like, so Title 16 youth are not going to get likely a rehabilitative slate of
Right.
services because that isn't the status they're in.
And do they stay with you? Title 16?
They stay for a long
Stay
time.
for a very long time. And that's one of the problems that we have highlighted. So, just to give you a sense of the scale of what that problem is, we're talking about an average length of stay awaiting placement of 63 days. Last year, the average length of stay for youth that were Title 16 in their pretrial status was over 900 days.
Okay, so trying to do an analysis of your population and the time frame that you need to complete any action, and then to figure out the services that an individual, it's a little complicated,
Yes,
but it can be done.
absolutely. Absolutely.
And you
it can
must be
done.
doing it every day because you're the custodian of all of these young people.
So absolutely, there is a flow of the process. That doesn't mean every bit of that process is working as quickly as we want it to. So
Well,
there
we-
are certainly challenges. And so that is why we look at those categories, just like you ask, and say, okay, how long are they staying in this status? Because that's going to be the indicator that we need to know,
Well,
is our plan working?
For our work here, looking at legislation, this particular piece of legislation, it just seems to me we would need more information from you about how your system, your process really flows. And
So-
what's the volume of the flow?
So absolutely, we can give you the process flow. And I think maybe a flow chart that identifies that is the best way to communicate it. But I also want to give you how the process should flow.
All right.
Because there are changes that need to really be made, structural changes.
Yes.
To put us in different parts of the juvenile justice system that will alleviate some of the challenges that we're facing.
So have you had discussions with the DC Attorney General about how we might, as a community, have access to the young people at the first stage? As
I have had
opposed
that
to, quote,
discussion,
social
But
services?
it's, I would say, a casual discussion, not in-depth enough to.
And they're not, it's not like the AG doesn't want us to have access, but they're the prosecutors. So they're not the legal custodians of the young people to say, here's access to them for these purposes. So I just want to say, like, they're not like, you can't do evaluations of young people. It's that legally, our relationship with young people in the system is defined by their status and the law.
I guess I'm looking at it, trying to look at it holistically, trying to look at, how do we help our young people who have gone down the wrong path? They're in trouble. And we're now the custodians of them. How do we help them move forward? And to me, it's about creating a system that would work. So, because we're hearing today that the system we have doesn't necessarily work.
And we, like I said, we want every young person to succeed. And if you're looking at rearrest rates that are 40%, like that's too high. If they're 20%, that's too high. But it does mean that we need to hone in on what we're doing with the 80 or the 60% and see if for those young people in the category that aren't in the successful, what the difference
and
is.
if you're
I don't
gonna-
want to, I don't want to
Right.
forget them as
And we all want the same thing. There's no question about that. But as you are thinking about the information that you said you could get for me, would you also include in that information of those that are under your care? How many have had accidents or have had cases of violence while they have been under your care?
So I want to highlight some data, and this
Okay.
is the incident data that's on the Independent Monitor's own website, okay? And this is stuff that we concur with. So if you go back to December of 2022, which is how this graph shows, and I'll happily pass it up if you'd like to see it, the rate of critical incidents, and that's a roll-up of incidents that involve injury, serious incidents as defined by the Independent Monitor. The rate at YSC in December of 2022 was 19.69. Okay. In August of this year, this is last month, it's 7.05. We have made significant progress on the safety of our youth and the safety and security of our facilities.
All right, well, I'm way over my time. I just thought trying to get a grasp of the real numbers would be very helpful. Thank you very much.
So Director Abbott, it turns out I asked the wrong question when I asked about vacancies because there's a high no-show rate of employees. I forget what the rate was or how many.
I don't have the number today, but it has hovered in the mid-30s up to 40 individuals, which is a lot for an agency of our size.
So I can't say I really appreciate that what I was trying to get at, that I apparently didn't ask the right question. And also, I've taken the time of 3 members' rounds of questions to look a little bit at the Uplift Act. And I have to say, maybe I don't have to say, I don't have a lot of respect for that bill. And I kind of touched on this earlier because the part that deals with truancy would have required that all attendance referrals, this would be for youth over the age of 13, instead of going to CFSA, excuse me, instead of going to court social services, would go to DHS beginning last month. And that all referrals of under 13 would go, instead of going to CFSA, would go to DHS beginning next year. We're doing a pilot with 5 schools. And as we developed that legislation, DHS protested that it didn't have the capacity to do 5 schools, let alone 116 schools. And that's for kids who miss more than 10 days. So I don't have a very positive view of the Uplift Act, but it turns out that yes, it does. Well, it doesn't say risk assessment. The legislative language calls for some analysis that's similar to a risk assessment or risk analysis, but it's not for all intakes. It's only for youth arrested for a crime of violence or a dangerous crime, which might be reasonable, but it's not all. And there are some kids, I'm guessing, that get into the juvenile justice system who are not arrested for a dangerous crime or a crime of violence. So it's not all. But I would add to that, it just doesn't make sense to me that you would do you would do a risk analysis for every kid arrested who's going to court, when the number that actually get adjudicated is going to be far less.
Which is why we
Why
limited.
would you waste the resources? How much does a risk assessment cost?
Well, I
One
don't-
risk assessment.
I don't think it's a waste of resources to do a risk assessment at the intake portion. Because there is a critical decision that gets made there. And I don't know how many.
But the risk assessment that we're talking about, the risk analysis that we're talking about is one that informs the rehabilitative plan. And you don't need that for, you know.
I would
when-
argue that
but
any
you-
young
when-
person arrested, there is an issue. That whether or not they get adjudicated or go to, that is saying to us, something is wrong. So whether we change the type of tool we use or not, we all believe
if
that
we
we should be
wanna- if we
providing
wanna
services and
be-
supports to families whose young people are finding themselves even touching the juvenile justice system, so they don't find themselves further all the way down at the deep end, which is what DRS is supposed to be.
This sounds
So-
a little bit like Big Brother.
Well,
So-
with children, in many respects,
If it-
that's what our systems are.
Well,
is
then
Big
let's
Brother.
refer them to CFSA when they get arrested.
But I don't,
Well, there's no authority for us to provide any services to a juvenile.
that's exactly right. And we
is
would
not
argue
in the
that's wrong.
system.
We would argue that that's a problem because why, and many families have said this to us over the years.
Deputy Mayor,
Why do young
Deputy Mayor,
people get the services and
Stop,
supports when
stop.
they've committed?
Explain to me what authority you have or the government has to provide or require the provision of rehabilitative services to a juvenile who's not in the system. He or she is not committed to DYRS. He or she is not at CFSA. He or she is not in a diversion program. He or she got
I think that's a
arrested and then
weakness in
got
our
released.
system. I think that's a weakness in our system that we do not, for young people and families whose child has now committed an offense or been arrested. There's probable cause to believe they've been involved in some sort of crime or otherwise, that because they don't float through the juvenile
Probable
justice system,
cause
that we
for-
don't provide services
Probable
and
cause for the
supports.
arrest, but the case is dropped. So there's not probable cause.
I would say whether it's CFSA or otherwise, that the family may need assistance and that there isn't currently anything in the law, and that is
And who's going to
actually.
pay for this? How much is it going to cost?
It
The
doesn't
risk
matter. The
assessment
life
and the
of a
service.
child and their ability to live a successful life is actually worth it because people have talked about how much New Beginnings cost per child. I would posit it may be actually less expensive if we assessed a family early and provided, whether it's CFSA or some other government agency, support to the family so their young person doesn't either commit a more serious
Under
offense or
what
end up dead.
authority?
The
Deputy
one that
Mayor?
we're asking you all to create.
No.
You are the.
We do have the
No,
one line.
no, the Uplift Act
But
does not, the Uplift Act only would say that there would be this risk analysis.
We asked about, we
I'm
also believe in
asking you
system
about-
unification.
I'm asking you about rehabilitative services. Under what authority would you provide, you, the government would provide, you, the mayor would provide rehabilitative services to a child who's not involved with any agency?
So if we did an assessment, we would ask the family voluntarily if they would like to participate or receive support. We have many families who come to us whose young person is at risk or is in danger, asking for us to help them. And we're like, well, we don't have legal authority or otherwise. So if that's how we had to do it, is to get consent to do so, fine. But what we would say is, court social services, we're leaving the rehabilitative care to an entity not accountable to you or any of the residents of the District of Columbia
Actually,
already.
Not for the.
For truant young people, for young people all over the place.
Actually, not for
You
the
may want
juveniles we're talking about. We're not, because they would not be with court social services, because they would not be involved. You want through the Uplift Act to do a risk analysis that if it's a risk analysis, then it is to inform what rehabilitative services would be provided.
What we
that are
propose
needed.
for those
And you
young
wanna
people
do
with
that
crimes of
for
violence
every
or violent.
juvenile
No, we
who
didn't say
is
that in that act.
arrested for a crime of violence or
Yes.
dangerous crime.
Yes,
Even though they may not be, the case may be dropped.
absolutely, we do. If they're arrested for a crime of violence or a dangerous crime, which are things like carjacking,
So, no,
homicide,
no, no,
assault
no,
with
they're
gun, yes, we do.
innocent.
That's
Aren't
exactly
they
what we would
innocent
like.
until proven guilty? What if it's a bad arrest?
I'm not saying whether
What if
they're
they
guilty or
arrested the
not,
wrong
but
person?
assessing them for supportive services because they've been even arrested for that level of offense. Yes, we would absolutely like to assess and do everything possible to provide them services. That is what we are asking for in the act.
How much does a risk analysis cost?
I don't have a number for how much it costs per analysis, but the
A guess at it?
I'd have to check what the contract
'Cause this is kind of
provides
an-
because it's our staff that does the
It's
analysis.
kind of an important data point.
Well, we
so
have
the
a
council
contract
decide-
for the actual intellectual property, but we don't pay for each assessment to the provider. We buy that assessment tool and then we administer it. Okay, and that's how that works. And the process
There
that I
still ought
described.
to be a per unit cost, because when the council legislates something, now here, my argument would be, you've done it before, you say you're doing it now, it's a question of when you do it. So I would argue there's not an additional fiscal impact. But let's say we crafted this in some way so that it's an additional expense. You bet your life, we're gonna be told there's a fiscal impact, and it's gonna be based on a per unit cost.
No,
or
so when I
expense.
started in 2012 at DWRS, we had 900 committed youth. Those were the numbers. That was we had I think it was $107 million budget. DWRS now has 180 something or 175 committed youth, $100 million budget. We would find a way, because if it allows us to support our young people so that they don't end up in jail or someplace else further down the line, to whatever is necessary. What I would say is that the agency is not significantly smaller from those days when we had 900 young people and we found a way to do it with just $7 million more dollars. So that's what I would say, like, is if it meant moving staff around or finding whatever, like, then it's worth it if it keeps our young people from moving further into the juvenile justice system. Or we had 9 young people so far dead, 50 young people shot. If we can do anything to drive down those numbers, and those young people who are arrested for a crime of violence or dangerous crime are most at risk of becoming victims,
Yes,
and
but you're-
usually are, then
You're
yes, it's worth
speaking
the
of them
money.
as though they're guilty.
No, I'm speaking of them more often than not, they're actually victims themselves who need some help.
Mr. Chairman, if I may, the intake assessment process that I described is done in both Virginia and in Maryland on every youth.
At
that's
intake.
Yes, at intake. And the reason it's so important to do that is because the intake authority, which I suggest should be DYRS, has the ability, currently this is the AG's authority, has the ability to divert a youth. And if you're going to make a decision as consequential as diversion, then you need to make it in an informed way. You
Right,
have
so
to have that
what is-
information to drive what the plan is. And that diversion is something that can be offered to a young person. If they say, hey, you know what, I'm not guilty of this, no problem.
So,
You can go to
so,
trial and
you know,
plead your
I
case.
do keep trying to interrupt because I'm on a clock, and every time I'm over the clock, and hopefully my colleagues aren't looking at the clock. So, what is preventing you from doing that?
Because we don't have authority over intake. DYRS does not have that authority. It is split between Court Social Services and the Attorney General's office.
I'm sorry, what is prohibiting you from doing this? Yeah, you just answered that, and I didn't like the answer. And the reason I didn't like the answer is because you could go to the Attorney General. Have you met with the Attorney General about this?
We have met, but
He's going to testify next, so I'm going to ask him about.
no,
the
we
meeting.
have not talked specifically about, hey, Attorney General, you should do this.
No, you
rule
would
for
do it.
us.
You want to do it.
Yes, but we
So it
would,
would be an MOU between DYRS and the Office of the Attorney General that you'll do these assessments at intake.
well, and I guess we'll find out his opinion of that.
Well, tell me why you can't do that, because I don't
Because
think there's
court
anything
social
that
service
prohibits.
has legal jurisdiction to do it. I mean, I guess if the Attorney General somehow is able to take the jurisdiction that Court Social Service has over, they do the intakes. That's legally where we are. And so, you know, I don't know how we on our side.
So
can
have you
take
met
these-
with court, have you met with
Director Odom?
Ms. Odom? Yes.
Many times.
And asked her about this?
I've asked about different things.
Yeah, okay,
And
I'll take that as no.
So we
Because
should ask, so. if
I've been
that's
around
what we
long
have
enough to
do
know
ask
that
if we can do
agencies can do MOUs. And you could do an MOU with courts. I'm not sure you would need to, but you could do an MOU with Court Social Services. It says you'll do these assessments at intake.
I
Or
mean,
you could
that's,
have
or
that
we're
MOU
asking for
with the
legal
Attorney General.
authority to do them, but I guess we could do things by MOU, but I mean, actually, I don't know if we can do things by MOU.
you'd have to
do
research
that.
whether we can
Legally, I
accomplish
don't know
all
if
of
that's
that by MOU, but if
Please.
that's possible, certainly I would be willing to engage that.
Please, I've seen agencies, Deputy Mayor, agencies do MOUs all the time. If you have the authority
Not
to
necessarily with our
do-
federal partners.
If you have the authority to do a risk assessment on a juvenile, then surely you can negotiate with the Attorney General or Court Social Services, whom I don't think you have to, in order to do the assessment. I'm over my
I mean, in
time,
lieu
and
of
I
you
still
all
have not
passing a
asked
law,
any
I
of
guess
these
that's what we could do.
questions. Councilmember
Yes, and
Parker.
thank you. And I will try not to use all of my time because our friends at the Attorney General's office, it's getting late. I want to just pick up where you all left off. What is the implication if we were to give DRS legal authority at intake? And I'm assuming we're making that sound a lot easier than it probably is in the grand scheme of things.
What are the implications? So that would mean that we would be responsible for doing both the detention risk assessment instrument, which is going to make that initial detention decision. The night a young person comes into custody, somebody has to assess, do they need to be held or not? That's a sort of quasi magisterial role that currently
And
is
right
with
now that's court.
Court Social Services.
And that would then be DRS making that determination.
Yes, making that determination and then, yeah, well, it would ultimately be a recommendation to the court, but in the moment, we would make the decision, do we hold this guy tonight or do we let him go and let the court determine, because the next day, the court would look and review and see, do they really need to be held or not?
Got it.
Right? But somebody has to do that work at the time that they get arrested.
Okay.
And then the other piece would be to do to make the diversion decision. Whether to divert a youth from the formal justice system or to continue that person into the formal justice system. Those are the two critical decision points that would be managed at intake.
The other thing is relationship. So that's not mentioned, but starting an early relationship with the family, when we talk about things like scheduling a meeting and all of those things, we're strangers and often interlopers into the lives of families. And so starting the relationship earlier so that when we're trying to have them be a part of the actual case planning process, there's a relationship built both between intake worker who will be doing the assessment and the agency should they proceed to commitment.
I like making the implicit explicit. I am also imagine when you are suggesting DRS or DC should take over that role, it is also with the thought that too many young people are being diverted.
No, actually, no.
That's not the
It's
thought.
not that we're like, it's too many because they're diverted to DHS, which is a DC government agency. But what we do believe is that we're a little ad hoc in how we're doing things versus some of our, Sam came from Maryland, where the decisions are made based upon a tool. It's a little trickier to tell how those decisions are made here without necessarily one tool we're all using to say, if you have this, you are eligible for diversion. If you have this, you're eligible for secure detention. And so, I mean, it would add some uniformity and standardization like the states around us.
Got it. I want to just go very, very quickly through different components of the bill and get a clearer sense of what you object to versus what you don't. So the risk assessment within 72 hours, it sounds like you're saying the risk assessment is not necessarily a problem, but the 72-hour window is unrealistic unless there's a way that DRS can implement it at intake. Is that fair?
That's correct.
Okay. The convening the predisposition meeting and calling the family and all these stakeholders, you're not opposed to that, but again, it happening within a few days, you think may be unrealistic.
I think it's unrealistic, and I also think that it puts an extra burden on the family that is unnecessary. Because if you have a functioning intake process where you're meeting with the family at the front end, you're having that discussion right there with the family.
The creation of the rehabilitation plan that would be delivered no later than 2 days before the disposition hearing.
So creating the rehabilitation plan, if we have all of the components, we could do a rehabilitation plan 2 days, I think is a pretty tight time frame because what we're going to be doing in a rehabilitation plan, and I think that the idea here is where would we place that young person is what they're after. That's not something that we can know for certain. We can develop the plan, we can do our assessment, we can get the psychological assessments and determine what the risks and the
So
needs of a youth
I
are.
don't have an issue with it in concept, but the timeline may be tricky just given the many
Right.
components involved. Two other things, the individualized plan upon re-entry or exiting secure placement.
Absolutely, we should do an individualized plan.
And then the no secure placement in excess of 30 days when services are not provided.
That I don't think makes good sense for public safety.
And I know I'm saying it would allow for the young person to be released. PDS earlier pushed back on that, but how I read it is they're not receiving services. There would be a claim and a push to get the young person released. And then allowing the courts to intervene with 4 months versus 6 months.
So one of the things that there was a question about, we need to ask the courts about their capacity to do so. Because the reality is if you're going to be giving the courts increased oversight, once they commit, it is true that they no longer can do anything other in these dispositional hearings other than specify that the agency must meet the plan of care. So what they're saying is, okay, it's great, we'll have additional court oversight. But I'm not sure that the court would agree that that is resources that they have. Specifically, if you look at how long it's taking for them to move through cases of young people who are pretrial right now, let alone then reviewing on a half the amount of time they currently do, additional committed cases,
I think
right?
that's a
Like,
very-
so
I think that's a very fair point.
the court is screaming at us that their workload issues are real.
And then you all were very clear about your views on the Independent Juvenile Justice Facilities Oversight Office. So those are the major components, and it was helpful to just get a clearer sense of what you agree with versus what you object to. A few other questions, and I'm going to pass it. Deputy Mayor, you talked about we should assess all young people, not just those at YSC. I don't think anybody would object to that. What is stopping DRS from doing that right now?
I don't mean just DORS committed young people. I listed the whole kind of panoply. Those young people are currently under court social services supervision where they're not linked into district agencies and they're not getting services.
I see.
Right? All of the young people on probation or pretrial, we talk about services for committed young people. They're in community with oftentimes very long dates till they'll trial, and court social services will tell you they're not rehabilitative and they also are not in the executive branch. So they're not, what rehabilitative services are happening there,
I think
right?
that is a
For
fair
young
point.
people in other parts of the system, whether consent decrees, deferred disposition or deferred prosecution agreements, what services are being provided there? So if we want to look at rehabilitation, let's look at, is everybody assessed and what's happening there that's actually helping them to not reoffend or end up further in the juvenile justice system?
Okay, I'll leave it there just for the sake of time. Here's an invitation from the CCJC, two stats that jumped off at the page at me. Nearly 50% of young people in the fourth quartile of being highest risk of being engaged in our criminal justice system have experience with trauma, as I see that related to CFSA, as well as they have an IEP. And so I take your point to heart, Deputy Mayor, when you say we should be trying to preempt these young people before they're ever at DURS, and I agree wholeheartedly. So in the months ahead, I want to work together about how do we improve functions at DURS, but also be thinking and coordinating with the chairman about how we can lean in with our schools and other agencies to ensure young people are supported before they ever get there. Thank you.
Thank you, Councilmember. Councilmember Lewis George.
I think one of the biggest things that people don't understand is sort of once a youth is committed to DRS, the system has already failed them in multiple different ways. Like that's just the reality. Whether it's the education system, whether it's the neglect system, once they are committed, they've gone through pretrial, whatever disposition is, court social services has monitored them. And whatever services court social services put in them, that's another question for the court social. So once a youth is committed to DYRS, they are really at their last point of hope, and for me, hope, because I believe that we can rehabilitate them. I guess one of the most heartbreaking things was when a youth would be committed to DYRS and they would end up killed or dead. And I'm curious to know, what are those numbers like now? Over like sort of what the pattern has been over the last few years where, you know, I have a youth who has multiple jackets, did multiple cases, got committed to DYRS, somehow while on release was killed in some way. What are those numbers
I
like
think it
now?
was one DYRS youth that was shot last year, like, or one committed youth. I can get them. They're published. They're put publicly now on the CJCC
Right.
dashboards. But I agree, right? That's the worst thing that can happen. And so one of the reasons we came in here squawking a lot last year was about, there was a period in which I think it was over like a 2-month period, six kids, CSSD kids were shot and killed. And so Director Odom is coming to me being like, what we're doing is not working.
That's
Because
right.
those are, they care about those young people as well. So the numbers are published and we can pull those for you. I think it is one young person that was shot. I think it was shot, and I don't know that that young person was killed, but shot. That was committed versus a higher number on our probation.
On the probation side, okay. And I will take a look at those numbers, because for me, that number is important, and it's the most heartbreaking thing to have a young person murdered or killed as a result while they're committed. Next to the young person who is sort of murdered or killed, the other one that would break my heart is when a youth was committed to DYRS and then picks up a Title 16 offense. What is that number of youth who are committed to DYRS as a young person, meaning not Title 16 eligible, but then picks up an offense and is now Title 16? That would be the youth that also breaks my heart, because that means we failed in some way and they ended up committing an offense that now they now will be charged as an adult and end up in adult jail.
We'll also have to circle back with that number. Don't have it off the top.
After my youth who, I'm going down the list of sort of the heartbreaking pieces of it, that's the reality of it. There's my youth who just end up, I don't, you've recidivate, who pick up an offense of the same nature. So a youth armed carjacking committed to DYRS, weeks later picks up a new armed carjacking while they're committed to DYRS. What is that number? And I think that's what you guys were sort of going back and forth of. I want to know, what's that number of youth who are committed to DYRS who are rearrested and charged for an offense of the same nature?
So we have the total rearrest number and like broken down in there. We would have to like kind of break out by charge. So I don't know that we have that. The total rearrest number is what Sam said at the beginning. I think it was
21% is the total rearrest number.
So we
but
need to.
We'd have to look through that and see if
They're
they have
committing
been
offense and then.
arrested for a similar
A similar offense. Okay. Those numbers are the numbers that I think are just the are important. And I guess there's a back and forth around that 27%, 42%, what that number is. Any number, Director, for you is too high, because your job is to have that number be as low as it can possibly be.
We'd like to put ourselves out of business.
That's right. That's the attitude. We should all be trying to put ourselves out of business in that regard. As far as monitoring goes with the CJC. So I know CJC monitors DYRS as part of the Juvenile Justice Delinquency Prevention Act. And I know that they're supposed to conduct a thorough review of the juvenile justice practices as a compliance piece. So I guess, Deputy Mayor, could you provide details on when the CJCC last issued a report specifically addressing key aspects of DYRS operations, such as case planning, such as incidents, such as population count, medication management, staffing levels, and sort of how have those findings then, that report, informed any recent reforms or improvements within DYRS?
I don't know if they publish a report, but they do their annual monitoring, because in order for us to basically like, number one, comply with the JGDP Act. They have to report all of that. And the last time I like looked at this, it was an online reporting tool that they have. So like they would then print out a report for us. Because in like the JGDP Act requires annual, and also for us to get federal dollars, like we have to comply with it. And so we can ask them to
Okay.
pull it because again,
Because the last
it was-
report I see that was the last report completed was in 2018
oh, no.
on juvenile recidivism.
No, so this is not the same, like as their JGDP like requirements, like I'm telling you, like there's some sort of online tool that they use of some sort, because I've seen like the online of all the different categories, but I can check with the CJCP on that.
Because my issue is that we're talking about who's going to monitor.
Yeah.
If the last report wasn't of recidivism wasn't in 2018, I'm trying to figure out what evidence we have to support the narrative that CJCC sort of monitors
It's the
DYRS.
compliance by the district with the JJDP Act, right? Like and all of the requirements of that. So we can kind of provide what the act actually mandates and what it looks like, because they certainly do oversight of all the facilities, including shelter homes, visits, all of those things, which is why I'm saying, like, if there is something that's missing, let's talk about that, because currently we do have a lot of different bodies that occupy the same space. And so we need to streamline that, because there does, this is real, become role confusion of who's like doing what, so.
Yeah, and based on what annual report you get, you then take those recommendations, and how does that end up into the improvements you're making as an agency?
I mean, if we're falling short on things related to the facilities or otherwise, we make adjustments in the same way as some of them tie in with our KPIs. If the agency's not living up to KPIs, we got to adjust, so.
And if we are deficient in any of the core requirements of the Juvenile Justice Delinquency Prevention Act, then the federal government would require those funds, percentage of those funds, to go to remediation.
Okay. The staffing issues have been come up. What are you all thinking about as sort of addressing the staffing issues? It seems to me there's a quality and a quantity problem.
Of course.
And so I don't want to just address quantity, because you could just hire anybody and you would get your number. But the quantity and the quality, I think, is where we're at. What are we doing to address the quality issue in addition to that quantity issue?
So quantity matters first, because like some of why, like we always have standards for, like in 2009, they changed it so people have to have degrees and other things like that, right? Like, so that's one piece. And obviously when we have young people, they have to pass CSHA, the Child Youth Omnibus Act background checks, which is enhanced because they're working with children, right? Like, and young people. But one of the reasons we focus on quantity as well is because staff get tired. And like part of what leads to them calling out or not coming in is they're tired. When we have one facility, we talk about that, because if one young person that we can't move that's Title 16 is very assaultive, staff start calling out. Like, so part of it is making sure that we have over and above the staffing numbers, because this isn't just a DWRS issue, DOC, OUC.
Oh, I know. I just want to make
NPD,
sure
fire EMS.
When I went to the facilities, they had different groups, Imani, Emoji, like different, they had their different houses. And I could tell that there was a difference in how houses were run based on who the staff were.
Yeah.
Like some staff were just really good with their house, like House of Faith, House of Imani, whatever was in order. House of Harambe was a mess because of the staff. Like it was a difference in staff. And so I'm just saying, when I say quality of staff, I mean someone mature, nurturing human beings who have the ability to de-escalate, to understand youth. Like that's what I mean by you all have to figure out that quality piece right there, because there was a difference as I went around to each group and talked to them. Some people actually were cool with who their monitors were. They were like, oh yeah, this is our monitor, and he monitored. And there were some people like, they ain't giving us our shoes, they not giving us our jackets, they not giving us our stuff, and they're using that as punishment. And I was a little like, all right, clearly. And then there was one group who was well taken care of. So I would like there to be, that's what the youth told, this is what the youth said to me and my colleague, Councilmember Trayon White, when we both went to DWRS, that they wanted to see a consistency among the staff that were there to support them. And in maturity and in care and nurture and respect.
Absolutely. So part of that is accountability, part of that is training, and we're doing both. So on the accountability side, first, I've mentioned we've set up our policy and quality assurance teams. Quality assurance means going around and actually documenting the operations and how they do. And when we see deficiencies, they have to develop a corrective action plan. And then on the training piece, I'm creating a new position that is dedicated to training insecure programs specifically, and to provide that kind of mentorship and on-the-job training that we need to get to that quality level, because I do recognize that there is variance. And then also another piece of the accountability is that as management, we have to
Right.
hold our staff accountable. And when they don't operate the way that we want them to, or that they are directed to do that, we have to do that accountability piece. And that is actually helping the morale of our very good staff that come in and do the job and do it well. And so what I would give you as a sort of measure of that morale going up is, while we haven't yet onboarded any of those new staff that we thankfully received from council and from the mayor's budget, we have seen a great reduction in the use of drafts. So when we have gaps in our schedule and nobody volunteers, we have to draft people to stay on. That is a big morale killer. Now, we very rarely use that because staff are volunteering. Staff, when we go to a muster or a shift change, when we have those meetings and say, hey, we've got 2 people that called out. Is anybody willing to stay over? I'm routinely seeing 75% of the room raise their hands. So it's building that sense of culture of a team and working
And
together.
have incidents gone down as a result of that? Because I would imagine
Yes.
incidents should go down as a result of that.
And that was the data that I mentioned earlier. Going back to December of 22, or say the beginning of almost 2023, the rate of incidents went from 19, this is rate per 1,000 bed nights, went from 19 to now it's at 7. It's a huge decline.
Thank you, Chairman.
Thank you, Councilmember Bonds.
Thank you very much, and I will not be long. I just want to ask about, of the 175 that are your clients, we know that 94 are over at the center, right? Okay, so that leaves 81. You had 98 beds.
So not all of the 90 are committed. So I think it's 20 something. It's the 28 of that 175 are at the YSC. I think it's 45 are at New Beginnings, and the rest are in a variety of other placements. Home, I think, is 45, group homes, other.
Yeah, we can give you a breakdown of all of the placements that.
Okay, all right, that would be very helpful. Because I wanted to follow up with a question about staff. What is your total staff capacity?
Our total staffing number, agency-wide, we're just over 500 staff in total.
Okay, and of over 500, and of the 500, how many are concerned with the center?
Well, there were, I think,
I
238.
think you said originally, maybe like 228 or.
It's 228 YDRs and 31 SYDRs, but then within the center, there's also behavioral health staff. There's also medical staff. There's culinary. So those numbers are direct care staff on unit, but there's a whole host of others who obviously behavioral health, medical, education staff, our culinary, are kind of all of those who
So
surround
how
these
many are responsible for working directly with the young people who are in the 98 beds?
There's 259 between
Yeah,
the 2 facilities.
259 between the 2. I need to get the breakdown. The larger proportion is at YSC.
Okay. All right. Then I wanted to ask a little bit about the When we talk about how many young people do we have in private homes contracted out?
We have, let's see, 19 and
I think I have something that indicates maybe like 34, only 34.
no, so,
That doesn't seem right.
so I have it broken down by the type of provider. So we have 13 that are at group homes. We have 3 that are in foster care. We have 36 that are in home placements. We have 1 that's in a technical center, which is a it's actually a higher ed.
Okay, so we're
facility.
talking 53 plus more?
Plus, and then at the next biggest category is residential treatment centers. We have 19 at various residential treatment centers.
Okay, so they're not on the premises of the center, correct?
No, they're not.
All right, so 72. My total was 72. Okay. What I'm trying to understand, of those that are not on the premises, what is your staff ratio to the young person? What is the requirement?
I don't know that there is a ratio requirement for the kids that are on supervision within the community.
What's our caseloads?
I think we have high caseloads right now. I believe each case manager is carrying around between 25 and 30 cases.
So how many case managers do you have?
Let me see.
Because I guess I should not count the 72.
No, you do, because if they're committed, they have a case manager, even if
Right.
they're at New Beginnings or YSC. They
Okay.
still are committed, so every committed young person will
Okay.
have a case manager.
I'm just trying to understand what the requirements are in order to get this work done.
Sure, you want to know the numbers of what we
Yeah,
would need in
yeah.
order to be able to do this up at the front
Exactly.
end, basically.
Yeah, let me come back to you.
All right.
Councilmember Bonds, on the number of case managers. I don't want to give you the wrong
Okay.
number.
I
Well,
will say this, that one of the things that we've done in the past and that we've talked about is we have tried different things. There was a period in time in which we had committed caseworkers who were always at the courthouse. There was a unit that was there, and that helped with some of our pre-commitment work. We had a pre-committed unit that had a series of caseworkers that only did assessments. And I know that the director is thinking of having that for YLS as well, so that you have just a unit that does all of that intake. And that's what they're doing all of the time, just like the same way we have units that just do all of our TDMs or our kind of team meetings. They're responsible for scheduling and doing those. So-
right. Well, for me, in addition to just understanding your numbers and the requirements of personnel, I want to understand also the services that those young people get. Those
Yeah,
that
so the
away
community
from the
placement,
center, yes.
absolutely.
And how do you really monitor those? That would be another concern.
Yeah, so we do have community placement agreements. There are written agreements that we have with our young people that detail the requirements that they have and the services that we are
Okay.
obligated to.
And then I would want to know a little more about those that recidivate that are in those facilities. Is it higher than those that stay at the center? I don't know. And that would be something for us to look at, I'm thinking.
Yeah.
We're trying to think into the future of how do we handle our young people, those that are in great need of assistance. At least that's where I'm coming from, more than anything else. And finally, I wanted to ask about this portion of code, DC Code 24-912. And that's the use of where you seclude some of the young folk. It's happened more frequently with the girls than with the boys.
So, yeah, we have currently a fairly high-profile case of 5 co-defendants that are court-ordered to be separated. But we only have 1 living unit for girls. As we've gone over the numbers, we have a full facility. And so within that unit, we are now legally ordered to separate those kids at all times and not let them contact each other.
And how many are there that you must separate?
There's 5
5
for
of them.
that particular case. Now, we have orders for different youth in different parts of the facility that are, that need to be separated as well.
Okay, I know it's very complicated. And we're leaving that, impression with the public. And the more complications that you put on the record, the more it lends itself to thinking that we're maybe at a point where you need all the help you can get. And in needing all the help that you can get, I'm very serious.
Too.
We have to look very honestly at what's being proposed in this legislation. So that was my point.
And I welcome the assistance.
Thank you. Thank you. Thank you, Chairman.
Thank you. A few questions and then I'll let you go. Successful reentry planning requires periodic reassessments of a youth's criminogenic risks and needs. How often does the department currently require staff to conduct reassessments of youth under its jurisdiction?
Reassessments are required every 90 days.
Every 90 days.
Yes.
If the district's section 1115 Medicaid waiver is granted, how does the department plan to integrate the ability to utilize Medicaid funding for incarcerated youth into reentry planning?
So we are working with the Department of Healthcare Finance on the Medicaid waiver. And our plan is currently to utilize the reimbursable funds for the last 90 days of commitment to do medication-assisted treatment for substance use youth. We can also get reimbursement for case planning during that period of time at the end, and then also 30 days of prescription drug medications for youth post-release.
You were present when there was some testimony earlier today questioning whether the department would be ready for the process of Medicaid reimbursements. What's your response?
Yeah, I have a dedicated staff that is working as our liaison with Healthcare Finance. And we are putting together that plan jointly with them so that we can maximize the reimbursement that we can get for the district. And this is very important to me because that can free up local dollars to be used for other purposes.
How will the department know when it can begin utilizing Medicaid funding?
I'm sorry. I don't remember off the top of my head the effective date, but there are 2 different dates that we're working with. I'd have to come back to you with exactly when those effective dates are.
And how will you be able to begin utilizing Medicaid funding if the department is not setting a child's release date at least 90 days out from release?
Yeah, the release date is certainly one that we have to tackle. And the best that we can do is, and this is true for any of the youth systems that I'm familiar with, is that this is the anticipated release date. And so we should be able to get reimbursement for those those last 90 days. If there is some incident that requires us to push that date back, then we would just disallow the days that exceeded 90.
At what point is a decision made about a child's release date?
At what point is the decision made for a release?
About a child's release date?
It's when they complete their programming. So with our private providers, they have a treatment program. We do a success plan with those young people. When they complete their goals, then they will be given a discharge plan, and we work with them to bring them back into the community. And
So the decision is made by events.
well, it's made jointly with our providers and with our with New Beginnings. We do that obviously ourselves. And again, we want the release date to be contingent upon completing your goals. So that success plan is what's going to drive the length of stay, and how long you stay depends on how well you engage in the programming.
So instead of saying today, Johnny's going to be released on December 1st, it's you have these goals and Johnny will be released when he completes the goals.
Exactly.
At what point is a decision made about where the child is going to live upon release?
Yeah, we do pre-release planning, and we would be working with the family. Generally, that's where we would be placing youth with their families. But obviously, some kids are not going to be suitable to go home to their families. For older youth, we do have independent living programs. And if they want to avail themselves of that, we can put them into an independent living program, which provides them some supports and job training so that they can essentially live on their own. And then we do have a youth right now that is in a higher education program that we are supporting. And it is a technical school that he's attending.
So at what point are these decisions made, or is it again determined by events?
I'm sorry, I'm having trouble hearing, Mr. Chairman.
So at what point are these decisions made, or is this again where the decision is determined by events?
It's basically determined by their progress. So it is not something that is set in stone that we will make this decision today, because they're all dynamic factors.
At what point is the decision made about where the child is going to attend school upon release?
Once again, if they're returning home to their family, then they're going to most likely go to their community school wherever they were enrolled before. So that is, again, a decision that we would make with that family.
Research indicates that the type of facility, such as security facility, group home, community placement, that the type of facility a youth is placed in can impact their recidivism rate, which suggests that placement decisions must be made after carefully weighing both criminogenic risks and needs. What factors does the department use when making placement decisions?
So we use the YLS tool. And I think there was testimony earlier about the structured decision-making tool. That was the sort of previous version that we are trying to move away from. And that is the YLS is a risk and needs assessment tool. So it's assessing both the risks for recidivism and the needs of a youth that should be accounted for in their treatment program. Additionally, we have to look at those psychological evaluations that are done if they have any kind of diagnoses that need to be addressed, DSM types of diagnoses. Those also need to be addressed in their treatment plans.
And YLS, I believe, stands for Youth Level of Service, and that's just a type of tool that you use.
Yes.
So it could be a different tool. In fact, you used to use a different tool. How long does it take for the department to complete a risk needs assessment?
So in order to get it completed, it takes about 3 weeks to do that. It's not about just actually doing the instrument. Finishing the instrument takes an hour, but getting that information back to our contracted partner to do the quality assurance, to send it back for any updates, that's a little more time consuming. And then of course, to perform the tool itself, we have to schedule a meeting with the family and have that meeting with the youth and the family.
And what mechanisms do you have in place for quality assurance?
So as I mentioned, we actually micromanage the entire YLS process. And we have that contract. We have a contract provider that reviews every single YLS. That contract provider is certified by the purveyor of the tool to do that work. Ultimately, and as Deputy Mayor Pia mentioned, we have stood up a pre-commitment unit that is dedicated to doing YLSs. I don't want to have all of the care coordinators doing YLSs. I want specialized folks that can do that. And once they have enough experience doing YLSs, our supervisors can be certified by the tool provider to do that quality assurance work as well. In addition, we are also setting up our policy and quality assurance teams. And so we would put measures in place as part of our overall agency quality assurance process to determine the effectiveness of doing the tool, timeliness, all of the other pieces that we've been talking about.
Now, I think earlier we heard testimony that quality isn't so good. So what's your response to that?
My response,
Earlier there, we heard testimony that the quality isn't so good. So what's your response to that?
the quality of the YLS.
Yeah, or the implementation, more the implementation.
So there has been a lot of struggles with the implementation, and I did hear the earlier testimony about staff that did not want to do it. The tool that we have selected, the YLS tool, is a very good tool. And the tool previously done is not as nearly as robust. But a lot of folks want to continue using the old version of the tool, and it's frankly just easier to do. But I'm requiring them to do the YLS, and ultimately, we need to get to a place where everybody is competent and comfortable doing that.
There's a individualized treatment plan. Advocates report that such plans are rarely completed and that the list of stipulations and requirements contained in a community placement plan, a community placement agreement is often substituted in its place. How do you respond?
Yeah. So the individualized treatment plans are important. And I will tell you, in my evaluation, they haven't been as good as they should be. So this is an issue that we have detected ourselves in my own assessment of the agency's performance. We have already scheduled training and trained our staff. We need additional training. And so we have a number of training events that we are working with our staff to improve their performance on developing those individualized plans.
But I would also note that 80% of our young people are not being rearrested. So we also, like, if that's one of our baselines, then
Don't go there. That's kind of like spin. I'm asking about the individual treatment plans being implemented. So how
or you
long is
just
this-
were saying they were not very good. It was a quality question. So how we judge quality is inherently an objective or subjective. So I was trying to use an objective metric, but we will always say that it's better, right? Like you said they were not very good.
Well, the director said that he
He said there's room for improvement. Yeah.
yeah, and he also said that you're putting some, I'm gonna call it PD, professional development, in place. So how long is that gonna take?
We have scheduled, we've had several already scheduled, and we have at least 2 more already on the books. So the next one is scheduled in October 2nd. So I think it's a process. I think we have to continue to do training to improve the quality of those plans.
Director, I'm probably gonna send you a longer list of questions instead of going through them all here. And so there's just to forewarn you that that will make its way to you and we'll be looking for the responses. Does anybody else want to go for another round? I see a no, I see a no, I see a yes, one question. Let's go for it.
Thank you very much. And I know it's very late and I can see the Attorney General. I got it. Yes. The rays are coming this way. We understand. Thank you for that. My question is, I've heard so much from you tonight about, it seems like you're contracting out a lot of the work. You have contractors reviewing this, reviewing that. So, at some point, when you get the inquiry from the chairman, if you could give us an indication of the number of contracts that you have in progress and the type of service that they are providing. That's what I would like to know more about. And with no other, agenda, just trying to understand how we get this important work done. So if we could have that, that would be helpful. And that's my question. So thank you very much and look forward to working with you.
Thank you.
I did forget one other thing. Deputy Mayor Pia. Kathy Patterson testified. Talked about the Department of Health has to do environmental assessments.
Yes.
3 inspections a year. And she said, I was told by DC Health, the inspections were conducted in 2022 and 2023. Those reports have been submitted to the Executive Office of the Mayor in June. And when that's Kathy Patterson, inquired again last week, they had still not been submitted to the council. What's the story?
They were not submitted to me. I don't oversee DC Health, so I can check to see where they were submitted in EOM, but I don't have the reports, but I can check on them.
Would you please, these are reports of the Department of Corrections.
Right, but they're
So they're-
DC Health reports, so I will check to see where they are. If maybe they've been submitted to DMHHS or otherwise, but I'll check.
Okay, well, it doesn't speak very well that these reports are required by law 3 times a year. And 2022 is still hung up in the EOM. 2023 is still hung up in the EOM, so you'll look into it.
Sure.
All right, thank you for your testimony. Thank you, each of you. We'll turn now to the Attorney General, Office of the Attorney. I don't know why it says Office of the Attorney. We'll turn to the Attorney General, Brian Schwab. Thank you for your patience.
Good evening.
Good evening.
Chairman Mendelson, members of the Committee of the Whole. As you know, I'm DC Attorney General Brian Schwab. I'm here to testify in support of the Road Act. Thank you, Chairman Mendelson, for moving quickly to consider this very important public safety bill. Subcommittee Chairman Parker, congratulations on your new assignment, although perhaps after this marathon hearing, you're maybe ruing that is your assignment. But I very much appreciate the fact that this Road Act is the first or one of the first bills that your leadership will be responsible for stewarding. So I look forward to our collaborative relationship. Look, among other things, the Office of Attorney General does, and there are many things, we are charged with prosecuting juvenile crime and holding young people who break the law accountable. Prosecution is not the end of the line, though. Once a young person is prosecuted, public safety requires a systemic commitment to rehabilitation through a process designed to help that young person take accountability for the harms he or she caused, and importantly, a process designed to prevent them from committing crime again when they eventually, inevitably return to community. The available data indicates that with respect to rehabilitation, particularly for young people in the deep end of the juvenile justice system, the district is failing. The Department of Youth Rehabilitation Services, DYRS, is tasked with providing young people with the resources and structure they need to get onto the right track. DYRS is struggling. The most recent comprehensive data released by the Mayor's Criminal Justice Coordinating Council in 2022 indicates that nearly 50% of youth committed to DYRS, 47.6 according to the report, are subsequently convicted of committing an additional criminal offense, either while under DYRS care or within a few years of their release from commitment. That is not acceptable. I introduced the Road Act this past spring to try to promote better outcomes, to reduce recidivism, and to improve public safety. In advancing targeted, specific amendments to DC law, the bill is an important step to improving our system. It's not going to solve all problems, but it will close some very important gaps that have been identified with respect to our committed youth. ROAD has two goals. First, ensuring prompt, proactive, and effective rehabilitation of committed young people. And second, ensuring robust, comprehensive oversight of that rehabilitative process. Let's start with rehabilitation and what it means to be committed to DYRS. These are young people that have been adjudicated responsible for committing a crime. There is no longer a presumption of innocence. They have been committed, they have been determined after a process that they are responsible. And a judge has determined that they should be committed into the custody of DYRS. Many committed youth will be locked up in a secure facility. Once committed to DYRS, the young person is the ward of the district. And the district has an obligation to provide rehabilitative services, which along with other quality social supports are intended to help prevent the committed youth from committing future crimes. In this way, rehabilitation prevents crime and improves public safety. You have heard me ad nauseum and many others talk about the importance of addressing root causes in order to prevent crime from happening in the first place. As Councilmember Louis George alluded to earlier, by the time young people show up in the Superior Court's Family Division facing serious criminal charges, they've been failed repeatedly by so many people and systems that are supposed to care for them. We need to invest in strategies, policies, and programs that will address the underlying drivers of crime if we hope to prevent or at least meaningfully decrease the amount of crime happening. And we also have to hold young people accountable when they do commit crime. Commitment to DYRS is an opportunity not only for accountability, but also to address root causes so we minimize the chances of reoffending. Currently, youth committed to DYRS are waiting too long to get the necessary rehabilitative services they need. Under existing laws, DYRS is supposed to assess that young person's needs and develop a treatment plan to address those needs within weeks of commitment. Let me repeat that. Under our existing law, DYRS is supposed to assess the young person and develop a treatment plan within weeks. Alarmingly, DYRS's own performance plan for fiscal year 25 disclosed that less than half of committed youth, 45.3%, have a treatment plan within 90 days of commitment, 3 months after commitment to develop a treatment plan, much less implement it. That is not acceptable. Even worse, according to DYRS's own disclosures, most committed youth, nearly 55%, are waiting even longer than 90 days to receive a treatment plan. That is not acceptable. Too many committed youth are being securely detained, lingering for too long without an individualized rehabilitation plan and without the services, therapies, and appropriate treatment that they need. We must and we can do better. ROAD offers a proactive alternative. Develop a meaningful individual rehabilitation plan before a young person is formally committed to DYRS so that delay in providing services is minimized. When OAG prosecutes a young person for serious criminal conduct, there is a point during the proceedings when all parties, the young person, their counsel, OAG, court social services, and the court, they all know that DYRS commitment is the most likely outcome. This is after the adjudication of guilt. In serious cases, prior to disposition, our office puts parties on and the court on notice that we intend to seek commitment. The current practice is for DRS, however, to wait until after commitment before formally beginning the process of conducting an assessment and forming a treatment plan. That's an unnecessary and harmful delay. ROAD provides that as soon as DYRS is notified of the likelihood of commitment, all relevant stakeholders will begin developing an IRP so that it can be implemented immediately upon commitment. Road also goes a step further. It eliminates the vagueness in the current law by delineating specific requirements for creating IRPs. Road requires the use of an industry standard tool known as a validated risk needs assessment, ensures that all relevant parties, including the family, are involved in the development of the IRP, and requires the IRP to be reassessed every 90 days to ensure that it is working as intended. And if it's not, to take a fresh look at what other rehabilitative services the young person might need. I note that what you heard during this hearing is that some of those things are already being done. So it is not a massive expansion or change. It is making clear in our law what the best practices are and assuring that it continues to happen as a matter of law. Road also requires DYRS to engage in discharge and reentry planning. Another thing we've heard today they claim they're doing. Currently, when a young person is released from a placement outside of their home, there is no statutory obligation for DYRS to ensure that the rehabilitative services are going to continue upon discharge. Unfortunately, this often means returning a young person right back to the same circumstances that led them to a commitment to DYRS. Road closes that gap and ensures we are not missing an opportunity to continue rehabilitation and prevent crime. Proactive and meaningful evidence-based rehabilitative planning is the first key pillar of Road. Equally important and critical to ensuring the success of that planning is robust oversight and transparency. Delivering effective rehabilitation to our young people is not easy. Young people come to DYRS and they are often dealing with complex trauma, disabilities, educational failures, mental and behavioral health challenges, substance abuse issues, unstable housing, unsafe communities. The list goes on. They are often oppositional and resistant. It takes skilled, trained professionals to address the trauma, meet the needs of each individual child and their family, and help empower them to make positive changes in their life. DYRS has a weighty responsibility. It must ensure that the youth that the system entrusts into its custody receive the services and support they need to make sure they don't commit crimes again. It's critically important that DYRS, that all of us get it right. And transparency and oversight, especially on such a complicated and difficult issue, and given the unique history of our city, are key to getting it right. The system as designed is opaque, as this hearing has revealed. Road provides oversight and transparency from three sources: the court, DYRS itself, and an independent third-party agency, and I want to address each briefly. First, the court. Currently, a young person who is committed to DYRS and who is not receiving critical rehabilitative services must wait 6 months before petitioning the court to review the services and placement DYRS is providing. This is too long. Road would reduce that time down to 4 months. This shortened time frame would still allow DYRS a reasonable time to, for example, identify a new service provider or switch therapeutic placements or reassess and update the young person's IRP, while allowing for timely judicial review if DYRS fails to do so. Second, DYRS. Currently, DYRS houses committed young people in several different facilities, including New Beginnings and YSC, both of which are owned by the district and operated by DYRS. Many young people committed to DYRS, however, are not housed at either facility. Many are securely detained in other residential settings, including residential treatment centers, psychiatric residential treatment facilities, therapeutic group homes inside and outside the district. For all of those placements, DYRS contracts with private or other state-run congregate care facilities. Our understanding is that DYRS only monitors New Beginnings and YSC. Director Abbott told us today that is not true and that they are, in fact, monitoring facilities outside of the city that they are contracting with. Again, Road makes clear what the director says is already happening, that DYRS has a duty to ensure that everyone in its custody, not just those securely detained in district-owned facilities, receive the same minimum standard of care and safety. Road would make clear that DYRS is required to conduct oversight of any facility where it or the court chooses to place a child. Finally, Since 2020, the district has relied on the Office of Independent Juvenile Justice Facilities Oversight to conduct investigations and issue public reports on DYRS, including, for example, detained youth population reports, evaluations of medical and dental services, documentation of critical incidents and assaults within the facilities, and staffing levels and deployment reports. That independent office's existence has periodically been threatened, even though the need for DYRS transparency and accountability has never been more vital. Fortunately, the council adopted emergency legislation to continue the office earlier this year after it otherwise would have sunset back in January, and then through the fiscal year 25 budget, placed its functions within the Office of the DC Auditor and provided for it to continue its independent oversight role throughout the coming 2025 fiscal year. The ROAD Act would permanently establish the office's functions within the auditor's office and expand its mandate to ensure that council and the public continue to have reliable information about whether and how DYRS is handling its critically important rehabilitative functions, as well as the data necessary to evaluate future needs. Committed youth spend far more time in the supervision and care of DYRS than they spend interacting with MPD or OAG. DYRS plays a critical role in our public safety infrastructure. It carries the weighty responsibility of rehabilitating district children who, for a variety of reasons, are in the deep end of the juvenile justice system. All of government, my office, you and the council, the executive, should all be aligned in making sure that DYRS performs its crucial functions as effectively as possible. Public safety in the district now and into the future depends on DYRS getting it right. ROAD is a roadmap to help us improve the care and rehabilitation of district youth. And by doing so, maximize the chances that committed youth, after their commitment ends, never find themselves system involved again, whether that's the juvenile delinquency system or the adult criminal justice system. I urge the council to pass ROAD.
Thank you, Mr. Attorney General. 10-minute rounds. Let me see. Want some notes. I want to ask about this risk assessment. So you were here and heard some of the testimony on that. I thought it was a little bizarre to say they want to do a risk assessment on everyone upon intake, regardless of whether there's going to go forward with any sort of a prosecution. Let me see. In your statement, you said the current practice is for DYRS to wait until the after commitment formally begins before conducting an assessment and forming a treatment plan. That is an unnecessary and harmful delay. But should it be at intake?
No, and that reflects a misunderstanding and maybe a confusion for the council on the way the process works. Intake is a process when MPD arrests a child. That first appearance in court, there's decision-making that has to be done at the front end with respect to the detention of that child and some of the charging that goes on at the front end. It is a quick process that is done at the front end, and many young people who show up in the criminal justice system at the front end are going to be diverted out of the program. Maybe the charges won't be brought. There are a lot of initial decisions that are made in relatively short order. The longer term rehabilitative work that we're talking about that needs the assessment work is after it's a determination that the child actually committed the crime, is going to be held accountable for the crime. And we're focusing on a later process, later time in the process, which is after the adjudication, after there's been a determination of responsibility, which is the guilt finding, and that gap period before disposition. There is a period of time in our system where we know or have a very high likelihood that the young person is going to be committed to DYRS, given the severity of the crime, given the severity of the harm, and given that there's been either a plea or a finding of responsibility. To the hearing at disposition, where the juvenile court, the family court, makes a decision of whether to commit the child to DYRS or put a child on probation or make some other decision. The system actors, everybody you heard from today, PDS, Our office, the experts, the academics, the field knows that there is a point in time in the process when everybody knows commitment is coming. And what we're suggesting with Road Act is we don't have to wait till the disposition hearing when that commitment order is entered to start doing the work that it takes to get a treatment plan in place. And that's what Road Act is focusing on. Let's take advantage of that period of time to have the assessments done, the ones that take more time, that involve more input from family and others, candidly, that involve a situation where whatever defense, PDS, and the defendant may have had beforehand have been resolved because a finding has been made, and get them focused on what their treatment plan will be. If it takes some time to do it, take advantage of the time we have predisposition so that a plan is in place and that when commitment happens, DYRS is ready to start implementing that plan immediately rather than delay. We're talking about doing the same work, but we're talking about doing it before commitment rather than after
And
commitment.
there
Now,
was testimony that that's what DYRS used to do, but you heard the deputy mayor, she was quite clear. No, she wants to do that for everybody at intake. How long do these assessments take? But the director said 3 weeks, 4 weeks?
well, I think you break down the component parts of getting it done. There's a time period for getting it scheduled. And these assessments are important to interview the child and the family and other people. And that process of a meeting may take several hours. And so maybe it takes a couple days to get the family and the child together for a meeting to do the assessment. We think that can be done within 72 hours. That's what the Road Act is proposing for children who are in detention at the time. We know where the child is. We know, we can bring the people together to do the assessment tool. Then it takes some time with the basis of that assessment tool and other reports that are in the file at that point to develop a treatment plan, a particularized, tailored rehabilitation plan. So those are the components. The plan is the product of having the assessment done.
Well, there's a risk assessment. You think that can be done in 72 hours? And the director said 30 days, and then he said 3 weeks, but he sort of stood by his 30 days. But you think 72 hours?
To have the meeting.
No, the risk
Right.
assessment,
Right. The
which
risk.
is the meetings
the ri-
as well as then analyzing all the whatever and coming up with a risk assessment.
The risk and needs assessment that we're talking about this time can be done in
The risk
72
needs.
hours. Yes. And if there's some delay in terms of pulling together the family and the child and the professionals to do it, that's where the delay can happen. The assessment tool, the meeting and the use of the tool is a 5 or 6 hour process.
You heard the exchange between me and the deputy mayor where she says they don't have any authority to do it before they get the commitment. And I thought that was a little strange. I asked if they had talked to you. They said, well, the juveniles under the custody of the court, which doesn't sound quite right to me, are court social services, and therefore DYRS has no authority. What was your reaction to that?
Well, from a literal sense, under the current regime we're in, that's true. But that doesn't mean that there can't be, as you suggested, MOUs between agencies to change the process and to see who's working at which time. I do think it's important to keep in mind, though, that in our system, there's a very big difference between a young person who has been accused of a crime and maybe has court social services monitoring, supervising, keeping an eye on them pre-trial versus a young person who's been determined to be responsible for committing a crime. And so I think we're going to run into some serious issues about starting to build a rehabilitation plan when young people haven't yet even been convicted of committing crimes. The rehabilitation comes in part when a young person has to take accountability for the crime, acknowledging, or at least has been determined to have committed the crime. There are young people who are arrested who didn't commit the crime. There are young people who are arrested and charged, but the case is gonna be dropped because for whatever reason, witnesses don't come, evidence isn't available. Can't prove our burden of proof. So those are not the young people we're focused on. And when I used in my testimony, quite literally tailored and narrow group, we're talking about those small number of young people who are in the deep end of the juvenile justice system, who are likely going to be securely detained, who it's imperative that we put in a tailored rehabilitation plan for.
There's a notice of, I think it's called a notice of commitment.
Notice
This is
of intent
before
to commit.
Notice of intent to commit. That's issued by your office or the court?
I believe it's issued by our office, but it may be court social services on time. I can ask
No,
my
I'm not sure
colleagues
that
there.
matters so much. Do you know how long that notice is?
How long it is?
Yeah, and I don't mean like it's 3 pages. I mean, is it like 30 days, 1 week? Do you know how long?
Yeah, it depends on each case. It depends on what work needs to be done
Sure.
to actually schedule a hearing. And I think you heard PDS talk about what they do in preparation for that disposition hearing and how they want to make sure that when that hearing ultimately takes place, all of the information necessary to make their record and make their arguments are available. So I believe one of the PDS witnesses talked about it generally being scheduled for 3 weeks or so down the road, but oftentimes they come to that hearing and then they ask for more time because everything isn't there and it gets kicked out another 3 weeks. So the actual time from intent to commit, notice of intent to commit to disposition hearing is variable. But it's somewhere, I would say, probably in the 3 to 6 week timeframe.
You also have in your statement, you talk about how in the Road Act that an individual can petition the court after 4 months. Not getting services can petition the court. Right now it's 6 months. Road Act proposes 4 months. PDS said 3 months. What do you think?
Well, we talked to a lot of experts beforehand. We understand their practical constraints when you set timeframes and time limits. And in the exercise of our judgment and discretion, we thought 4 months seemed like a good compromise. I'm not surprised PDS wants it more frequently. I would be surprised that they didn't advocate for that. That's part of their job. They do it well. But we thought 4 months was the right timeframe.
Give me just a second. Councilmember Parker.
Thank you.
Thank you.
Good to see you again, Attorney General. And I wanted to start with this definition of recidivism. I thought it was quite interesting that we heard today, oh, our recidivism rate is only 28%. I think that was the number that was thrown out. I'm not going to get into the weeds of how one defines it or not, but it is my understanding, and I'm asking if this is a shared understanding, that 92% figure includes new arrests for new charges as well as violations of current charges. So you can't go here and you get caught here, you get rearrested. That's all in that number. But then there's a 70% roughly number, if I'm not mistaken, that is made up of new arrests. And then there's a roughly 50% number that the chairman cited, which is a shared understanding here of that is the number of new arrests for new charges. Generally, is that your team's understanding? Because I'm really not clear where we got 28%, which it sounded like the deputy mayor and Director Abbott is defining as new arrests for new charges when you're out in the community after a given period of time, which seems like a very narrow definition.
So I think your observation about splitting hairs and getting caught up in a definitional debate is important because we can get distracted from what we're really talking about here. The best data we have is the longitudinal study that the CJCC published in 2022, tracking a cohort of young people from the time of their commitment in 2018. Recidivism, by definition, it has to be a longitudinal look at how young people do. After they've been committed, after they've allegedly been rehabilitated, do they stay out of the system or do they come back into the system? And CJCC recognized that to try to track that across different systems, it was important to get the system, the terms defined in a uniform, consistent way, to gather the data in a methodical way, and to look at it over a period of time. This is the mayor's CJCC publishes these numbers.
Great point.
So that's the best data we have. I don't know where DRS comes up with some lower number. I don't know over what period of time they're using. I don't know what definitions they're using. CJCC looked at whether a young person picked up a arrest as a young person while they were still committed, as a young person after they were committed, or as somebody who was in the adult system. They're looking at a set definition. When they did that, they also looked at arrests, which can be over-inclusive because people can be arrested but not convicted of a crime. But the lower number that we're focusing on is the conviction rate, which means there was a process of admitting or proving that a new crime was committed. That number of around 47% for committed youth is in stark contrast to the same methodology that was used for young people who were diverted to ACE, less than 15%. DDAs and DPAs and consent decrees, less than 16%. So the committed youth are committing crimes and getting convicted of those crimes 3 times as frequently as the other tools that are used in the prosecutorial. Now, I'm not saying that we don't need to talk about DDAs and DPAs and the ACE diversion program, but the ROAD Act is trying to focus on a real concrete problem we have, which is kids in the deepest end of the criminal justice system who have been committed to DYRS, and at close to 50% of the time, according to the CJCC's longitudinal study, are getting convicted of
Yes.
committing a new crime.
I think that is a very powerful point and is the crux of what we're talking about. And it, to me, points to what we're doing is not working. And what we're doing at DRS, we know is in large part not providing young people services, not moving them to placements, not supporting them in the ways that they need supporting. I want to keep moving. Your response to the chairman in terms of when the risk assessment is implemented, when does the 72-hour clock start? So I took from the deputy mayor's response, that clock would start upon arrest. It seems like you're suggesting, no, actually it's between the disposition and them actually being committed.
So our terms are clear. The notice of intent to commit triggers a time period to a disposition hearing. At the disposition hearing is when a judge is going to decide, yes, I'm committing this young person into the custody of DYRS, or I'm going to use a
And
different.
when does the clock start for the risk assessment?
What we were proposing in the road is that within 72 days of the notice of intent to commit,
72 hours.
sorry, 72 hours. Thank you. 72 hours of the notice of intent to commit if the young person is locked up.
I got it.
A little bit longer if the young person is in community, at home. There are sometimes other terms of the period before commitment that are controlling where the child is and what those terms are. So shorter period of time if the young person is locked up, a little bit longer if they're in community to start that process, to have the assessment made.
That's clear. And the deputy mayor's response that, well, we don't have jurisdiction doesn't stand up because they would be in DRS's custody at that point at the notice of intent to commit. Is that correct?
Well, if the young person is being securely detained at YSC, they certainly are in the custody of DRS at that point. When we have in the process a finding of responsibility, the adjudication has been made and commitment is inevitably or very likely going to happen, the basis for DYRS starting to have its jurisdiction over the child is different than at the very beginning of the process where the deputy mayor was suggesting at the threshold intake, DYRS should get involved.
So let me just go further there. So there are some young people, I would imagine, there's a notice of intent to commit, but they're still in the community. Is that fair? Maybe they're being monitored. You're suggesting DRS still has the capacity, the jurisdiction to engage with that young person, even if they are not in the facility at YSC.
I believe so. And to the extent that there are legal MOU or other things that have to be done to make clear that that can happen, we can do that. But I believe, and I believe PDS acknowledged today that they know that in that lead up to commitment, their clients are going to have to engage with DYRS to start to develop what the plan is for their client when the client is committed to DYRS.
Got it. That is super helpful. What influenced your decision to direct the Office of Independent Juvenile Justice Facilities oversight to the Office of the Auditor? And a second follow-up question there, I'll let you gather your thoughts. I know it's been a long night. My colleague and I were over here talking like, could the that oversight office be with the Ombudsman for Children's office if the auditor isn't thrilled to have it, and perhaps there may be concerns about conflicts of interest there?
So I think that the facts on the ground of what we were seeing happening in our city generally with public safety and with youth in particular coincided at a time when post Jerry M and the independent office was set to sunset.
Yes.
And the community and the council, and I fully agree that this is not the time to sunset this very important independent organization.
I think it is fair and clear to say that the mayor is not a fan of this office. I fully support protecting the office. I guess my question is just more so, is there a reason that it has to be the auditor? Are you wedded to that, or are there other versions that we can have this office function in relation to another agency, i.e. the Ombudsman?
I'm not wedded to anything when it comes to the way in which this oversight, this independent oversight is done. And I think that what may be suggested from this hearing is, given the law in place now and the report that's going to come from Mr. Jordan, that maybe there's a basis to wait and reflect on what the report tells us about where we put that independent oversight function. As with any oversight, it could be in multiple different places. I will say this, the reason why I thought it was important to put it into the Road Act is, one, we were proposing Road Act in the spring, and that was before some of the subsequent budget work got done to put it where it is and to cover it for the year. It is extremely important that we have it, and we have in the current office a track record of doing the work for several years. We have expertise built up in that office. We have the unique fact that it involves public safety, it involves young people, and it follows on the heels of a consent decree. And there was a practical administrative ease to tuck it into the auditor's office. It has worked well there. I think that the auditor's office plays a very important role. It is a tool of the council. It is an ability for the council to leverage what it can do with the resources it has. And so I think it works there. I appreciate Auditor Patterson's concerns about resources and telling her how she has to do her job and things like that. But at the end of the day, as she acknowledged, she is a creature of this council's discretion and judgment about how to use the auditor function. And I don't think that there's anything inconsistent with having an auditor that has general ability to do ad hoc audits on other things in the government. But when it comes to our juvenile justice facilities, have a very prescribed mandate, scope, and expectations of what would come from that. And I know you can make the argument, well, what about all the other agencies that, need oversight? And, does this mean that the council doesn't have to do its job on oversight? And I'm not trying to take on all of that rest of the stuff.
Yes.
We have an acute problem right now.
Yes.
And in my judgment and I've made it very clear, and as the Attorney General, we will hold kids accountable. It's part of our job, but let's hold ourselves accountable too. And if we're going to commit young people into the custody of the DYRS, we got to make sure that when we have that relatively small number of kids with this intense period of custody, that we do better by them. And I think oversight, independent, transparent, regular, meaningful oversight is going to be essential for us to get to where we really need to go on this issue.
Fair point. Thank you. I am over time. I would just say I too reject the premise that creating an independent office or maintaining an independent office somehow undermines, impinges upon the council's responsibility of oversight. But thank you for that.
Thank you, Councilmember Parker. Councilmember Lewis-Drake.
Thanks. AG, thank you for being with us today in this important legislation. in addition to working with DYRS, there's two other entities here that are important, which is Court Social Services and our DC Superior Court Family Court. What, if any, conversations and commitments did you have from Court Social Services and DC Superior Court as far as implementation of the Road Act? Sort of what did that look like?
There are no commitments from the Superior Court or from its Court Social Services Division. And as we've talked about many times, you know, one of the real challenges we have in this bifurcated criminal justice system that we live in here in the District of Columbia as a byproduct of home rule and our absence of statehood is that we have federal partners that we have to work with. We have split jurisdictions and the council has no ability to dictate what the Superior Court does or what Court Social Services does. But the recognition behind this is that the practice that is in place right now, the role that Court Social Services plays, and we have an excellent partnership with Director Odom and her team of probation officers, is not going to meaningfully have to change to make the Road Act work. The Road Act has been out in public since the spring. There's been no objection from the Superior Court or from Court Social Service. In fact, there's been no objection from anybody except our executive on this. Every actor that plays a role in our criminal justice system for young people, the advocates, the prosecutors in our office, the defense bar, the academics who study this, the advocates who are in this space are in favor of it. You're hearing one lone voice that says they oppose. And for reasons that are not central to what we're really talking about the narrow issue about kids in the deep end and making sure they have tailored rehabilitation plans as soon as possible so we maximize the chances that we actually can get an effective rehabilitation plan implemented and reduce recidivism.
Yeah, absolutely. I appreciate that. And I would imagine Court Social Services and DC Superior Court Family Court would see a benefit from the Road Act and helping them as sort of they have to execute their part of the mission as it results our young people. Right now, DYRS fails to produce individual plans for committed youth in a timely manner about half the time. How do you all plan to sort of enforce DYRS adherence to the new standards for individual rehabilitation plans?
So not to be too technical, but DYRS doesn't have treatment plans in place for close to half of the youth at 90 days. Okay. The statute, if you look at the time periods in the current statute as to when they are expected to put a treatment plan into place for a young person is generously somewhere between 24 to 30 days, depending on how much leniency you give to when Court Social Services gets them the materials. So when they, in their own performance report, this is not a CJC data thing that they can kind of quibble with definitions. Their performance report tells you that at 90 days, 46.3% of the youth have a treatment plan. That means 55% have no treatment plan at 90 days.
Right.
All right. So that's where we are right now in terms of their ability to, they're meeting their current statutory obligation. How do we get DYRS to do it? Well, part of it is understanding through, I think, a good back and forth oversight process is what are the obstacles? What obstacles are you finding to getting this done? You ask good questions today. Is it a resource problem? Did we give you enough budget? Do you need more people? No, gave us plenty of budget. Okay, well, do you have the people in the right place? Maybe you don't, maybe you do. Do you have a problem with getting people to come to work? The idea when an agency has a statutory obligation to do something and isn't doing it would be for the council to ask the question, why isn't it happening? And there could be very legitimate reasons why it's not happening, in which case the council could say, we can help you with that problem, or my office can help you with that problem, or the court can help you with that problem. But the idea is not to play gotcha with DYRS. We represent DYRS. Our civil litigation division is working regularly with DYRS to deal with other exposure issues. Our prosecutors want to work closely with DYRS. So this is not an attempt to set them up so we can say, hi, you're not doing it. It's to hold them to the standard that the district residents and families, all of us deserve, to make clear what is expected of them, and then have an oversight process so that when we have clear data and understanding of what's happening, oversight, as often as you all want to do it, might be informed by, look, we're seeing that you've brought those rehabilitation plans down now so that 75% are being done within 45 days, but it's still too long. Why aren't they down to the numbers we want? And maybe you'll hear, we need some help on X, Y, and Z.
Yeah, I think the other point there is consistency as well, because as leadership changes, things change in the agency, which we also heard today. And by codifying some of the things that maybe a new leadership is doing right now, it means when that leadership leaves, those things don't change. That consistency, I think, is key and important. We talked a little bit about some of the reasons of the delays and what takes them so long. I just wanted to ask you, we talked about some of the analysis that happened, getting a psychoeducational and getting the child guidance clinic, CDC to do these things. Do you all on the diversion side of things have the ability to request psychoeducational analysis and things early on, if a youth is diverted?
So we probably have the ability to ask for it, but as a practical matter, those prosecutorial decisions, as you know, are made oftentimes by MPD. So MPD diverts young people.
That's right, that's right.
And so there's some decisions of diversion being made by the police force. Our prosecutors, looking at the level of offense, the criminal history, other factors that are available to us, can make some decisions about diversion at the front end. And a detailed psycho-emotional social history is not usually necessary to make that kind of decision. And I also don't think that it's necessary for us to, do the work that we're doing. But I don't know that there's any prohibition on if we felt like we needed that, asking for it. Resources, time, the decisions that have to be made, implement all of those prosecutorial functions.
That's right. Okay. I think that's all my questions. I'm going to give you back 2 minutes and 24 seconds. Did I get a gold star today, Chairman?
Yes, you always get a gold star. Because you represent Ward 4. Uh-oh, now I'm in trouble. I want to go back to this. So notice to commit. Is that what the bill refers to as a recommendation to commit?
I'm going to ask my colleague Sarah Como to walk through some of the specifics of the detail, if you would.
Sure. So when a notice of intent to commit is issued by the court, what will happen is at a hearing, our office might say in the court hearing, Your Honor, we want to notify the court of our intent to seek commitment at disposition.
So
And then
which comes first? You just said when the court issues a notice to commit, then your office will issue or will respond by saying we intend to recommend a commitment.
We notify the court of our intent to seek commitment at disposition. Court social services can also does tell the court, we recommend commitment at disposition as well. Then all the parties are aware and the court can issue a notice of intent to commit and DYRS gets notified that in this particular case, the parties are seeking commitment at disposition. And at that moment, the moment DYRS is on notice of an intent to commit, the timelines in Road Act would start like a waterfall. That's the moment that sets the timelines off.
Oh, that's not what this says. I'm being very precise.
Okay.
It says, following the court social services or the Office of the Attorney General's notice to the division of its recommendation to commit. So that's not the court issuing it. That would be you or CSS issuing it.
So what happened?
And the phrase notice to commit is the same. When we're saying that, we are saying the same thing as the recommendation to commit.
So what happens practically right now? We are recommending to the court, to the division, notice that we are seeking an intent to commit. So I think this,
Could
we
be
might be,
noticed
we
if-
might be getting stuck on semantics here practically versus,
Well,
so
when we're drafting, we have to be stuck on exact words. So notice or recommendation are the same. Notice from you or recommendation from you is the same.
we provide notice of our recommendation to commit.
Okay. And the court social services may do the same thing.
Yeah.
Separately, the court will issue a notice.
The court then would, I don't know if they, the court's issuance of a notice makes our notice of recommendation of intent to commit official. It's just the terminology.
Oh, I have to
Horrible
know.
here.
Okay, but understand, and maybe it doesn't have to be resolved right now, but when we draft legislatively, we have to be precise. what we mean.
Absolutely.
Is there anything in the statute that requires this?
No, currently,
This is just practice.
yes.
Okay. And I think I asked this earlier, there's no time requirement here. You could recommend a commitment today for a hearing that gets scheduled next week, or you could recommend a commitment today for a hearing that gets scheduled a month from now.
So what'll happen is that after a young person is adjudicated and found involved in a delinquent act, there will be, one of the parties will indicate their notice of a recommendation to commit to the court. And once that happens, regardless of if that process happens, once a kid is adjudicated and found involved as delinquent, the next step is for the court to set a disposition hearing. So the kid is found involved, there is a moment where either court social services or our agency will notice of our
Yes.
intent to make a recommendation to commit. The court will issue an official notice of intent to commit. A disposition hearing will be set.
There are no timelines prescribed in the law for this.
For the amount of time to go to disposition?
For the time for you to issue your recommendation, for the court to issue a notice of
No,
intent to commit, for the
Correct.
court to schedule the disposition hearing,
Correct.
disposition hearing,
correct.
no timelines. Okay. But all this is after a decision to adjudicate. And excuse me, after decision to adjudicate.
After the young person is found involved in the alleged
Yeah, isn't the
delinquent act or
phrasing,
entered into a
isn't the phrasing the youth is adjudicated
adjudicated
as
as
involved?
delinquent, found involved? Yes.
Yeah. So the way this is written is the department would have to do the validated risk needs assessment within 72 hours of the recommendation to commit. Now, earlier, when I was probing the deputy mayor, I was sort of getting at, why would you do more of these assessments than you need to? But wouldn't it make sense to tie it to the court's decision, the adjudication? Regardless of whether you're going to do a recommendation to commit? Because that is a finite, not a finite, it is a finite date.
It is. The reason we decided not to do that is because there are multiple cases in which there's no intention to ever seek commitment. The disposition that's going to be sought would be probation. And the period of time for probation might vary, or it might be at issue or
And there's no
contested.
value to
So-
the risk needs assessment.
No, because Court Social Services is the agency that supervises everyone on probation. And so this bill does not address the practices of Court Social Services for kids in supervision. This simply addresses what happens to young people when they are committed to DYRS, not for the probation process.
Okay. Well, my staff's going to be working with your office, but I would be more comfortable. I'm uncomfortable with the 72 hours. Director Abbott did kind of sway me a little bit on that point. So I'd like to have some prescribed periods. I'm not quite sure what that is. And I don't know, he said 3 weeks, he said a month, maybe that's too long. He said, they've got to do these, set up these interviews, and then they have to do their quality assurance. That's kind of,
We certainly can walk through and explain why these are practical deadlines that we've proposed. The language is for detained child, 72 hours to perform the validated risk needs assessment.
what is
To
performed?
perform it, That's getting the family and the young person and counsel together, having a professional who knows how to use the YLS assessment tool and doing it. And
And I
then
think-
perhaps writing up the findings. It doesn't mean
Completing.
well,
It doesn't mean completing.
it doesn't mean that you've completed the treatment plan that that assessment is going to inform. This is a key data point that's going to go into the tailored plan. And I didn't hear testimony from PDS or Professor Ferrer or anybody else that it couldn't be done. At one point, Director Abbott said it takes an hour to do this. So the idea that it's going to take a long time to do the assessment, I think we'll sort that out with you, but we're not looking to create a timeline that can't be met. But in developing this legislation and talking with the experts about what actually happens, getting an assessment done, the time-consuming thing about getting an assessment done is scheduling the meeting with the child, the family, the advocates, and the professional that's going to use the YLS tool to do the assessment.
Now, there's also the requirement of no later than 2 days before the dispositional hearing, provide the completed individualized rehabilitation plan.
Correct.
And without knowing what the time period is between the notice from the court and the date of the hearing, it's a little squishy what that means. 2 days before when I say squishy, what it means, I mean in practice.
Well,
So the dispositional hearing could be a week from today.
in practice, the parties are going to stand before the court. The judge can say, I've just adjudicated this young person guilty of armed carjacking. And there's a notice of intent to commit. We all know that I'm not going to be releasing this kid on probation. This is a kid that's going to end up being committed to DYRS. I now need to set a disposition hearing. What do you all think? Well, we know that risk assessment is going to be done in 72 hours.
He really wants it 72 days.
It's late. You kept me here late tonight. 72 hours.
He asked all the questions.
We're then going to take the data from that assessment. We're going to gather the other materials we have in the file, and we are going to develop a treatment plan, a tailored rehabilitation plan for this young person. We think, Your Honor, it's going to take us 3 weeks to do that. Could you set the disposition hearing for 3 weeks and 2 days? Judge is going to look at her calendar and she's going to say, okay, I'm going to put it down for a month from now. We'll have a disposition hearing, make sure the rehabilitation plan's in place, make sure it's circulated 2 days. I want to see it 2 days before the hearing, and we go. That's the way it's going to work in practice. Somebody says, you know what, Judge, for some reason, we're totally backed up on these things. I can't get it done in 3 weeks. It's going to take us 5 weeks to get the rehabilitation plan. The judge can say, okay, I'll give you 6 weeks, set it for 6 weeks, which is what PDS told you today is happening anyway. They're showing up on the 3-week disposition date. Everything isn't there, and they get a 3-week continuance to come back, and hopefully at that point, everything is assembled so a decision can be made.
That's helpful. Anything else?
Okay. Wanted to come back to this underlying point that has been brought up before. You discussed the laws that are already on the books, that they must have this treatment plan within 90 days. DRS is already not doing that. I totally get the value of codifying within law what our expectations are. I'm also fully persuaded that these are best practices and make a lot of sense. We may debate about the numbers, but generally we should hold DRS accountable to providing these services and plans. I guess what I'm not convinced of is what's going to be different a year from now because of this legislation, because we already know what's in law DRS is not honoring. What's going to be a trigger within the ROADA Act to make this different? And yes, there is going to be highly effective oversight, but is the value here that we are merely codifying higher expectations in the law, or do you anticipate something is going to change in practice within the facility?
Well, right now, the statute doesn't prescribe with the level of specificity, timeframes, and specifics about who is involved in the planning and what it's based on. And so we're going to eliminate there being any ambiguity about what's expected. We're going to codify and we're going to remove that as a potential excuse for why things aren't happening. We're going to create an oversight process for gathering data in real-time information to make sure that if DYRS isn't doing what it needs to do, that we can promptly address that through an oversight hearing or through some public roundtable or something to try to address and fix the problem. And again, my conviction is that DYRS wants to do better. It's got a director that acknowledges it's not doing as well as it can. He points to progress. And so we need to continue that progress. And without being too reductive about it, I just don't think we want to be a government that says, no matter what standard we set for ourselves, we're never going to meet it. So why set the standard?
No, I agree with that.
And so that's really like, we have to set the standard. We have to be clear about what is expected. We have to have oversight. We have to hold government accountable and expect that we are going to get back to the place which we heard in this testimony not that long ago. This agency was doing better in terms of the timing and the delivery of rehabilitative assessment and plans.
What do you say about the deputy mayor's assertion that the courts may not have the capacity to move their intervention timeline from 6 months to 4 months? Your legislation moves up the timeline where the courts can intervene if a young person is not receiving services. The deputy mayor suggests, well, they are already backlogged. They don't have the capacity.
We have a lot of challenges in our democracy in being able to have access to the courts. And so many rights and so many things that are critical to democracy and to our community depend on having access to the courts. And we are, no question, handcuffed by Congress's failure to help us fill the vacancies on the Superior Court. So we have to continue to advocate. And I believe we have allies on both sides of the aisle on the Hill who want to see public safety improve. And we need to keep continuing to urge that Congress allow us to have a fully employed set of judges on the Superior Court. So we'll keep doing that, and I'll keep doing that. You know, if it's important when you have a child languishing in custody without a plan and you need redress, you have to be able to go to court. And I don't think any of the Superior Court judges are going to say, you know what, it's okay for that child to languish for 2 more months because I'm so busy. Our judges work incredibly hard on emergency matters when they come in. And I can't imagine there being many kinds of emergencies that we want to try to make sure don't happen than this type of emergency, because in the long run, there's more work for the Superior Court. When we don't deal with these issues, we create cycles, we create more cases, more work. So I believe the leadership of the Family Division, the Superior Court judges, the Chief Judge, they recognize that, yes, there may be some front-end work associated with having to make sure that if there's a lingering child beyond 4 months and they're not getting what they need, want to hear it, want to make sure that we can fix it if we can.
PDS, to your earlier point, suggested 3 months. That's their job. Any reflection there? You're sticking with 4 months, which is in the legislation, or are you open to moving it up to 3 months?
Look, I'm not going to die on the hill of 3 months versus 4 months. I do think you have to try to shorten up the current situation because one shot at it every 6 months is too long. There are practical issues. If you find a certain treatment plan is not working, you've got somebody at a particular facility and it's not working, particularly if it's an out of state, and you need to now find some alternative. I don't know that, you know, we can say 90 days, it's going to happen in 90 days. So my sense is, as a practical matter, 120 days, we should be able to get it fixed. We should not have that problem lingering for that long.
Got it. And your legislation also suggests that the courts can intervene with the expectation that within 30 days, a young person should have received services. When does the clock start on that? Is that also after the notice of intent to commit, or is that after they are actually committed at YSC?
I think we're talking about at YSC when they have been committed.
Got it.
And they're not receiving what they're supposed to receive. And ideally, what RODAC would have is when they are committed, there's a rehabilitation plan ready.
No,
right
I
then,
get
right?
that. But what we heard from Eduardo and others is, well, there are young people that are sitting there awaiting being their time to be committed for months, and they're not receiving any services. Although the deputy mayor said everyone receives services. So frankly, I just don't buy that. But just to be clear, for that timeline, the 30 days, that's after they've been committed. So technically, they could sit there 4 months waiting to be committed, but once they are committed, that's when that clock would start.
That's correct.
Got it.
And I do want to clarify because I believe it was in the written testimony, some suggestion that there's like a provision that youth are going to be released if that doesn't happen. That is not what is prescribed in the Road Act. There's no suggestion that there's this get out of jail card free if you haven't gotten what you want. What it says is there's going to be an appearance in court and DYRS is able to show for good cause why something hasn't happened. There's no automatic release being
And
provided.
that appearance in court is the same or different than that 4-month intervention from the courts?
That's what we're talking about.
But that is that
The same,
4-month
the
intervention.
same mechanism that the Road Act says is.
But that judge could say, Brian is not receiving services to release him.
I don't think that that's likely, given the way our judges are approaching these issues. They may say to DYRS, I want to have eyes on why we don't have a treatment plan in place. I want to understand what's going on. I'm going to have a status hearing tomorrow. I want you to come back and tell me what you're going to do. And we are seeing that. The judges are doing their job of riding herd on DYRS getting things done. That's really what this is. It's not a get out of jail card free. We've got a real issue here. We need some judicial eyes on this to try to make sure we fix the problem.
Understood. And my interpretation was not that it was a get out of jail free. I want to end on this point. I asked it earlier. To me, it seems illegal for us to hold indefinitely young people, whether or not they're waiting commitment or not. I would ask you, the district's lawyer, what is your interpretation of what is playing out in practice at DYRS, which is, as I understand it, there's an indefinite time that young people can be held. Then while they're being held or even after they've been committed, they're not really receiving services. There doesn't seem to be access provided to advocates, lawyers, others, especially at group homes and some of these auxiliary placements. I mean, what is your interpretation of what is happening? That, to me, that seems illegal, but I'm not a lawyer.
So I think it's very important to separate out the time period before there's been an adjudication and the time afterwards. Before there's been an adjudication, if a young person has been accused of a crime and is being securely detained, there are very prescribed timeframes by which that young person is entitled and required to have a trial. Sometimes as quick as 30 days, sometimes as quick as 45 days. So we don't have a problem of many young people languishing before they're adjudicated responsible. Where we have a problem is some young people are languishing post determination, waiting commitment or waiting placement. And those are other issues. Now, I don't want to speculate too much about the legality versus what's right or wrong. And really what I'm focused on is how do we improve recidivism rates? Because whether it's legal, whether it's constitutional, whether it's best practice,
but what I'm getting at,
the longer they linger without rehabilitation services, the higher likelihood that they're
absolutely. So why not put a stake in the ground in this, as we mark up the bill, why not put a timeline? Tell DYRS you must place or commit this young person within X period of time. Because right now, what I'm understanding is a young person could sit there for 6 additional months while DYRS says we're figuring out their placement.
I'm happy to think more about that, Councilmember. I will say this, there are certain practical constraints on placement. We need to have a conversation in this city about whether we're going to create, build, and support our psychiatric residential treatment facility in the District of Columbia. We don't have one. We got to have a conversation about building and supporting residential treatment facilities in the district. There are other states that have them that we pay our taxpayer dollars to that state to take care of our kids because we don't have the facilities here. There have been conversations in our community about doing that. We have places in our city where we can do that. It requires a commitment of resources. I hope we're going to have that conversation.
Yes.
In fact, it's starting to work its way through some of the subcommittees at CJCC about how we deal with the absence of a treatment facility and psychiatric residential treatment facility in DC. As the city's chief law officer, I don't know that I would say, given the practical constraints we have, given that we're not a state, that we don't have the space that a state of Maryland or Virginia has to put kids in our own facilities, that putting a stake in the ground as a certain date that all things have to happen is necessarily the most practical, although I aspirationally wish that we could do that. So I'm thinking out loud a little bit about what I would be asking my team and others to wrestle with about whether it's practical to have a deadline by which it's sort of a drop dead.
Got it. Well, thank you. It's been a long night. I just would end by saying I am receptive to the intentions and the goals of the legislation. I will be working with the chairman and his team as this moves towards a markup. But there is a stark difference in what we heard from advocates, the academics, your office, and what we heard from the executive. And I'm just left with, if we are going to get serious about this as a city, we need to be on the same page, rowing in the same direction. And in the absence of that, we need to at least put stakes in the ground of what our expectations are. So I appreciate you pushing this conversation. And I think it's going to be a net positive for young people in the district overall. Thank you.
I like that enthusiasm. Let me just note that the bill does, in a way, get at the timeline for overcoming these juveniles languishing, because requiring a rehabilitation plan. The rehabilitation plan presumably is not going to say, well, for the first 6 months, we're going to provide no services. And instead, it's going to say, we're going to start providing the following services and in the following setting. That'll be the plan. And then if the juvenile languishes, then there's the ability for the attorney for the juvenile to go into court and say, hey, we're not getting the services that the plan provided. So that is a way of getting at the concern you raised, which is that these juveniles are languishing too long. That was not said to prolong this. We are at the end of the hearing. Mr. Schwab, thank you for your patience since you sat through 2.5 hours of the executive testimony. And I think you thought we were going to get to you sooner. And thank you for your testimony. Thank you as well for bringing this legislation before us. As I said at the beginning of this hearing, which was roughly 7 hours ago, the record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on October 9th. The time is 9:49 p.m. and this hearing is adjourned.